Ready to go? I call this regularly scheduled November meeting of the Tennessee Real Estate Commission to order. First on our agenda is the roll call by our Executive Director, Ms. Eve Maxwell.
The meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as part of this year's meeting calendar since September the 7th of 2012. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Wednesday, October 31st, 2013. Also, this meeting has been noticed on the 10Gov website since Friday, November 1st, 2013. Now I'll call roll. Alexander?
Here.
Collins?
Here.
DeChara? Here. Flitcroft? Grease?
Here.
Haynes?
Here.
McMullen?
Here.
Stevenson?
Here.
Bloom?
Here.
No. We don't. Commissioner Grease just looked at me, said, "Don't we do this alphabetically?" I said, "No, there's no rhyme or reason to anything this Real Estate Commission does, John. You're going to learn that along with Gary, our new commissioner." But anyway, let the record show we have 8 in attendance with 1 absent, being Mr. David Flitcroft. At this time, I would like to call on Commissioner Austin McMullen if he would lead us in our invocation this month.
Thank you. Will you pray with me? Eternal God, we come before you and want to express our thanks for the many blessings that you give us. We pray that we would ever be mindful of those and the source of those blessings. We're thankful for the lives that you've given us. We pray that we would make the most of those every day. We also pray that you would guide the deliberations of this body, that they would be pleasing in your sight. In your holy name we pray. Amen.
Amen. Now to adopt the agenda, but I would like to go ahead and add one thing that our executive director has already informed me. On the second page at 2:45, our agenda says that we're having an informal appearance, request for waiver of 50-mile rule. That individual will not be here, so we're going to delete that from our agenda. Does anybody have anything else they'd like to add or know of any deletions that we need to take care of at this time?
What's Kelly saying?
Yeah, we just, that's what we did, Kelly. That's okay.
Good. I'd like to just have a quick follow-up on our advertising discussion. Just, it won't take 5 minutes, I don't think. But could we plug that in at, say, 2:45?
Yeah, we'll add in place of our informal appearance waiver of the 50-mile rule, we'll just add Commissioner Grease has an update he'd like to bring before us about advertising. So we'll add that at 2:45, advertising by Commissioner Grease. Anything else?
Motion to approve agenda as amended.
Second.
Have a motion by Commissioner DeShara to approve our agenda as amended and seconded by Commissioner McMullen. Any discussion? Hearing none. All in favor say aye. Aye. Opposed, no. Motion carries. Now, our minutes. Does anybody have any additions or corrections to our minutes?
I'll make a motion we approve September's minutes.
I'll second that.
Have a motion by Commissioner Grease to approve September's minutes and seconded by Commissioner DeShara. Any discussion? All in favor say aye. Aye. Opposed, no. The minutes are approved.
For September.
I'll
September.
I'd like to move we approve October's minutes.
And I'll second.
Also have a motion by Commissioner Grease to approve October minutes and seconded by Commissioner DeShara. Any discussion on this motion? All in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman,
Commissioner McMullen.
I abstain from the vote on the October minutes.
Let the record show that Commissioner McMullen, because of his absence, has abstained from the October minutes.
And Mr. Chairman, likewise, I abstain from September's vote.
Mr. Bloom he did not vote on abstain from the September minutes. Next on our agenda is the public rulemaking hearing.
We can't begin it until 9:30 just because we have people that may be attending to make public comments and they're limited to signing in. So if there's something we can do either off the administrative report, or I don't know if we can do the education report before 9:30, that would be great. I just want to be sure that anybody that wants to come and make a comment has, we haven't started too early where they're not allowed to do that.
Okay, so it's 9:08 now. We've got 22 minutes.
Stephen, do education.
So we're going to have our education report by our education director, Mr. Steve McDonald.
Morning, Commissioners. Thank you, Chairman Stevenson. Before you, there are 16 courses submitted for November that I've brought the backup material. These are ones that were no questions and comply with the rule. There is one that we'll speak to after there are any questions through N1 through N16.
I have any questions?
Hey, Steve, can we talk for a minute about N14?
Yes, sir.
Who's the audience for this course? Is it for law students or attorneys, or is it for real estate agents?
It's for the real estate licensee.
Assume that they'll get involved in mediation at some point?
Talking about N14?
Yes.
Are you talking about N15 from Vanderbilt Law School?
I apologize.
Okay.
15. I'm sorry. That's correct.
Kelly Murray has had courses approved. Her very first course was Divorce This House, which she put together for CLE, for those that were attorneys and for those that are in the real estate business. This course gets licensees to understand the consumer protection rule, how to facilitate the documents. Refresh myself with this. It does not give them a Rule 31 license. It just familiarizes the licensee with the process of divorce and elder real estate law taught or given by faculty at Vanderbilt, a lawyer herself.
Just by reading the outline or your capsule right here, I got the sense that an agent after taking this course might feel like they can practice law in some form or fashion, if it's facilitating documents and those kind of things.
Pull the course application. Ms. Murray states that this is a skills-based supplement for real estate licensees on intra-family civil matters concerning documents, information, and consultations needed for informed decision-making regarding real estate valuation and disposition. The course will clarify the consumer protection role of real estate licensees pre-transaction to help facilitate documents and other information gathering that foster informed decision-making by homeowners in divorce and elder matters regarding real estate-related issues, whether those issues be house valuation or disposition, whether through voluntary alternative conflict resolution, such as mediation or litigation. It's what I can surmise is that she's not promoting the practice of law. It's giving the licensee the ability to help those involved in these types of scenarios understand them before it may get before a legal matter.
Commissioner Grease?
Yes.
I've been to her course. It's quite good.
Have you taken this course?
Yes. What she really does is tries to show, like, for example, if there were a divorce and the judge said, and I'm decreeing that the missus gets the property, but there's a mortgage on the property that still has to be paid, and the Mr. is still identified as part of the responsibility to pay that mortgage. So what I saw in the course that I took from her was quite good in terms of real estate practice. It had nothing to do with the
It's basically for-
practice of law.
It's for information, not necessarily.
The one that I went to that she taught.
Okay. Thank you both.
I had a question on the number of hours for N3 and N16.
Okay, Commissioner Collins? Sir, we'll start with N3 if that's okay with you.
Okay?
All right. Course outline has this as a reback course. It is an ABR elective credit. So the outline was put together to begin with by NAR, and that was the hours that they requested to satisfy that ABR elective. So I can go through, it's quite extensive outline. It's 6 pages.
One-day course?
It is a one-day course. Yes, sir, it is.
I think it's 8-hour credit worthy.
There's 6 pages of information, and I know the reback program is pretty intense.
Okay.
And for it to be an ABR elective course,
What about N16?
okay? Yes, sir. This one again is another ABR elective. It's a reback course. It's the same as GNAR's course that we just referenced.
Read it from different associations.
Okay. Thank you.
Sir.
I have a quick question, because I was asked this recently. Planning, zoning, codes, they all have to have, if you're on those kinds of boards, there's mandatory education by the state. The person that is giving some of the education asked me, how does he get approved for, because a lot of the folks that are on planning and zoning, or several of the folks, and as they should be, are involved in the real estate industry, and they would like to get credit for their planning and zoning as well as their real estate planning. Just contact you, and can you walk him through that?
Absolutely.
And that would be true of any, I mean, this would be good information for anybody that, because that would apply to real estate very well.
Correct. In Rule 126503, 5A 11 speaks to land use planning and zoning. So we do have that as a topic within
I
the real estate
thought we
forum.
did,
Yes, ma'am.
so, okay, good, because I've had several people that are on planning and zoning commissions call me and say, why can't I have real estate education? Talk to
Need to
Steve.
contact me.
Talk to Steve. I'll do it.
Yes, ma'am.
I'll have him do it. I'll give you his name later.
I make a motion, we approve the courses presented.
Whoa.
1 through 16.
16, okay.
Have a motion by Commissioner DeShara and seconded by Commissioner Collins that we approve courses 1 through 16 that have been presented this month by Steve McDonald. Any discussion on any of these courses other than what we've already heard? All in favor say aye.
Aye.
Opposed, no. Motion carries. That,
Hey, Chairman Stevenson. N17, we're picking up the discussion that we had last month's commission meeting in Farragut, Tennessee, where Mr. Pitts came before you and spoke about the topic of reverse mortgages and having the commission actually approve those courses in the future. He has since sent in his application. I have put it on the education report as a course requiring discussion. Commissioner Haynes has also supplied, which I passed out to you, some additional information on reverse mortgages. So if we could have this opportunity to discuss this portion of the education report and the future of reverse mortgage courses being approved by the commission.
Chairman, for purposes of discussion, I'll move this course be approved.
I'll second.
have a Motion by Commissioner Grease and seconded by Commissioner DeShara that this course, number N17, be approved. Discussion on the motion.
Mr. Chairman,
Commissioner Alexander.
the position of the Tennessee Real Estate Commission is to protect the public. If you read, and I got into this last month some, if it's so good, why would Wells Fargo, Bank of America, and MetLife exit the program because they're having so many losses? If you read this, it's going to be one of the worst things that's happened. It'll be nearly as bad as the inflated mortgages and the thing we got in before. And I certainly hope that this commission goes on record of not approving this course.
FHA has $2.8 billion in projected losses on reverse mortgages over the next 30 years. I mean, I just don't completely understand why anybody would even get a reverse mortgage. And I'm sorry I didn't have more information last month to talk to. Over 1 out of 10 will fail, for sure, according to the government statistics. I'm just real hesitant approving a course that, because it puts our stamp on it, like we have approved that this is a good thing. And I know several seniors, and I'm in that category, I'm 62, that might look at our approval and say, well, you know, it was approved by the Tennessee Real Estate Commission, so it must be all right. I mean, whether it's information or not, I just feel like we have to protect the public, and I just don't feel like this course is protecting the public.
Any other comments?
I'll speak in favor of the motion, Mr. Chairman. Reverse mortgages are legal, they're advertised, they're occurring on a daily basis. I don't think it's the role of this real estate commission to sense that we have to ratify a program before we approve the education of that specific loan. So until the loan possibility of a reverse mortgage goes away, I think it's important for our licensees to be able to educate the public, not just act like it doesn't exist when in fact it's a big, well advertised program these days.
And I'm going to speak to that too. And he gave us his training, and I don't know how this compares to other training, but I didn't get much information from it. I had to go to the internet and get much more information. And I'm sure, I know this is just an outline. I understand that. But did you understand the training? You're a trainer.
Well, yes, because I know that what I send when I do my outlines for Steve may be 16 or 20 pages long, and it's a 4-hour course. And, of course,
This was
Gary's a past instructor, too, and our outlines certainly don't cover everything we cover in the classroom.
his was 1-page summary.
Well, that's his summary, and typically my summary's only going to be 1 page unless it's an 8-hour course. But I agree with Commissioner Grease. I think our job is to educate the agents, not to put our stamp on reverse mortgages. But I think if a consumer who is 70 years old calls us and says, I'm thinking about getting a reverse mortgage, what do you think? And then to be able to share some statistics with them and show them what happens, I think is much more valuable than just going, oh, well, I don't like them, you don't need to do that. And they go, but why?
Well, the way I understand this, the government requires them to have a counselor and go to a counselor that is trained. So if somebody wanted to take the training to be a counselor for reverse mortgage, because before they get that mortgage, the way this reads and what I've seen in a couple of, they have to be counseled. They have to know what they're doing because there's so many failures. So are you saying that we should approve education to be a counselor?
No.
I mean, they can get that information from a counselor. They have to before they get it.
Well,
It's part of the law.
My father did a reverse mortgage. And I wish at that time I would have had more information about it myself to be able to share with him. But I went with him to the counseling. It lasted about 30 minutes.
The counseling, right.
So you don't get a lot of information.
But what I'm saying, if an agent wants, that's where they should really get it. Even though it was about 30 minutes.
Yeah, if I took this course and found out that I had to go to a counselor, I've learned something in the course, because I didn't know that before you just said it. And that's what I think the benefit of the course would be.
Well, but you could find all that on the internet. I mean, it's not that
I
hard
know
to.
some 60 and 70-year-old people.
But you as an
And people
agent.
still have flip phones that don't
Yeah.
know how to use the internet.
Well, I know a few of those too.
Don't.
I do know a few of those also.
My take on it is, if somebody calls us and wants to know if we should have heart surgery or not, maybe we should have training on counseling people for heart surgery. You know, we're involved in buying and selling of real estate. What kind of loan they get on it has nothing to do directly with what we're supposed to be supervising people over. And I think we're sticking our neck out for something we don't. Where do you end? In what area do you stop providing training to realtors?
Well, I asked a question about mediation a little bit ago. I mean, should we be involved in that? Yeah, we
That's
approved
about the same
course.
question I'm saying.
Well,
Heart surgery?
We approved the course. I mean, I don't agree with most. I haven't seen the outlines on any of these courses.
Well, part of the mediation was taught by a lawyer and a university, and I think the requirements there were a little stricter than possibly this man from Alabama that has started a nonprofit to teach these courses, in my opinion.
And for the record, I'm just using that course as an example.
Yeah, I understand, but that's the reason I approved that course, was because of who was teaching and where it was being taught.
Well, we run into a lot of situations where people want to sell their property, where they got in a divorce, and we have to deal with it, and that's important. But whether or not something out of our scope they're wanting to get approval on, I don't see how it impacts us at all as protectors of the public.
Mr. Chairman,
Mr. Alexander.
call for a roll call and call for the question.
Call the roll.
This is a vote whether the motion was to approve the course as presented, course number N17. So that's the motion, whether to approve course N17.
Commissioner, Ms. Maxwell, I know we have called for a question by Commissioner Alexander. Commissioner Alexander, could I ask a favor of you? Could I ask that, I'd like to hear from Commissioner Bloom on this topic.
I didn't know you wanted to speak, but I would.
Okay.
And then I've got a comment or two to make.
Okay. I think the course, we probably know more about this course than any of the others that we approved, for one thing. I don't particularly like reverse mortgages. I don't, at my age, particularly like debt. But I don't think it has anything to do with what's before us now, and that's whether or not this course ought to be approved so that we can inform people in the industry and members of the general public about what this item is about. And after the presentation of that material, I'm not sure I'd feel any differently about it, but I think they have the right to have that material presented to them. So I would speak for the motion.
I would like to say, I've listened to this discussion last month and this morning. Personally, I am totally opposed to reverse mortgages. I've seen, like I told you all, about a situation in Oak Ridge where this lady had taken out a loan, and I mean, all these future losses are coming down the pike in these type of mortgages. That, coupled on the other side of my thinking, sort of goes along with what Commissioner Bloom just said as far as informing people about these type of mortgages. I don't know that it hurts having knowledge and being able to create knowledge of these type of loans to not only our licensees but also to the public. I'm about 49% against and 51% for this motion. That's about where I am right now. Anybody have anything else? Commissioner Alexander.
Chairman, I'm gonna try to convince you to get 2% more out of you.
Yeah, please.
Just get one and he'll pass.
No, you'll take 2 out of him. You know, you talk about informing the public, but I look out and I think about myself when I was about 3 years into this market, when I had a big debt, like Commissioner Bloom said he was against debt. And I've seen the time I'd have promoted to sell a reverse mortgage, because I needed a commission. And that's what you're gonna do. You're not talking to the people that's gonna get the reverse mortgage. You're gonna talk to the agents that's gonna sell them. I'm gonna get them. And it's, I feel it.
Oh, yeah, I think it's a great concept for agents that can't sell something else. I mean, go out there and my age group, I could talk to all kinds of folks my age and say, hey, you've got $400,000 house. Let's see. You can take that and get a $200,000 mortgage on it that you don't ever have to pay a dime on, that has compounded interest is the way they pay out of the remainder of the value of the house. Now tell me if I'm wrong. And then I get a commission as an agent because I convinced my friend, and then the mortgage company gets their commissions out of it. And I'm not sure who else. There was several other fees that were involved in it. And as an agent, man, that's a great way to make commissions. I mean, I for that point of view, I think it's a wonderful idea. But I don't know that we're here to protect the public. We're different from anybody else and anybody else in the industry. We're here to protect the public.
Mr. Chairman,
Yes, Commissioner McMullen.
I'd like to ask a question. I did not have the benefit of the discussion last month. I've looked through the materials that I've seen here, and my question is, does this class address the risks of a reverse mortgage? I see a lot of information in here about the benefits of it, but I think if we're going to be educating people in order to counsel people about this option, I would like to see that the risks of this type of transaction are also addressed, and I just wanted to know if that was something that was addressed last week, or maybe if I'm missing that in the materials somewhere.
Steve, do you know the answer to that question?
Risks are not addressed.
9:30, we need to have a vote.
Let me ask one question, Steve. If this commission said we'll approve the course, but with the condition that risks are included in the course content, is that an appropriate motion or an amendment to the motion?
To reapply.
He has to reapply?
That's a significant amount of material.
Everybody I'm gonna call for the question
But-
one more time.
Okay, I think we're ready now. Call the roll, Ms. Maxwell.
This is, the motion was to approve course number N17. Haynes,
Against?
Alexander,
Against?
McMullen,
No.
Bloom,
No.
Collins,
No.
Grease,
Yes.
Chara,
Yes.
Stevenson.
No.
So there, 2 against and 6 in favor. So, I mean,
the other way around.
Backwards.
2 for and 6 against, the motion fails. Had it marked right.
Okay, Steve.
Thank you.
Based on our vote and action, you proceed with this topic. What else do you have?
Just instructor reviews. There's just 2 in.
We can go ahead.
Yeah, I mean, if we start a couple minutes late, that's better than not giving people enough time to get here.
Okay.
To speak.
Especially
So
with
that'll
traffic
be
today.
brief, so.
Okay, Steve.
Mr. Chairman,
Commissioner Bloom.
I wonder if Commissioner Grease has a motion in regard to the reverse mortgage.
I don't have a motion, but can you, is it appropriate for you to instruct the creator of that course that if it was expanded to include risks that we'd reconsider?
Absolutely, I will have that discussion and make sure that you have ample time to review that.
Thank you.
Thank you.
Don't lead him to believe that it still might pass.
Correct. Okay, instructor reviews. There are two providers before you. Number one, Sally Cummings of TAR, Tennessee Association of Realtors, provider 1110, requested approval of the following. Bobby Wood to teach GRI 404. That's approved course 6761. Steve Champion to teach GRI 402. That's course number 6759. Juanita McDowell to teach GRI 406, course number 6763. Sue Turner to teach GRI 403, course number 6760. All of these instructors are previously approved with TAR and qualified to teach these courses based on the material previously sent for them. Number two, Candy Joyce of the Middle Tennessee Association of Realtors, that's provider 1141, requests the approval of the following. Bobby Wood to teach fair housing for today's real estate, that's course 3415, and Laura Pratt Umbarger to teach successfully selling HUD homes, course number 6633. And again, all of these instructors are previously approved and qualified to teach these courses based on the
Motion to approve.
Second.
Have a motion by Commissioner Collins and seconded by Commissioner McMullen that we approve these instructors. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Instructors are approved. Is that the end of your report?
Yes, sir. Thank you. Thank you,
Steve.
Commissioners.
Thank you. At this time, do I turn it over to you?
If that's all right, and we can begin.
Okay, go ahead. You're in
All
charge.
right. This rulemaking hearing is called to order. My name is Julie Kropp. I serve as staff attorney for the Department of Commerce and Insurance and serve as attorney for the Tennessee Real Estate Commission. Would the agency representatives who are present introduce themselves for the record, please? That would be y'all.
Wendell Alexander.
John Grace.
Austin McMullen.
Michelle Haynes.
Gary Bloom.
Janet DeChara.
Grover Collins.
Mayor Stevenson.
Thank you. It is Wednesday, November 6th, 2013. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated, Section 45204, in Conference Room 1A of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on proposed rules of the Tennessee Real Estate Commission, proposed rules the Tennessee Real Estate Commission has made public due to the recent passage of legislation regarding these topics. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. These rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the back of the room. Only those who have signed will be permitted to speak. The notice of rulemaking hearing included in the entire text of the proposed rules and was filed with the Secretary of State and published on its Administrative Register website on August 8, 2013. Ms. Maxwell, what additional notice was given to the affected individuals or groups?
There was a notice placed on the Tennessee Real Estate Commission website with a link to the proposed rules. There was notice given to all local Realtor associations and the Tennessee Association of Realtors. There was notice on the notify.gov site, which can be reached through the Tennessee Gov site. And there were notices given at all the Tennessee Real Estate Commission seminars throughout the state.
Thank you. As the agency hears public comments on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will read the substance of the proposed rules into the record. There are two proposed rules, which are both new rules. The first proposed new rule, number 1260-01-.16, entitled Lapsed Errors and Omissions Insurance, is somewhat lengthy, so I will not read it word for word. This proposed rule specifies certain provisions of Tennessee Code Annotated Section 6213-112 as amended by Public Chapter Number 84, which allow the Commission discretion regarding penalty fees for reinstatement of a license which was statutorily suspended for failure to maintain errors and omissions insurance, or E&O insurance, as well as regarding conditions for reissuance of a license which was statutorily revoked for failure to maintain E&O insurance. This rule specifies the penalty fees for reinstatement, as well as the conditions for reissuance of a revoked license. In addition, this rule specifies that failure of a principal broker to ensure that all licensees affiliated with that principal broker hold E&O insurance constitutes a failure to exercise adequate supervision and outlines the disciplinary actions applicable to a principal broker whose affiliated licensees failed to maintain E&O insurance. The second proposed new rule, number 1260-01-.17, entitled Fingerprinting, is also somewhat lengthy, so I will not read it word for word. The proposed rule expands upon Tennessee Code Annotated Section 6213-303, as amended by Public Chapter Number 420, which provides that all applicants for initial licensure on or after January 1st, 2014 shall submit a set of fingerprints for the purpose of obtaining a criminal background check. This rule specifies that all fingerprints submitted shall be submitted in an electronic format which is classifiable or able to be read, with said fingerprints to be taken by a company contracted by the state, which transmits the fingerprints to the TBI and FBI and submits an electronic report to the Commission. Finally, the rule defines initial applicants as including new applicants for a broker, affiliate broker, timeshare salesperson, or acquisition agent license, as well as any former licensee who must reapply for reissuance of his or her license, or the former holder of an affiliate broker's license who applies for licensure as a broker. At this time, I would like to make the notice of rulemaking hearing, which contains the entire text of both proposed rules, and exhibit to the record. At this time, we're going to take the comments for the attendees that have signed in on our sign-in sheet that are here present today. We also have 2 written comments that were submitted to us. We'll take those immediately following those that are present. I'll take these in order of the people that are signed in, and if you'll just come up to the podium and introduce yourself, please, and then address the commission with your comment. After they have given their comments to you all, what you're responsible for doing is stating the reason for adoption or rejection of whatever requested change they are asking for in their comment. We can go back over that later if necessary. The first person signed up to speak is Johnny Griggs. Oh, you thought it was the sign-in sheet. Okay, we'll pass over that one. The second one is, I can't read the, Tammy Sova. Same thing? Okay. Third one is Jim Gibbs.
Good morning. Morning. Chairman, Commissioners, Chair Bear. Those that are familiar with me, I'm really going to bring just back an old haunt. I've read over the regulations, the new laws that are joining them. I'm not particularly offended by the new rules herself, but I'm a little concerned for those who were on the commission in 2009. I repeatedly come before the commission and criticize the commission for not following the law and governor's executive order regarding the Regulatory Flexibility Act. And I've perhaps Ms. Maxwell or Ms. Kropp can direct me if it has been, but I don't see any evidence that the proper analysis has been done on the rulemaking process prior to it reaching this body. And I believe that the law is very explicit in it. I believe the executive order from the governor, it was actually signed by Governor Bredesen. It's still in effect with Governor Haslam. I would encourage you all to look at the Regulatory Flexibility Act, try to understand it as it involves this commission, and assure that those things are done. Fortunately, since Governor Haslam has been in office, one of the first things he did was put a moratorium on rulemaking, so rulemaking hasn't been a real big business since he came into office, but it looks like it's time to refresh our memories. There are some laws governing the rulemaking process, and I believe we need to follow them, and that would be about the only thing I have to offer today, and I thank you for hearing me.
Ms. Crop, can you speak to that, please?
Well, we all, as you all recall, in the July 2013 meeting, before these rules were sent up to be filed with the Secretary of State's office, you completed part of the regulatory flexibility analysis, which is supposed to be completed prior to rulemaking hearing. It was a list of, I believe, 6 considerations. It was on the record. You all discussed each one in turn and passed by motion responses to each of those. You also went through a number of other considerations by the government's office that are handed down by the government's office, and considered each of those and adopted responses by motion at that time too. We'll complete the second part of this regulatory flexibility analysis. The part is to be done at the rulemaking hearing, which is specifically called the economic impact statement, today after we have discussed any possible changes to the rules before moving forward.
Approach the podium.
I am not an attorney, but my understanding is that this is all supposed to be done prior to this hearing, and it is in fact, the governor's executive order even goes so far as to say that notification to the public, each agency shall take reasonable steps to give notice to the public and small businesses of the analysis of the economic impact in the proposed rule. And if I'll be willing to stand corrected, but I do not believe that it is an after the fact issue. I believe it is prior to it reaching this board. I do recall when it came out, or when I brought it up in 2009, Ms. Wiseman was the attorney for the real estate commission at that time. She read the law to you in the executive order, and then one of the board members did an analysis by motion, and I'm not sure that that's what legislative intent was. I believe it was intended to be analyzed, the impact it will have on small businesses, and not only the impact it will have on small businesses, but the impact that the rules will have on the commission itself, on the staff. Can they deal with what you're creating? And again, I'm not complaining about the proposed rules. I'm just suggesting that we need to really revisit the Regulatory Flexibility Act and get it straight, get it right.
Ms. Crop, wasn't that what we did in July?
Pursuant to Tennessee Code Annotated Section 45402, which is an analysis of the impact on small businesses, it states, prior to initiating the rulemaking process, as described in 45202A3 and 45203A, all agencies shall conduct a review of whether a proposed rule or rules affect small businesses. That then says that each agency shall, after June 21st, 2007, employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small businesses. The agency shall consider, but not be limited to, each of the following methods of reducing the impact of the proposed rule on small businesses while remaining consistent with the health, safety, and well-being. The following 7 considerations that you all each addressed at your July 2013 meeting prior to filing this with the, this notice of rulemaking hearing with the Secretary of State's office on August 8th, 2013. The following subsection 4.5 to 403 says preparation of an economic impact statement. As part of the rulemaking process for any proposed rule that may have an impact on small businesses, each agency shall prepare an economic impact statement as an addendum for each rule that is deemed to affect small businesses, which shall be published in the Tennessee Administrative Register, filed with the Secretary of State, and made available to all interested parties, including the Secretary of State, Attorney General, reporter, and the Government Operations Committees of the Senate and House of Representatives, and as described for rules in Part 2 of this chapter. This statement shall include the following, and then there are 6 considerations which we are addressing today. That again states, as part of the rulemaking process. Prior to the rulemaking process were the ones that we considered back in July.
So what we did in July, you sent up to the Secretary of State, is that correct?
No, that was not sent up to the Secretary of State. The economic impact statement, what we're doing today, has to be sent up with the to the Secretary of State's office, and that is published with the rulemaking hearing rules up at the Secretary of State's office in their administrative register for 90 days before coming effective. The initial part of it just requires that you engage in an analysis on the following, and that you must consider each of the following. The publishing requirement is for the economic impact statement, the part that we will consider today.
Mr. Gibbs acknowledged he's not an attorney. Mr. Gibbs, thank you. Neither am I. Ms. Crop is. Do you think we're on safe ground as we go forward today?
This has been the way that we did it in our last 2 rounds of rulemaking hearings last year. Like Mr. Gibbs wasn't here then. It's my understanding from supervisors within the legal department, as well as my own reading of these statutes, that we're addressing the appropriate concerns at the appropriate times.
Ms. Crop,
Commissioner
did you
McMullen?
say there was some action that we were required to take after each comment?
After each comment, you should state the reason for adoption or rejection of the specific changes. Here, these aren't specific changes to your rules, but I guess just some kind of statement to Mr. Gibbs's comment, since he has come here and taken the time to address you all.
Mr. Chairman, if I could speak to that. Mr. Gibbs, I think I understand the concerns that you're stating, and I think I understand what you're talking about there, and I recognize that and think that those are good comments, but I think in this situation it appears that we have fulfilled those requirements prior to the rulemaking hearing that's going on today, as Ms. Crop has explained, and so I think we are on good ground, as Commissioner Grease said, going forward, having complied with that particular executive order.
Well, I appreciate that. I would also just like to throw out for Ms. Crop to make a note of and have her research it, because while the wording of it is very similar, there's some slight differences to it, but there is an executive order number 38 that you really need to look at too. And I do believe, and I respect what you're saying, but I do believe that by not doing the analysis, a true analysis of the impact of these rules, at this point, I believe is not within the legislative intent or the intent of the executive order when it was made. Because I think at this point, it's too late for all intent and purposes.
What do you consider a true analysis? Maybe that's where we differ.
I'm sorry?
What do you consider a true analysis?
What would I consider an analysis?
A true analysis, as you just stated?
Well, you know, an analysis, to be definitive, is a process of breaking down a complex topic and the substance into smaller parts to gain a better understanding of it. But for example, here from the executive order, it says the economic impact statement. In conducting this interview, each agency shall prepare an economic impact statement that sets forth the following: the type and types of businesses that will be directly affected by, bear the cost of, or directly benefit from the proposed rule. And in this particular case, you have 2 on both sides of the errors and omissions insurance rule. One, you have the small businesses, the individual brokers, the individual affiliate brokers that are going to be fined if they don't comply with getting their errors and omissions insurance. I'm not sure I really have a problem with that. A lot of states don't have errors and omissions insurance required by the Real Estate Commission. So it's not across the board, across the United States. What we do create when we have a required errors and omissions insurance rule, as we do in the state of Tennessee, we create a approximately, just doing the math off my head, 25,000 agents at the minimum of $6 million every year in insurance premiums going to a specific state-appointed, for the most part, and that's on the slide because that's saying $200.
They bid on that, and we are one of 13 states.
Pardon?
That has to be put out for bid, and we are one of 13 states.
I understand that, but
I understand
but
totally
still,
what you're
this
saying.
coming again from
But I don't see
the
that it
executive
makes sense.
order, those things need to be considered in this analysis. You asked me what an analysis was. It also says a description of how small businesses will be adversely impacted, whether or not, to what extent alternative means exist for accomplishing the objectives of the proposed rule that might be less burdensome on the small business, and why such alternatives are not being proposed. The reason for the Regulatory Flexibility Act in its executive order to begin with was to try to protect small businesses. Rice Insurance is not a small business. Association of Realtors is not a small business. Individual brokers and brokerages are small businesses, and that's what we need to be protective of. I realize your agenda is to protect the public, but you also need to be, according to these Regulatory Flexibility Acts, attentive to the welfare of the small business in the state of Tennessee also.
Ms. Crop?
Thank you, that was well stated.
Ms. Crop, is the E&O insurance required by statute?
It's statute. That is not something that's being promulgated according to these rules. The
So-
economic
so
impact
it would not
statement is
be-
something that the type or types of small business is an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. This rule is not the rule that requires errors and omissions insurance.
But
This
the
isn't even the one that outlines the penalty fee ranges. We're merely going within a statute that was promulgated by the legislature to clarify some discretionary ranges.
So the decision of the economic impact of requiring E&O insurance was a decision that was made by the legislature up the hill. It was not a decision that we're
That's not
making.
something this rule is creating. It's
Mr. Gibbs, I'd just like to say one thing. I just want to say thank you for coming and bringing things like this to our attention, but we have to rely upon Ms. Crop and our other attorneys within this department to keep us informed as to what we're doing and what we're doing right and what we're doing wrong. And it's my understanding, Ms. Crop has stated, that we've done everything that we're supposed to do to comply with the statutes that are in place. But I appreciate you coming and taking your time to address us. It's always good to see you, Mr.
Thank you. I
Mr.
appreciate
Gibbs.
that, and I understand your position. Thank you very much.
Okay, thank you, sir.
the next person that we have is Paul Gagliano. Sign in. Okay. Maybe we don't have as many as I thought. The last one on here is Richard Lewis. Sign in. Okay. Now we just have two written comments that I need to read into the record fully. Likewise, these comments deal with the substance of the rules. So when I finish with reading each written comment, I'll read the first one, and then I'll need for you all to respond as to whether or not you know, why you want to or do not want to move forward with the proposed changes. The first written comment I received by email from an individual named Ken Barnes, and it says it was directed to Mr. McDonald, our education director, but copied me, and I told him I would treat this as a comment, and he expressed appreciation for that because he could not be here today. His comment states, Steve, thank you for the email pertaining to the subject hearing. After reviewing the proposed rule changes on E&O insurance, I noticed that the Commission does not have the disciplinary authority to revoke or suspend a principal broker's license under Section C4, subsection 2, as proposed. Specifically, Tennessee Code Annotated Section 6213-310, subsection C, states that any unlawful act or violation of any of the provisions of this Chapter 13 by an affiliate broker may not be the cause for the suspension or revocation of the license of the broker with whom the affiliate is affiliated. Again, thank you for the notice, and I will be following it closely. Sincerely, Ken Barnes with the Professional School of Real Estate. This is a comment dated August 16th, 2013. What he is addressing is the subsection found within the first rule, the lapsed errors and omissions insurance rule. It's subsection C, which is on this page. It's labeled as page 3 of the rulemaking notice of rulemaking hearing. C, number 4, subsection 2, where it says nothing in this rule shall be construed as limiting the Commission's authority to seek any other legal discipline, including revocation or suspension of a license for a failure to supervise an affiliated licensee's E&O insurance. That is the provision that he is addressing within his comment. It is on what is labeled as page 3 of the notice of rulemaking hearing. Within the folder on your iPads, it's page 5 of 18, I believe.
On page 3.
It's labeled as page 3 at the bottom.
Right.
And
then where on page 3?
somewhat toward the center, there's a number 4. It's a little bit below the center. It says nothing in this rule shall be construed. Do you see that?
Yes, thank you.
It's the subsection 2 that
Okay.
he's speaking of.
Oh, was it your interpretation he favored that or did not favor that?
He doesn't. He doesn't believe that the commission has the authority to have that provision for, allowing for possible suspension or revocation for failure to supervise E&O, an affiliate's E&O insurance, because he states specifically with regard to one of the statutes contained in the Brokers Act, 6213-310C, it says, any unlawful act or violation of this chapter by any affiliate broker may not be the cause for the suspension or revocation of the license of the broker with whom the affiliate broker is affiliated. That's his concern of that section of the proposed rules based on that statute.
Ms. Crop, does the rule actually provide for the suspension of the principal broker?
No, it just allows for the possibility, I guess, in the event that there were certain circumstances that arose to where that was the action the commission wanted to take. But you will note that it says that the revocation or suspension of a license would be due to failure to supervise. That is on the part of the principal broker. That's not for the affiliate's actions. There's actually a separate, under 6213-312B, 15 is a violation for a principal broker for, in the case of a licensee failing to exercise adequate supervision of the activities of any licensed affiliate brokers within the scope of this chapter. That would be the grounds there.
So the statute allows a principal broker's license to be suspended if they fail to supervise an affiliate broker?
Actually, yes, B says the commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee, in performing or attempting to perform any of the acts mentioned herein, is found guilty of. It lists a number of items, but number 15 is the one I just read to you, saying in regard to a licensee failing to exercise adequate supervision.
So is the section C42 of the proposed rule consistent with the statute that you just quoted?
In my opinion, it's consistent with the grounds for disciplining a principal broker for failure to supervise. Our rule actually specifically states any action shall be taken against a principal broker for the activity of failing to supervise, which I believe is distinct from the underlying actions of the affiliate broker. However, that's up for you all to determine.
Mr. Chairman?
Boom.
I have a hard time making that work for me. That seems to be a conflict. What he
Be
sta-
be specific. Where are you, Commissioner
Well,
Bloom?
in the one we're addressing, it says not seek discipline against the principal broker for failure to supervise an affiliate broker's maintenance of E&O insurance. That's very specific. Says he cannot be.
For the record, exactly where are you reading from? Identify.
On page 3 of what Ms. Crop identified, it's for, yeah, 6213-203 for IV, is it not? Am I not right?
6213, I'm sorry. You're saying 6213, 312B?
I'm actually looking at,
Number 4 under 4, is that where
right,
you are,
right,
Barry?
right. Yeah, what he referenced, what this gentleman referenced.
Oh, the proposed rule.
Right.
Okay. And I'm sorry, I didn't understand your question.
Well, it says that we should not seek, or you cannot seek discipline against the principal broker for failure to supervise an affiliate broker's maintenance of E&O insurance. And then the other reference that we were saying says that you cannot discipline a broker for affiliate broker's actions.
Right, but what I was stating is this would be suspending or revoking a license for failure to supervise, which is actually an action on the part of the broker. Again, it's up to you all's determination, but like I said, I looked at the two statutes and.
Possibly, part of the confusion is Mr. Barnes referenced C4-2, Gary, and I think you're looking at C4-4.
I am?
I think that the proposed rule just leaves options open to the commission to either discipline a principal broker if they fail to supervise, or to not discipline a principal broker if they determine that discipline is not appropriate.
If y'all, and this may help a little bit, on page 2, the previous page of the rulemaking hearing notice, toward the bottom where it says 2A, it begins with, a principal broker shall ensure at all times that all licensees affiliated with that principal broker shall hold E&O insurance as required by law. A failure to do so shall constitute failing to exercise adequate supervision over the activities of a licensed affiliate broker. So that's pointing back to, here is the violation for the principal broker. And in my opinion, that falls under 6213 312B15, which is an action that you all are permitted by statute to suspend or revoke or otherwise penalize a principal broker for failing to supervise. Again, I'm just trying to give you all of the relevant statutes that appear to address this.
That clear to everybody? We do have the statute says that we have the authority.
So, Mr. Chairman, if, to address Mr. Barnes' concern, I'd like the record to note that we discussed it, and I make the motion that it appears to be an unjustified concern because statutorily we do have the right to suspend or revoke licenses for failure to supervise.
Anybody else have any other comments of the concerns that's been sent to Ms. Crop by Ken Barnes?
At the response, y'all want to, I think he made it in the form of a motion,
Yeah,
which I don't
that's
know that
what-
we did the last time,
Well, I don't
but,
have to. That's my sense, and perhaps it's the sense of the commission.
okay, do you all want to do that by motion?
I agree with what Commissioner Grease said.
I put that in form of motion.
I
Well, he did, and that's why I asked.
Okay.
And I will second Commissioner Grease's motion.
Thank you.
Motion has been made by Commissioner Grease that we, based upon the discussion that has been entered into the record, that we have addressed the concerns of Mr. Ken Barnes' comment, and we're on solid ground. It's seconded by Commissioner Alexander. Any discussion on this motion? Hearing none, all in favor say aye. Opposed, no. Motion carries.
Okay, there's one final written comment, and it's somewhat lengthy. It's got 3 issues in it that I see, and so I'll read it through, and then if we need to, we can go back to each issue one at a time. I think that it's in your iPads if you'd like to read along. It was sent by Russ Farrer from Farrer and Bates. It's page 15 of 18 of the materials within the book. It's dated October 10th, 2013. It states, Dear Ms. Crop, as General Counsel for Tennessee Association of Realtors, TAR, I have reviewed the proposed rules which you are set to be presented to a rulemaking hearing on November 6th, 2013. As you know, these rules provide a basis for the Commission to enforce the amendments to Tennessee Code Annotated Sections 6213-112 and 6213-303 as recently amended by the state legislature. After reviewing the proposed rules, TAR has several concerns. Proposed Rule 1260-01-.16 is the rule establishing the guidelines for enforcing the amendments to Tennessee Code Annotated Section 6213-112. As you recall, TAR initially brought this bill per the request of the Commission. However, we have one concern regarding Section 2 of the proposed rule. This section provides for the discipline of principal brokers in the event that they have licensees who failed to renew their E&O insurance based upon a theory of failure to supervise. Our concern is that the civil penalty assessed to the principal broker is greater to that imposed on the agent who allowed the lapse, pursuant to the recently revised civil penalty schedule included in Rule 1260-02-.32, effective March 3rd, 2013. For example, if a licensee failed to renew his insurance, his license is immediately suspended. If he provides insurance from day 30 to 120, he must pay a fee of $200 if he is able to backdate his policy to provide continuous coverage, and $400 if he is not able to backdate the policy. However, the principal broker would be presented with a consent order in which he would be subject to a civil penalty in the amount of $250 if the affiliate is able to backdate his policy, and a civil penalty in the amount of $500 if he is not. The same is true for those licensees who are suspended for months 6 through 10. This seems a bit harsh. Although we understand that a broker may be able to prevent any fines at all by releasing the agent, it seems inequitable that the true wrongdoer in this situation, the agent with the lapsed insurance, faces a smaller fine than does the broker. This is further compounded by the fact that the broker faces higher fines per agent who allowed his insurance to lapse. TAR asks that the Commission reconsider the fine amounts and seek a lower amount to be imposed on the brokers through a revision of 1260-02.32 and this proposed rule. Proposed Rule 1260-01-.17 establishes the framework through which new licensees are to be fingerprinted in compliance with the amendments to Tennessee Code Annotated Section 6213-303. Our concern is that the rule is broader than the underlying statute, specifically with regard to who is required to be fingerprinted. Under the amended statute, all applicants for initial licensure must provide a complete and legible set of fingerprints. Tennessee Code Annotated Section 6213-303 L1. However, the statute also provides an exception to this requirement. Tennessee Code Annotated Section 6213-303 L2 states, the Commission shall refuse to issue a license to an applicant for initial licensure who does not comply with subdivision L1, provided a licensee who requests to obtain an affiliate broker after being licensed as an affiliate broker shall not be required to submit a set of fingerprints pursuant to this subsection L. However, the proposed rule goes a bit further. Pursuant to the proposed language of the rule, it would include any person who previously held an affiliate broker license but no longer holds said license at the time each person applies for a broker's license. In the definition of initial applicant, thereby requiring them to provide fingerprints, Rule 1260-01-.17 1E2. As a point of clarification, TAR would request that the proposed rule be amended to clarify that this requirement does not apply to anyone who is reactivating his or her license or bringing it out of retirement. Secondly, the proposed rule sets forth that all sets of classifiable fingerprints required by this rule shall be furnished at the expense of the applicant, and that the applicant shall make the arrangements for the processing of his or her fingerprints with the company contracted by the state to provide electronic fingerprinting services directly, and shall be responsible for the payment of any fees associated with processing of fingerprints to the respective agency. Rule 1260-01-.171B and C. However, the rule does not allow for this. The clear language of the statute states that the Commission may authorize the Tennessee Bureau of Investigation to collect from the applicant the costs incurred by the department in conducting the criminal background check. Tennessee Code Annotated Section 62-13-303-14B. The statute clearly states that TBI is authorized to collect the cost incurred by the department for conducting the criminal background check. It does not permit the applicant to be charged with services of the third-party company for transmitting the fingerprints to the TBI. Please feel free to call me with any questions that you may have. I look forward to speaking with you regarding our concerns. Sincerely, J. Russell Farrer. As I said, there's 3 issues in this. If you all would like to take them one by one, we can go back to them because they all appear somewhat distinct from one another.
Ms. Crop, would this be an appropriate time? I have been asked by a couple of commissioners that they would like to take a short break.
That's fine. If you need to take a break, we can do that.
Okay, let's take a 5-minute break, come back quickly.
That letter you just read from Tara, is it publicly available?
I don't have I only have my actual original, but if you'll give me your email address.
You ready?
200.
I'll call this meeting back into session. Ms. Crop, I'm turning it over to you.
Okay. We'll start with his first concern. That was regarding the errors and omissions insurance rules having a larger penalty fee schedule for the principal broker than the underlying individual whose errors and omissions insurance lapse, and his concerns with the discrepancy in those penalty fees as laid out in the rule.
Do you have any comments on his concerns?
Well, I recognize what he's saying is correct in that the fees outlined for a principal broker is $250 if it's backdated. This is from the 30 to 120 day period, and $500 if it's not backdated within that 30 to 120 day period. The one on the first page is $200 for the individual if it's between 30 and 120 days, and $400 if backdated within that 30 to 120 day range. But not considering, something that I don't know if this was considered or not, the underlying individual who didn't do it did have their license suspended for a period of time, which is factored into the penalty for not maintaining that insurance. That's something that is not applied to the principal broker. They're not suspended in the interim. For example, if someone's insurance lapses on January 1st and they get it reinstated 90 days afterward and they have it backdated, they've been suspended for 90 days, plus they pay a $200 fee if they have it backdated. The principal broker only pays the fee, and there is the provision in there that the principal broker within that 30 days, if the person either provides insurance or they broker release them, then the principal broker has an option to have no penalty. However, if you all would like to revise these numbers, that's something we can do, but I think that some of those things are relevant considerations when thinking about the penalty fee structure for reinstatement of the license.
Ms. Crop, if that's based on one person, but if that broker has 10 people, then it's 10 times that fee, is that right?
That's correct.
Not sure that's not a little harsh.
Well, they can also broker release them.
Well,
They can broker release each one of them.
That may be true, but if I had a real good agent, I'd hate to broker release him, or she. If they're not worth a flip, not produce me any money, I'd probably turn them loose, but
Well, if they get their insurance within that 30 days, likewise, there's no penalty. If they're a good agent, one would think, they would take care of that. But we can, his concern was our existing civil penalties rule, the civil penalty range, which this was the reason why this was set this way initially, also considering the suspension factor for the affiliated licensee. The minimum civil penalty for a violation of section 6213-312B15, which is failure to supervise, is $250 per violation. However, within this rule, since it's just another rule and we're assessing really a penalty fee as opposed to a civil penalty fee here. In this particular set of circumstances, if you all did wish to lower that below $250 or $500, I think we could say notwithstanding, this rule, in this instance, we could make that lower if that's what you all determined you wanted to do.
Or we could make the agent higher.
Or you can make the agent higher, that's correct. It's really up to you, but that's the basis of his concern and some other things that, I thought would be relevant to your deliberation.
So from my opinion, just to discuss a little bit, this commission has, since I've been on it, has taken the position that the principal broker is the contact person and the person that we turn to on any issue. And so the question is, if an affiliate fails to buy errors and omissions insurance and the principal broker fails to broker release, what's the penalty to the broker?
And I would note that within the statute, as amended by the Public Act, it mandates notice be given to the individual whose insurance is lapsed and the broker. So there would be little argument for I didn't know, because the statute actually mandates that the commission, as part of the notice provisions, send notification of the license suspension by regular mail to the licensee's broker, and that's immediately upon suspension.
Oh, the minimum fine, you said, for failure to supervise is $250?
As specified in our civil penalties rule.
Julie, if we change any part of this, does it affect when it goes into effect?
I think if we were just changing these amounts, we can still, just address that this is the amendment you'd like to make and then move forward with that when we do our analysis later on. But it's something we need to address now and determine if that would be part of the response to that part of his comment, is whether or not you want to change it or not.
bill's in effect now.
Yes, the bill is, but our rule is not. So at this point in time, we have the policy that says it's the maximum and they can write in and, try to request less. That's in the interim until this rule becomes effective, because the amendment to the statute is already effective, and it allows for a licensee suspended more than 30 days but less than 120 days, a penalty fee of not more than $500. So as Commissioner Haynes was saying, if you wanted to do this, you could increase it for the individual licensees to echo the principal broker if you thought that were appropriate. That would be allowed by the statute to do that as well. Just responding to your comment.
Mr. Chairman,
Mr. Alexander,
I'm going to make a recommendation that
recommendation or a motion?
I'm going to make a motion that we reduce it to the same as affiliate,
Reduce what?
the fines.
To the broker.
The penalty to the principal broker?
That it be the same as an affiliate broker. I want to give my reasoning. Those of us that have been on this commission, and since we've had all this problem with renewing E&O insurance, we've got it now where we think we'll not have near the problem that we've had in the past. We would not had that had not TAR gotten behind the bill. They got it done for us. And they have done most everything we've ever asked them to do. I give them a hard time all the time, especially on contracts and other things like that. But still there's time to use a little judgment, and that's my motion, and my reasoning.
I'll second.
We have,
Beat you to it.
we have a motion by Commissioner Alexander that we make the
Both of us.
penalty for failure to renew E&O insurance the same for the principal broker as it is for the affiliate broker.
Tell the clerk who's second.
One,
And it was seconded by Commissioner Haynes. Now discussion.
yes. I want to be sure, though, that the fact that if they've got 10 folks in, it still stays, it's 10 times for each affiliate that's behind.
Right, it says, $250, let's see.
It'll be 200.
$200 and then now $400.
So, Mr. Chairman, does that include the 200, 400, 500? Are we going all the way down? Okay.
Yes. Any other discussion?
I want to ask,
Commissioner Grease.
since Julie gets through looking at something,
I think Commissioner Grease has a question of Ms. Crop.
not until she's done looking. So do you need language that specifically states this is less than the minimum requirement, or minimum civil penalty for failure to supervise?
I can I can work it into exact language, but I think that's something that we would need to put that in there, notwithstanding our provisions of this one, that they will be lowered. And to make sure I understand your motion fully, what you're saying is on C1, I and II, it would say $200 if the affiliated licensee's insurance carrier backdated the licensee's E&O insurance policy to indicate continuous coverage, or then it would say now $400 if the affiliated licensee's insurance carrier did not backdate the licensee's E&O insurance policy to indicate continuous coverage. That's your motion of the two amounts to amend? Okay.
On page 3, is that the ones you're reading, Julie?
That is on page 3, and
Yeah.
that is, right, that's the one I, and then II is what it's labeled. Commissioner Alexander, did your motion include paragraph 2, where it says that there's a civil penalty of $1,000 if it's more than 120 days after suspension? Because it cuts off at $120. $1,000 after that 120-day period for a principal broker. If you look on page 2 of the rulemaking hearing, it's $500 if it's from 120 days to 6 months, but then it increases up to over $1,000 if they go over month 12. It is capped for a principal broker. It's slightly different there. That's not something he'd addressed now. I'm just making sure I understood your motion.
I only want to do what he addressed.
What he addressed, just those two then. Okay.
Mr. Chairman,
Commissioner McMullen.
I'd like to ask a question to either Ms. Crop or Ms. Maxwell. Based on historical numbers and what you've seen, approximately how many either affiliate or principal brokers would be subject to these penalties in any given year, just based on what you've typically seen as far as violations of insurance?
I think that not this year, before this most recent renewal, we had about 290 or so principal brokers. The principal brokers who have uninsured licensees normally have more than one uninsured licensee. And that's about, it seems like that's about what it kind of all boiled down to when we got everything in and got it sort of all processed through. That was about 290 to 300 principal brokers.
Thank you.
Any other questions or comments? Chair is ready to call for the vote. All in favor of Commissioner Alexander's motion, say aye. Aye. Opposed, no. Motion carries. Continue on, Ms. Crop.
The second issue addresses something with regard to the proposed rule regarding fingerprinting. To give you an overview of what he had stated, his concern.
Ms. Crop, are we finished with the E&O part? Have we addressed everyone's comments from the E&O before we move on to that
That
fingerprinting?
That was his only concern regarding the E and O. That was the only issue he raised regarding the E and O rule. His remaining two concerns both address separate issues with the fingerprint
But do
rule.
we have any other comments from anybody else on the E&O policy?
We've addressed everybody that signed
Okay.
in to speak, and then these were the only two written comments.
Okay, thank you.
And, Ms. Crawford, if I could ask, as we go through this rulemaking process, is there any action we need to take to have read into the record that we are finished with the E&O portion of this rulemaking, or we just need to just transition right on into fingerprinting?
Well, since this is just a comment portion and everything was open to comments at this part, it's actually just a comment portion.
Okay.
And we will close that before we move on to the analysis. But this is really just a general comment portion as to both rules. So the second issue addressed by Mr. Farrer in his letter is that under the rule, it states that any person who previously held an affiliate broker license but no longer holds said license at the time that the person applies for a broker's license falls under the definition of initial applicant, therefore requiring them to provide fingerprints. He said that he thought that that was going further than the statute, because the statute said all applicants for initial licensure shall provide fingerprints, and it did state in a section that provided a licensee who requests to obtain a broker license after being licensed as an affiliate broker shall not be required to submit a set of fingerprints pursuant to this subsection L. And he asked as a point of clarification that the rule be amended to just clarify, as a point of clarification, TAR would request that the proposed rule be amended to clarify that this requirement does not apply to anyone who is reactivating his or her license or bringing it out of retirement. Just to address that, if you've looked in the notice of rulemaking hearing, the section that he's speaking about is on page 4 of your notice of rulemaking hearing. Toward the top, it's E2. It says, in addition to new applicants for broker, affiliate broker, timeshare salesperson, or acquisition agent license, the following are considered initial applicants for purposes of this rule and therefore are required to submit fingerprints in an electronic format for the purpose of obtaining a criminal background check. Number 2 is any person who previously held an affiliate broker license but no longer holds said license at the time such person applies for a broker license. This was meant to contemplate, this was outlined to speak of a person who either had a license revoked, had it expired for a number of years, went away and came back and was applying for a broker's license. It was not intended to cover someone who placed their license into retirement or inactive status, as Mr. Farrer appears to be referencing. We can include a clarification, but it's been my understanding throughout the time that I've been here that if you have a retired license or an inactive license, you still have a license, and therefore that would not be someone that would fall under this subsection 2. But if the commission feels that further clarification is necessary, then we can do that by adding that into that paragraph.
I think clarification's necessary myself.
Okay.
I don't know about the rest of the commission. The clearer we are, the better.
What do you recommend?
It
Add the
would be as
language.
simple as that. The sentence
Adding
said,
the language, yeah.
licensees in retirement are considered to have a license and don't fall under this category. Something to that effect.
In retirement or in inactive
Right,
status, because
retirement.
he mentioned reactivate as well, which would cover anybody who may have gone inactive for a period of a couple months. Licensees who are retired, or something to this effect. It's licensees who are retired or in an inactive status.
Specifically excluded from this requirement, or however you want to say it.
Okay. Or not included as part 2, or something like that, just clarifying
I'll
that.
second that motion.
I don't think we had a motion, but I do want to ask,
I'll make the motion.
I-
I thought I made a motion, but I didn't say I make a
It
motion.
doesn't have to be a motion necessarily.
Oh, John made the motion?
I just like,
You make the motion if you
I would just like to ask and remind all the commissioners to speak up, because we've got a court reporter that's taking dictation of this proceeding, and she needs to be able to hear and we need it clearly read into the record. I mean, how would you phrase the motion if you were to make a motion, Commissioner Grease?
We'd phrase it just like Commissioner Russ Farah put it. Where did he have it? I'm
It's
sorry.
at
I'm
the
looking-
bottom of the second page of the letter, the very last part of the second to last paragraph, the last sentence there.
His letter. The clear language of the statute states that the commission may authorize the well, no, that's the wrong one. You got it? Okay, you
Mr.
go.
Grease?
Their request is that the proposed rule be amended to classify that this requirement does not apply to anyone who is reactivating his or her license or bringing it out of retirement. I think we say that or some similar language.
Or something like, this will not apply to anyone who has an inactive or retired license at the time of application for a broker's license.
Says the same thing.
Yeah, I understand your,
Okay.
Do you consider that a motion?
That was my motion. Mr. Alexander, thanks for asking.
I'll second it.
And Commissioner Haynes is to second the motion that Commissioner Grease has read into the record with some help. And any discussion on this motion?
I got a question.
Okay, Commissioner Collins?
Do we need to go further say that anyone who has been suspended or had their license taken away does not apply? Do we need to do that? We've kind of circumvented that.
Good question.
you mean if they've totally lost their license?
Right.
If totally lost, it's just like starting all over again, and it's already in there.
Well, suspended, though, wouldn't be in that totally lost category.
But we've taken them away for cause.
Yeah. But it
License
wouldn't be
taken away.
total.
But
like
if they're coming
revocation.
back, I think they need to be scrutinized a little more.
Well, I agree, but I'm just saying, I think if they've done anything they shouldn't do, they should.
Well, and
have
this
to-
was also supposed to include somebody that it had been expired for a long period of
Yeah.
time too. But if you, so you're saying for someone who's been suspended or, well, if they've been revoked, then they obviously have no license once they come back, and that would fall into the language
just asking,
as it
do we
is
need
now. Suspension, I mean, we could say that, but no longer holds said license. I don't know, I mean,
But are we leaving loopholes by not saying it, or are we putting too many outs in there to put it in there?
Yeah, there are like about 50 license statuses. I mean, you know, some are bad checks, some are problem. So I don't know whether it's, you know, whether it's more dangerous to start listing the things that would not be applicable as opposed to just carving out these two specific
That was kinda my
categories.
question.
Because we do have a number of other categories, some of which probably will change when we get the new system, at least the way they're designated, and it might be more difficult to do that.
If I'm not
It's y'all's
mistaken,
decision.
can't you get your license, in your license automatically suspended if you don't pay child support?
It is, or Tennessee Student Assistant.
Or you don't pay your student loans?
Loan, correct.
So,
in those cases, though, they're not reapplying when they come back, they're just reinstated. They're not going through the application process like someone would be if they had been revoked or if they had expired for a long
But
period
if they're
of time.
suspended, they're not going through it either, right?
They're not going through the application process, for
Well,
example.
I personally think we need to just exempt the inactive and retired and not start naming all the other classes, because I think we would leave something out or open it to loopholes.
This is intended, the way it was written was any person who no longer holds a license and therefore has to reapply is the intention. And by addressing his comment, I think he just wanted to be sure that this doesn't include inactive or retired people. This would be a person that had an affiliate broker's license, for example, for 5 years, then let it expire for 10 years, could not come back and reinstate, and had to submit a new application. That's what we were trying to address here. Or someone that had been revoked for 5 years and was coming back to reapply. And as part of that, because it is part of the reapplication process, so.
Well, and I think if somebody's license has been expired for 10 years, they could have gone out and gotten into anything. So they definitely should have to be fingerprinted and everything. I mean, I don't think.
Define inactive for me, please.
Well, it's in there. I think it is for a certain period of time until, it's not a renewable status, but it is a status that's recognized in the statute. I'm not going to be able to find it now. I know it's in 3.
I think his motion, I think the concern that Russ Farah was expressing, I think this motion clarifies it.
Oh, 318.
I think it's fine without any additional to it.
I'm just afraid we'll open up too many loopholes
Yeah, I'm
by
afraid so too.
Just,
starting to name
I
names.
think we just need to vote on this motion and continue on. Do you have?
Agree.
As a short answer to his question, an inactive person is someone who is tried to enter their license into temporary retirement, but does not yet have the requisite continuing education. So you could be in an inactive status for a short while if you had not yet completed the
If you
education.
define term, and then I'll be okay.
Fine.
The term, is that what you asked? You can, if you turn in Track 1 to retire and you don't have any education, then you're placed in an inactive status, and you will remain in inactive status until either the renewal period ends, so your license expires, or you get your education within that renewal period. So once your renewal period is up, if you haven't gotten your education, your license expires. It is not a renewable status.
Mr. Chairman, could I ask a quick question, Ms. Maxwell and Ms. Crop?
Yes, sir.
Based on your knowledge of the historic licensing statistics, approximately how many applicants would you expect to be required to do the fingerprinting on an annual basis?
Based on the number of people that we have answered question 5, yes? I mean, is that?
Whoever's required under the statute to get fingerprinted, about how many a year?
Everybody has to get fingerprinted. I mean, like now, like all initial applications. So if you take just the people who are, take the inactive, the active people, the retired people, take those out, or the other people, we've averaged, I think the statistics show this month we had a little over 300 applicants. For last year, maybe we had 2,600. So that would be the people who initially applied. And then the people who already had a license applied for broker, they would be taken, they would be exempted out. So we probably, I'm thinking, and I really don't know, it's kind of hard to say, but I'm thinking that we'll probably have anywhere from 2,500 to 3,000 people a year who have to be fingerprinted. I mean, unless things just take off dramatically. And how many of those actually will turn out to say have to appear before the commission? Our numbers really on that front have been relatively low, so I don't anticipate that hope they don't change much.
Then how many have to get the criminal background check that this rule addresses?
Well, so everyone will have everyone will have a background check that gets fingerprinted. And of those, if they come back with what they call a hit, where it comes back and shows that they have a criminal history, right now we have probably, so I happen to have 3 this month who answered question 5, which is the criminal history question currently, who answered that yes. But I would say in a given year, we have 12 to 15 who answer it yes and have to appear with a felony or misdemeanor involving the theft of property, services, or money. So, I don't think it's going to, that's why I say I hope it doesn't have a real impact on who comes before the commission, because we hope that people have been answering correctly before. And it'll pick up individuals who have DUIs, and we get a lot, number of those, but the people who actually have to come before the commission is not that many. Does that answer your question?
And how are you prepared in the office to handle this?
Well, we can, when the fiscal note went up and became part of the record, it allowed for us to hire an additional person. So we can hire additional person to do it. What we're trying to see is exactly what the flow is going to be into the office, and then determine sort of what category of person we need to hire, and then go from there. But I talked to Assistant Commissioner Giannini about it last week and then about a month ago. So we're moving towards trying to get a feel for exactly what we do need and what position that person will hold.
The note included hiring a full-time person
Yes, to do that.
to do this.
I think because no one was exactly sure what the volume would be when it did start to come in.
Are that person's job, I guess, qualifications is just to look through all the fingerprints and see what the background is, and if it's something that we need to,
Well, it comes
They
through,
need to come
what happens
before
is
us?
it comes, the TBI supplies the information to us, and so it comes through on the computer. And the one program, one of several programs like the Protective Services, the people that do it now, the guards, they run off all the paperwork that comes in and go through each one as it comes in. And if it has a hit, and, that's a hit that requires action, say, to come before the commission, then those are taken out, and then the other ones are just processed as part of the application.
do you expect she's going to run those off, or just going to be electronically
Well, I'm
viewed?
hoping that maybe we can do ours electronically.
That makes sense.
They have a different, obviously, for armed guards and unarmed guards, they have a whole, they have a different set of factors that they're looking for. So I'm hoping that we don't have to run all of those off, that we'll be able to just look at them on the computer. But
Maybe run off the ones that have hits.
Right, but, and part of that is because if you've seen one, when it has hits,
It's real
It's really
confusing.
confusing to figure it out, and it's not like they come in any different format than what you all see when you look at yours. And so, if they have one of those that's kind of complicated, you almost have to, I think, kind of run it off and look at it and analyze it as you go through.
If I could remind this commission that we're getting a little bit over the top of what we're supposed to be doing this morning.
Mr. Chairman, I call for the question.
All in favor of the motion that we've been trying to vote on for 20 minutes, say aye. Aye. Opposed, no. Motion carries. Continue on, Ms. Crop.
The last comment in Mr. Fair's letter also addresses the fingerprint rule, and he states that the proposed rule states that all sets of classifiable fingerprints required by this rule shall be furnished at the expense of the applicant, and that the applicant shall make arrangements for the processing of his or her fingerprints with the company contracted by the state to provide electronic fingerprinting services directly, and shall be responsible for the payment of any fees associating with the processing of fingerprints to the respective agency. He states that the legislation only authorizes the commission. It authorizes it says the commission may authorize the Tennessee Bureau of Investigation to collect from the applicant the cost incurred by the department in conducting the criminal background check. My initial thoughts on this are this company that handles taking in the fingerprints electronically and transmitting them directly to the TBI is just an agent of the TBI. The TBI is, to my understanding, not it's not possible for a licensee to walk into the TBI and give them the electronic fingerprints. There's a contract between, I believe, the state through the TBI and this company that is how electronic fingerprints are handled, and that company is just an agent of the TBI for the purposes of collecting fingerprints.
So what's his concern?
I don't know. His concern is that the statute only, it says the commission may, that the commission may authorize the TBI to collect the funds from the applicant, and here the rule says that the amount is to be paid to the company collecting it, but that's just the way the system works with the TBI and this company. There's a contract separate and apart from the Department of Commerce and Insurance. The TREC, none of us had any say in who's doing that. If you do electronic fingerprints with the TBI, that's just who it goes through. And I believe Ms. Maxwell has a little more information. I don't know if it's a worry of increased costs. From what we've been able to determine, the cost is actually less.
How much is that I'm a new agent getting ready to apply. What's it going to cost me?
Electronically, it costs $42, and if you were to do it on paper and print and send it into our office, it's $60. So it's cheaper to do it electronically and really more secure.
And efficient, and time
to do
efficient.
it. That way, it saves time in the long run of actually
New
getting
agents will have to go to this company, whoever the
And this,
XYZ
the
brand
company represents that they have a vendor within 50 miles of everyone's location. And it's the company that does it for the state, so they do it for armed guards and armed guards. I've talked to the executive director of those programs, and she hasn't had anyone complain that they can't go, can't find a place. They have quite a number of those, and the person, much like you take the PSI test, you sign up with them at a time to go have your prints done, and they do them and then send them off.
Are we responsible for making sure that, or they have to find all this information on their own?
No, it'll be on our website. I have a copy of the letter or the informational sheet that Armed Guards has, and so I'll just parrot some of that, and then I've done all the research into the firm that does it, so I'll probably put some additional information that they have on there, and then you send them to their website, and they sign up online, or they can call on the phone and sign up if they would prefer to do that. So it sounds like it's not a difficult process. They haven't had any problems with it from their end, and they've been doing it for a number of years.
Mr. Chairman, can we add in our new rule that the classifiable prints, that payment goes directly to the agency authorized by the TBI and FBI?
That was kind of where I was going with that too, Commissioner Bloom, just to clarify it more, like Mr. Farah has it in his letter.
Would you like to put that in the form of a motion,
Well,
Mr. Bloom, so we can discuss it?
Yes, sir. I'd like to make the motion that we add in 1260-01-17 1A, after prints directly to the agency authorized by. And then that goes on to read TBI and FBI.
Where are you reading it from? I'm sorry, I'm lost.
It's in the second page, page 3.
Page 2, okay, to the respective agency, that's where
Right,
you're ending.
right.
And okay. I'm sorry, I was lost.
I was just adding classifiable prints directly to the agency authorized by the TBI and FBI. You're saying that's who does it?
That's who it goes through that company.
Yeah, and that would, I think, address his concern.
Heard the motion made by Commissioner Bloom with the addition of this wordage. Do I hear a second? You seconded, Commissioner Collins seconded. Now discussion on what Commissioner Bloom has brought.
Would that take care of it, Julie? Would that answer his concerns, you think?
I'm not sure. I mean, I think that it clearly states what I was telling you verbally, that, they're just an agent of the TBI. It's not possible to go give electronic fingerprints directly to them, and, I don't see a problem with it as worded, but I think that this should help to clarify that. I'm not sure exactly what his concerns are, if it was a greater cost or if it was just a wording issue. I don't know if that will satisfy him, but I think that would be in compliance. I mean, I think that would be within the intent or within the parameters of the statute, because this is just an agent of the TBI.
Is there more than one? And is there a possibility that, there are other companies out there that do this, but they would have to apply to the TBI, and so we would stay out of that?
Right, and and it's a state contract, so I don't,
Okay.
it's statewide
Okay.
for anything and everything that requires
So the
fingerprints.
state has to.
Right, so we
through
would
that
not be
process.
part of that process as it ended up anyway.
Mr. Chairman, I'm in agreement with Mr. Bloom's suggestion. I just wonder on page 4, Julie, Gary, anybody else that's following, at the top, subsection B, is that redundant? Do we need that in there? If we have in C, the following paragraph, that the fees associated with it are going to be paid by the applicant.
That's up to you all. I mean, I wanted to make it that part of it extremely clear, that was not included in the cost of license application to the Real Estate Commission, but,
And what really got me to that paragraph was the same thought process Gary was working on. In subsection C there, company contracted by the state, it's not contracted by TBI, is that correct?
Well, TBI is the state.
Oh, would it be good to put the Tennessee Bureau of Investigation in at that point, just so it's clear that's how it's going to be handled?
I have not seen a copy of that contract, so I don't know the contract's wording. So I don't know, if it's worded as the state of Tennessee some of our contracts say the state, even though it's a contract, involving the Real Estate Commission with, PSI, for example, currently for our testing. So I don't know, because we have not been able to get a copy of that actual contract. We left it broader to govern it. That is who it would be between, but I would hate to get too specific if that's not how it's worded.
Thanks.
Any other discussion on the motion that Commissioner Bloom has made, seconded by Commissioner Collins? I think it does clarify a little better, Commissioner Bloom. If no more discussion is in order, do I hear a motion? I'll call for a question. All in favor say aye.
Aye.
Opposed, no. Motion carries. Julie, I think will handle that for us. Yes, Julie.
That's the last of, that's the three concerns, as I understood them in Mr. Fair's letter. I don't know if anybody saw anything else. He actually did first and second, but I saw three issues. I see no more issues for you all to respond to there, and that is all of the written and current comments, so I think that would be all of the comments we have. I'd like to make these two written comments exhibits to the record, if I may, and that will conclude the comment portion of the rulemaking hearing at this time. So we'll then have to.
So we don't have anybody here who wanted to speak on the fingerprint issue?
Everybody that was here to comment was supposed to sign in at the beginning, and it was only actually one person that ended up wanting to do that. I went through the entire list. There were 5 names, and 4 were just mistaken. They thought that was the sign-in sheet, so. At this time, we will continue with the economic impact statement and the statement regarding the projected financial impact on local governments for these proposed rules before the commission votes to adopt the rules. I've included the considerations for the economic impact statement as well as the impact on local government in the handout which each of you have, along with some recommendations that I've prepared as a starting point for discussion as to each of the considerations. We just need to go through these one at a time.
Where can we find those, Ms. Crop?
It was a printout that I had put in front of each one of you. It just numbers the ones in the statute, since I know you don't all have code books with you. Do you have one?
Is this one broken?
No, I already passed it out. Do you have one?
Does everybody have one?
I'm not sure Grover does either, but Fair and I are sharing.
I'll share with them.
I was gonna say, put
Just 2
John's over
pages.
between y'all, because
Okay.
Grover doesn't have it
We're
either.
going to share this one.
Yeah, I may have it here. That's it.
Yeah,
I
that's
got
it.
it. I
He
got it.
found his.
Got it?
Eureka.
All right. Pursuant to the Regulatory Flexibility Act, Tennessee Code Annotated Section 45401 et sec. As part of the rulemaking process, each agency must prepare an economic impact statement as an addendum to each rule that is deemed to affect small businesses, which shall be published in the Tennessee Administrative Register, filed with the Secretary of State's office, and made available to all interested parties, including the Secretary of State, Attorney General and Reporter, and the House and Senate Government Operations Committees. This requirement is found at Tennessee Code Annotated, Section 45403. The statement shall include the following. We've got 6 statements here that are bolded. I'm going to go through them one at a time, and we just need to discuss and accept by motion a suitable response to each of these considerations. So it would just be a motion to accept a certain statement as a response to each of the following. The first consideration is the type or types of small businesses, and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule.
Mr. Chairman, I move that we adopt the following economic impact statement in response to issue 1. The types of small businesses that would be impacted by the rule would be real estate licensees that do not timely renew their E&O insurance, which is approximately $300 per year, and initial applicants for real estate licenses who are required to get fingerprinted, which is approximately $2,500 per year. The rules are not expected to have a measurable economic impact on small businesses. With respect to the E&O rule, any cost is relatively de minimis and is avoidable by the small business. With respect to the fingerprinting rule, the rule is actually a cost-saving measure that will benefit applicants.
Heard the motion that's been read in the record by Commissioner McMullen. Do I hear a second?
Second.
Seconded by Commissioner Grease. I will not attempt to repeat that motion, but if anybody has any comments or questions, hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
The second consideration is the projected reporting, record-keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record.
Mr. Chairman, I move that we adopt the following economic impact statement in response to issue 2. There are no projected reporting, record-keeping, or other administrative costs required for these proposed rules.
Second.
A motion made by Commissioner McMullen and seconded by Commissioner Deschara. Any discussion on this motion?
One quick question, Ms. Maxwell. Did you indicate that the state is going to have to hire an additional employee to take care of this fingerprinting issue?
We anticipate that we do. That was in the fiscal note to provide for the hiring of an additional employee.
A separate issue in your mind?
Could I ask a question, Ms. Kropp? Is this question intended to address the additional reporting, record-keeping, and administrative costs that small businesses would bear, or is it supposed to also address any additional costs to the state?
On my reading of the statute, it says that is deemed to affect small businesses. It does not appear in the statute to reference the state. If you'd like to include that in there to be on the safe side, based on my reading of this, and it's what I mostly quoted to you all before we began, it's speaking of a rule that may have an impact on a small business. And a small business is defined in there
State's not a part of it.
within that part as,
With that thought in mind, Ms. Kropp, if the state would not be included in this is just the way the statute reads, as you were saying, it's just for small businesses.
it says small businesses, and within 45102 in the definition section, it says small business means a business entity, including its affiliates, that employs 50 or fewer full-time employees.
Question's been called on. All in favor say aye.
Aye.
Opposed, no. Motion carries.
A statement of the probable effect on impacted small businesses and consumers.
Mr. Chairman, I move that we adopt the following economic impact statement in response to issue 3. There is no expected material adverse impact on small businesses or consumers as a result of these proposed rules. These proposed rules are expected to assist with the protection of the welfare and safety of the citizens of the state of Tennessee by helping to ensure that all licensees who are required to maintain errors and omissions insurance will do so, and by further outlining the procedure for the collection of fingerprints for the purpose of obtaining a criminal background check for initial applicants for licensure, which will further benefit consumers. The electronic fingerprinting procedure will economically benefit small businesses.
Second.
You've heard the motion. It's been read in the record by Commissioner McMullen and seconded by Commissioner Grease. Any discussion or comments on the motion that Commissioner McMullen has read? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Number 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small business.
Mr. Chairman, I move that we adopt the following economic impact statement in response to issue 4. There are no less burdensome, less intrusive, or less costly alternative methods known which will achieve the purpose and objectives of these proposed rules.
Second.
Have a motion made by Commissioner McMullen and seconded by Commissioner Bloom regarding number 4. Any questions or comments? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Number 5, a comparison of the proposed rule with any federal or state counterparts.
Mr. Chairman, I move that we adopt the following economic impact statement in response to issue 5. There are no known federal or state counterparts to these rules.
Second.
Have a motion by Commissioner McMullen and seconded by Commissioner DeShara. Any discussion on this motion regarding number 5? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Number 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule.
Mr. Chairman, I move that we adopt the following economic impact statement in response to issue 6. Any possible exemption of small businesses from these rules would result in less protection for the citizens of the state of Tennessee and would not be feasible given that many licensees are small businesses.
Second.
Motion by Commissioner McMullen concerning number 6 and a second by Commissioner DeShara. Any questions, discussions, or comments? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
We have one following consideration pursuant to Tennessee Code Annotated Section 45228. We need a simple declarative statement. A simple declarative statement must be adopted regarding whether the rules may have a projected financial impact on local governments.
Mr. Chairman, I move that we adopt the following simple declarative statement. These rules are not reasonably viewed as having a projected impact on local governments.
Second.
Have a motion by Commissioner McMullen, seconded by Commissioner Grease, regarding Tennessee Code Annotated 4-5-228. Any discussion? Hearing none, all in favor say aye. Aye. Motion carries unanimously.
Okay, that concludes that part of the analysis. So now the commission will address by motion whether it wishes to adopt the proposed rules as we have amended them here today during this rulemaking hearing, and this will need to be voted upon by a roll call vote.
One at a time, or one rule at a time?
Oh, no, just a motion to adopt the rules as amended here today. Something
Move to
that-
adopt the rule as amended.
Second.
We have a motion by Commissioner McMullen. I have a motion by Commissioner McMullen and seconded by Commissioner Collins that we adopt these rules that we have been discussing this morning as amended. Any discussion? Hearing none, all in favor say aye.
Roll call.
Roll call vote. Little minor detail. Call the roll, Ms. Maxwell.
This is to adopt the rules as amended. Haynes,
Yes.
Alexander,
Yes.
McMullen,
Yes.
Bloom,
I agree.
Collins.
Yes.
Grease,
Yes.
DeChara,
Yes.
Stevenson,
Yes.
Flitcroft is absent, so a vote yes to adopt the rules as amended.
Okay, that concludes this rulemaking hearing. So thank you to everyone for being here today and participating.
Thank you for making it clear.
Yeah, thank you, Ms. Crop.
So we've completed that part of it, and we're a little bit before lunch. I don't know if it's up to you, Chairman. That's all I have for the rulemaking hearing.
We move Commissioner Grease's advertising comments, this spot?
Take longer than 15
No, it
minutes.
won't.
He said it would only take about 5. Now, I'm going to hold him to his word. Commissioner Grease, tell us.
You being a man of your word consistently, I can see how you'd want to do that. So, Ms. Crop, last month in the town of Farragut's Town Hall, this commission approved some guidelines related to advertising. Is that the right way to say it so far?
Not really. When I started out at the beginning, we talked about doing guidelines, but after looking at it from the perspective of then pursuing these licensees for potential violations, I think the better course of action would be to address it by amending our advertising rule to clearly specify some of these issues and possibly adopt a new rule with regard to some of the team issues, because we don't have those addressed anywhere. So actually, the way it was presented to you all last month was a possible revision to the advertising rule, some of which I know Commissioner Bloom specifically had thought he didn't really think constituted misleading advertising, but maybe could worded some other way. So at this point, I had planned to come back with a more revised rule this month. It was told to me about a week ago at least that we probably would not get to an in-depth discussion of that, so I did not prepare that for this meeting due to our packed agenda, but I will have more of that next month. But it will be something that I believe would be best affected by amending our rules.
Okay, so I'm not arguing with you on that. At this point, Ms. Maxwell, for instance, if some broker calls and says, is this, can we do this? And it's not clearly stated in a rule at this point or in a statute, how do you answer some of these topics we've been covering?
Well, I answered one of those yesterday. Well, I start off telling them, well, first of all, we can't pre-approve advertising
Right.
anyway. But, I go through the analysis of whether, that no advertising can be misleading, deceptive, or false. And so I go through that part of, that part of the explanation, and then I state what the commission has decided, their interpretation of the statute regarding the font size of the name of the licensee and the firm name, and that the phone number needs to be on there, and that the firm name has to be, and the licensee's name has to be as licensed with TREC. If they ask about teams, which this one asked about yesterday, I tell them that, teams are not recognized under the statute, and that the commission has recognized that the statutory language applies to the font size of the firm name and the licensee's name, and the teams aren't even recognized, and that would be misleading that could be potentially deemed to be misleading to the public if they did not know with whom they were dealing. And then, I say that it's, that the public needs to know, how they can contact the firm. So I kind of go through that reasoning. And the bottom line is I don't give a definitive answer because I can't give a definitive answer. And I say that the principal broker, that the principal broker needs to review all of the advertising before it's released, and that they need to look at it from the average individual, what their impression of whatever it is. And if you remember, the web advertising really only says that you have to have the firm name on every page. So that's where a large number of the problems
Right.
occur.
So our minutes from last month reflect what we did. I don't recall what they're categorized under. I mean, we said this is our interpretation of a violation or is false and misleading advertising. I mean, we've made that statement, but how would we categorize that statement? What is it that we did?
Well, I mean, the way I understood it when I brought it up last month was we were moving toward these being possible amendments to the rule. However, in the meantime, I mean, if Ms. Maxwell gets things in that that somebody says, hey, I think this is misleading advertising, we can open those complaints in the meantime. In that case, you all would not be utilizing those guidelines to go, hey, you missed 1, 2, and 3 here. You would consider it on a factual basis to say, well, we think this constitutes misleading advertising. And in the meantime, you can address it on a case-by-case basis using the facts of the situation to determine if it violates the rule as it is now.
Okay, so
Why-
let me get one more question, I'll be done. we're going to get to rulemaking. What timeline do you see based on what we've done so far, as to go through the same exercise we did today on advertising?
We'd have to have a finalized rule, which I would hope we could do that next month. Like I said, I'm sorry, I thought we were too packed today to get into something that in-depth. I was told there was no way we could probably get through it with all we had on the agenda. But if you wish to have a different team rule, which I was going to work on for next month as well, if you did just those two rules, we could, the rulemaking timeline varies. If you pass off on them next month and we go ahead and do the analysis, then I can go ahead and work towards setting it for a rulemaking hearing. The benefit to the rulemaking process is, in the meantime, while the rules are pending, licensees have notice, they can come and comment like they did today, and you all have just more of an opportunity to consider what you're actually doing at that point, instead of saying A, B, C, D, and E, we consider this absolute violations, and then, in a certain case, maybe it's not so much of a, of an issue. We might have somebody that comes in with a valuable comment that could help us address, something maybe we hadn't thought of from another perspective.
So, Julie, what I'm trying to get to, in my mind, is, so we have you come with a rule next month, and then it has to, how long does it have to be published before we can actually do the rulemaking hearing?
I believe it has to be published for 50 days. There's a little bit more time period to that because I have to have it has to go up to the governor's office that has to look at it, and the attorney general has to take a brief check at it before then. So you could say 60, 70 days it's got to be published. You have a rulemaking hearing. It then has to be looked at by the Attorney General's office for legality, and then it has to be published on the Secretary of State's website for 90 days before it's effective.
So maybe by next March or April, we could go through this exercise that we did today as related to advertising or to teams?
Right, but in the meantime...
Does that seem reasonable?
I mean, by March or April, I think, yes, that's possible based on the headway, the progress we've made so far. I think that's possible. And in the meantime, like I said, you're free to interpret your rules on a case-by-case basis. If we see something egregious, there's nothing to say we've got to hold everything back until then. But there's some issues with this rule that, like she said, the confusion regarding the requirements for internet advertising. The top requirements about misleading advertising, they say that the whole rule applies to all advertising, and my thought would be that the internet advertising provisions at the bottom are just additional. Some people may not really understand that. I think that's other language that also needs to be cleaned up so that people are more clear on that. So,
Thank you. I'm just trying to.
Yeah, no, I understand. I hope that did that.
That's good. I'm great with it. Thank you, Mr. Alexander, for that.
You're welcome. Mr. Chairman, it seems,
I was just going to say, you'd be talking about summer before you'd have rules that were effective.
Mr. Chairman, it seems
Yeah.
that we could
That's what I'm looking for.
operate under a policy statement until the rules have been adopted. And if we do that, if we come up with some guidelines and we're operating under a policy statement, then we've got an opportunity for the licensees to have an idea of how we're thinking. Do you get to what I'm saying, Judy?
I understand what you're saying, Commissioner Alexander. It's just that when we're using a policy policies are supposed to be used for internal guidance by the commission to staff as to how to handle situations. They're not really intended to be used as a basis for disciplining a licensee or affecting the licensees. And I think that could be challenged if we ever.
That's my point, though. We've got some guidelines as the commission as to what we're going to do. And then when we file a complaint or consent orders against somebody, here's how we're thinking about it. It's not for the licensees, but for this commission to understand what we're going to do.
Wouldn't that give Ms. Maxwell more of an idea when somebody calls in and asks a question as to how to answer that question if she's kind of going by the policy of what the commission has set out?
I think it would assist her in that, and I mean, in that way, it does help. But I think that if we get down to a hearing, a formal hearing, say on advertising, and it's a charge of misleading or untruthful advertising, and then somebody says, hey, but look at our policy, it's listed here. You can't discipline someone based on a policy. It has to be by the facts and the rules and statutes that we have. So I think that's where we could run into an issue.
But isn't it already statute that they cannot have false or misleading advertising?
It is, and that's why I was saying that, you know, if there's a complaint of that, the commission would then look at it based on the facts that we have at that particular time and determine, does this meet our consideration of what is meant to have misleading or untruthful advertising. I don't know. I mean, you can, that's when I said you can interpret your rules. That's the case where you would do it. I can look at doing that for next month, doing a policy in the meantime. I've just been told that in the past that I've actually got a listing of several policies that I've been told really need to be made rules. And so,
It seems to me that if we sign off on some rulemaking procedure next month, it's the same as stating a policy. We're putting out in front of anybody what we're planning on doing, which is.
well, that's true. There would be notice
Yeah.
through the notice of rulemaking hearing,
Right.
which has been, like for this hearing that we had today, that notice of rulemaking hearing has been available by all the methods Ms. Maxwell noted, sending it out, as well as posted on the Secretary of State's website since August. So there is an opportunity for notice by that method as well, and I just thought it would create less problems for us potentially in a hearing situation by going that route, because it provides the notice, the opportunity for comment before it becomes effective.
Second. Commissioner Alexander has recommended that we break at 11:29 for lunch, and Commissioner McMullen has concurred along with every other commissioner, and we're going to break for lunch. Those you licensees, there's call this Real Estate Commission meeting back into session, and we're going to rearrange our agenda a little bit, and while we're waiting for some people to get here, we're going to go ahead and start with Executive Director Report, Ms. Eve Maxwell.
The first thing on my report is the complaint report, and that is on the iPads. And the first page of the complaint report shows that we have 123 open complaints right now, that we had this past month 36 complaints that were received. So the total, as I say, for the year is 123. The complaints over 180 days are 19, but those have been acted on by the commission, so there's not a problem there. We're at 95% of our complaints have been acted upon within the time frame. We have a couple of complaints that are currently out for investigation, and then we have a number that are in litigation as well. So we're doing well. Julie's doing a great job of having, getting through the complaints and presenting them to the commission, and the commission acting upon them. The amount of money that we have received for the month of October was $26,900, and $4,000 of that was from E&O, from the $500 penalty fee that was provided for in the E&O statute. So there are people that had been suspended who wanted to come back and needed to pay that $500 fee. So that's $4,000 that we've received thus far from the E&O penalty fee. For the year, we've received $102,230. Right now, we have closed 114 complaints for the fiscal year 7/1 of 2013 to 6/30. We'll go through 6/30 of 2014, but thus far, we've closed 114. We've had 2 revocations. 14 complaints have been closed with a consent order. 5 with a letter of warning or instruction, 2 have been referred to an outside agency, and 91 have been closed with no action. And a number of those have been timeshare complaints that have been closed, have been dismissed. The last page is the disciplinary action report. Are there any questions about that or any other items? And then there's a pie chart that shows the distribution of the complaints. Hopefully, it's in color on y'all's iPads. And are there any questions about that? If not, we can move to the licensing statistics, which are.
I think Mr.
Sorry.
Grease has a question.
So we talked this morning about agreed citations, like on advertising. Where do those show up in this?
They actually show up under complaints, because when we send an agreed citation, we have to give them a number, a complaint number, just so that we can track them. So they show up under the complaints, but they go out in the form of it's sort of like a consent order, but it's a little bit less formal than that. And so they show up under there, and we can spin those out if you'd like us to spin those out.
What I'd be interested in seeing is in your last document on this, where you list those respondents who've agreed to a violation.
Right.
They're not included, those advertising issues are not included on that.
They're included in the disciplinary action report if someone pays for advertising or any other citation. That's included in the disciplinary action report. So that reflects the monies that we have received in the month, in this instance, from October the 1st to October the 31st.
My concern is that a lot of licensees don't know that they can get penalized for false advertising.
Right.
Because it doesn't show up on this published list, in my opinion. The disciplinary action report may be published somewhere, but I never can find it.
Right here.
Oh, no, he said on the disciplinary.
On the disciplinary action report, okay. All right, so like the first person on there, advertising violation, we just need to beef that up and make it a little bit more clear exactly what the violation was. Is that,
You say
yeah.
that it's trying to be an educational process, and if it
Right.
says the agent's name was larger than the company's name on a sign, that at least gives them some clue about.
Okay, so we'll just specify exactly what the violation was as it relates to that.
And Director Maxwell, I believe Connell House did that this past month, that went out to the associations.
Oh, we did? Okay.
I believe the ones that we're sending out to associations starting this month has a little bit more of historical information.
This is website information here, isn't it? And so the more we can be specific, the better, is all I'm suggesting.
Okay, and I know that it looks like we beefed this one up as well some.
Ms. Maxwell,
Yes,
would it be possible on the complaint pie chart to show those actual percentages?
sure. I mean, I can do that. It starts it out sort of like that, and then it just breaks it down. But I can do that as well and show it as actual percentages. Write that down.
Ms. Maxwell?
Huh?
Is that everything on the?
Yes, that's everything on the
Okay,
complaint.
if we could just stop right where we are now, we'll get back to your rest of your report here in a little bit, but I think. We'll keep on going then.
Now we'll start your report.
Yeah, we'll start your report again.
Okay.
Licensing statistics.
The next thing is the licensing statistics, and this is as of 10/31 of 2013. We had 24,036 individual active licensees. That's up 50 from last month. Our inactive licensees were down 46. We have 949. We have 8,257 retired licensees, which is 17 less than last month. We have 147 people in broker release, which is up 17 from last month. And those people in broker release, that number, all have E&O insurance. Otherwise, they would be in suspension. And we have a grand total of individuals in those categories, 33,389. We have, which is 4 more than last month. We have 4,070 firms, which is 6 less than last month, for a total of firms and individuals of 37,459, which is overall 2 down from the month before. If you go to the additional statistics, which is back several pages, I guess, on your iPads, you can see the historical information and the changes that have occurred from 10/31 of 2008 to the present time of 10/31/13. The individual licensees, you can see in 2008, we had 46,688, compared to the 33,904 that we have today. So there's been quite a drop-off, but the drop-off has lessened as the years have gone by, which is a good sign. The change from 10/31 of 2012 to 10/31 of 2013 for the individual licensees was 746, which is really a lot less than from, say, 2010 to 2013, which was 5,422. Just sort of trying to go through these. If you go to page 2 of the additional statistics, you can see that that shows the firms that have been closed and retired, and our total number of firms closed and retired for this year, and this is a calendar year, is 161. So we average about 16 closures a month, closures or retired firms a month this year, as opposed to last year where we averaged 19. So the closures are down, and you notice in 2011, we averaged 31 a month that were closed or retired. The next page, page 3, sets forth the applications approved and the examinations taken from 2006 to the present time, 2013. In 2006, we had an average per month exam of 1,002 people, and our average of exam takers per month right now is 391. Our average applications per month in 2006 were at 648, and the average this year in 2013 is 284. In October, we had 304 applications approved, and 430 people took the exam. The chart right below that shows the type of exams that have been taken, that were just taken from the first of the year to the end of October. And you can see that we had 2,984 affiliates that have tested and 365 brokers that have tested. So we don't have that many people who test for broker compared to the affiliate brokers. Page 4 shows the number of individual licensees lost or gained through the year 2000 to 2013, and that shows it shows how it's lessened since 2009. You can see from 2004 to 2008, we had an uptick, an increase in licensees, but the difference this year in 2013 to 2012, we've had average loss of 59 a month, which is going down each month, which is a good sign. Are you ready? Oh, let me finish this off. The next page 5 shows the total of all of our licensees that we have, which includes the affiliate brokers, brokers in timeshares, the firms, the timeshare registrations, vacation lodging, acquisition agents, and designated agents. And the total of those as of 10/31/13 was 41,100. And on page 7, this is a breakdown of number of active individual licensees by license type. And as of 10/31/2013, we had 16,085 affiliate brokers, 3,402 brokers, 3,771 principal brokers, and 776 timeshare licensees. And that will show you the difference between the 07 and 2012 as well. Are there any questions about any of that?
Is a principal broker who is responsible for 2 offices counted twice?
No,
Just once?
just once.
Okay.
May I have any questions of Ms. Maxwell about this portion of her report, all the licensing statistics? Ms. Maxwell, I think at this time we'll just stop your report again.
Okay.
And if you want to go ahead and introduce what we're having, the James Fryer, are you ready?
Yes. James Fryer and Tom, is it Magalanes? I never know how to. Magalanes, never know how to pronounce his name. They're here from Pearson View, which is one of the testing companies. Actually, Pearson View, as they can tell you, has a number of business interests. And they're here to just kind of give us an overview of the type of tests that they do, and I think the fashion in which they conduct those tests, and wanted to make just a presentation to the commission so you could learn a little bit more about Pearson VUE's business. And so I'll turn it over to them, and we appreciate their coming to do this.
Okay. Well, first off, I want to thank the commission for giving us the time to present today. I know you have a very busy agenda, and we'll try to move through this fairly, but giving you the key points. Rather than read the agenda, we just are basically here to talk about what kind of value Pearson VUE brings to a testing contract, the fact that we have a lot of experience with it, that we recognize that your clients are people waiting to be licensed, and so therefore the testing program needs to work smoothly and clearly and efficiently. Today, what our main objectives are is to talk about our test center management and our content development, to talk about how we assign a program manager to work with you and your team, and also to describe our attributes of Pearson VUE as a long-term valuable business partner. To give you an overview of the Pearson Company, we are the world's largest education, assessments, and credentialing business, doing over $9 billion worth of annual sales worldwide. Pearson PLC is headquartered in the UK, and whether you recognize it or not, probably most of the people in this room are customers of Pearson in some way. If you have people that are in or in college level, and they're using textbooks by Addison Wesley, Scott Forsman, Prentice Hall, all of those are owned by the Pearson companies. When my daughter, to make it a little personal, when my daughter was getting her credentialing to be a special ed teacher in California, she had to take a Pearson Evaluation Systems test. Who enjoys a book called Humphrey the Hamster, which is also a Pearson publication. Globally, over 8 billion exams a year in both our U.S. owned and operated test centers. We also have a number of arrangements with academic institutions. We give the GMAC exam. They wanted to make it more convenient for their clients as they're working to enter a master's of business administration programs, so we work with academic institutions as testing sites. We do a lot of IT testing with Cisco and some of the other major companies. We work with the government. We also have a number of installations with the military. We've given examinations on ships. We've given them on tanks in Afghanistan. So somebody who may be in Tennessee completes his real estate training, gets called up to duty, wants to continue the licensing process, would be able to take it in whatever country he's scheduled in.
Actually, just to continue on with what Jim already presented, Pearson VUE in itself has over 30 years' experience in the state regulatory arena. And how we define the state regulatory arena is primarily our real estate, insurance, cosmetology, contractor contracts here in the U.S. Some of the services that we provide in that particular space is electronic fingerprint services. That's to make it convenient for those particular regulatory programs that require fingerprinting as part of the background checks for licensure. So when candidates complete their examination, they can move forward with the fingerprint process immediately after receiving their score reports. We also have a variety of back office services where we develop public and private partnerships with various agencies where they elected to contract out some of their back office functions, such as call center work, I should say tier 1 call center work, as well as application screening for both new and renewal licensure processes. We have 7 company-owned test centers here in Tennessee, as well as over 35 third-party partner sites, which are primarily used in some of the rural areas that will allow candidates to get to test centers without having to travel a long distance to the test centers. And Jim will touch a little bit on the differences between our company-owned centers as well as our third-party partner sites. This slide basically tells us how many exams we administer in Tennessee. We do lots of exams for a variety of agencies in Tennessee, and I'll get into that in a few minutes. One of our longstanding partners is right here in the building with the Department of Insurance. We've been doing their exam development and administration services for over 20 years, and that has evolved over many RFPs and exercising of contract options. So we're quite proud of the partnership that we've developed with the department over the years. Yeah. So the next slide, as I mentioned, we administer many exams here in the state, and while we're not directly contracted with the agencies that are listed on the left side of the slide, we have national partnerships. For example, with the Tennessee State Boards of Nursing, they're part of they're a member board of the National Council of State Boards of Nursing. The same with the Board of Pharmacy and the Emergency Medical Services and the Social Work Board. So they're part of larger organizations, and they contract with one entity across the country. So as many of you know, the Nursing Board, we administer the NCLEX exam here in the States, and that's for students who graduate and are seeking licensure for their RN, LPN, or BSN. They go through and take their state 7 owned and operated centers here in Tennessee, and the same with the boards listed in there. Jim already mentioned that we do the test for the Graduate and Management Admission Council. Those are for students wishing to get into business grad school. The reason why we mention this is the diversity of our client base allows us to sustain our test center operating hours. So if there's a downward trend in testing in a particular industry, and I'll use real estate as an example, a few years back, as you well know, the real estate market took a pretty good hit, and testing volume across the country went down. And our test center operating hours weren't affected, and the reason for that was our ability to keep our centers open 5, 6, 7 days a week, and that's because we were able to sustain the operating hours from the other programs utilizing our centers. So for those programs who experience a downturn, their service levels aren't impacted because of the diversity of our client base. See, that's a key differentiator between that and our competitors out in the market. One example, there was a particular state where our competitors lost a large contract, and they were forced to shut their centers down because it was their primary program feeding that channel, and then there was an appraiser board that was left without a testing provider. So we were able to absorb that particular program because we had a network of test centers that were being supported by the other programs in that particular state. So we see that's key for us in moving forward with the various states across the country. Next slide. Questions before we continue on? I know we're moving fairly quickly in order to catch up on time. No? Yeah. Turn it back over to you if you can touch on the next part of the agenda.
One of the important things about us is that we have a group which we call our Centralized Capacity Management Group, which operates out of our Bloomington, Minnesota headquarters. And their goal is to make sure that we have a sufficient inventory of seats available at all times. We don't want candidates calling up and being told, oh, sure, you can take your exam in 2 months, but we don't have any seats before that. What this group does is constantly study what's going on in the centers and adds sessions and hours and seats as necessary. So if a center may only be open 4 days a week, it could go to 6 days a week. If it's open from 8 to 5, it may run from 8 in the morning till 10 p.m. One of the other things that's unique about our company is all of our field personnel that work in our centers are required to be annually certified to be a test administrator. So there's an actual manual that they need to study, they have to take an examination on it, and if they don't pass it by the second try, they are no longer a test administrator for Pearson VUE. They may work some other capacity in the company, but they will not be delivering the examinations. So what they do is we have over 300 clients. Each of them had diverse business rules. This group watches to make sure that if we know a particular event is going to occur, for example, if in the Nashville area there may be a large school that's going to have a large real estate class graduate, if they let us know in advance, we can actually work with them through our events planning group to make sure that everybody can be tested. Tom and I both mentioned the Pearson Professional Centers. When we first got into the testing business quite a few years ago, our first client was the exam. They were going to go from paper and pencil to computer. And so what we did was we worked with them, we worked with architects, we worked with focus groups to determine what would be the ideal testing situation. We actually built 5 prototypes and tried them all out and ultimately arrived at what is currently called the Pearson Professional Center. It's 100% owned and operated by Pearson VUE. We control it in all ways. We've patented the test design. And in a moment, you can see down in the right-hand corner, there are people that are taking the examinations at in the sense that our dividers between stations actually go for 18 inches. And we control all of that. As we said before, the proctors are certified. We have a constant monitoring and quality control of both the proctors and what goes on in the center. We have very secure technology that we use. We have a controlled access server room where the examinations are downloaded in the morning before they're given. That is surrounded. No one in the center has access to it. Only our Bloomington technology team has access to it. And it's surrounded, the entire unit is surrounded in concrete, so no one could be, if it's a 2-story office building, upstairs at night trying to break in and steal our questions or the question banks that have been developed. We use biometrics for check-in. We actually have 3 forms. We do a digital signature. Every person is required to graph, which becomes part of the score report. And we also have palm vein technology. Some people, we used to do the fingerprint finger, but some people were concerned that we would be keeping their fingerprint, and they were concerned. Palm vein is very different in the sense it's less invasive, but everybody has a different palm vein marking. And so this machine actually records it, both hands, and then if you would go out to the laboratory while you're taking your test, you send your identical twin back in the same outfit or style of outfit that you were wearing, the palm vein would be able to pick up that it's a different person because their palm vein print would be different. Also, you notice in the right-hand corner that little round object, that is a digital audio and visual surveillance camera. Testing stations in the room, and it's fixed. It's constantly watching those 2 stations. Some of our competitors use ones that scan the room, but we actually keep people on camera the entire time they're being tested. Tom has mentioned the supplemental third-party test center network. They are required to meet our VUE standards, but they have our full confidence and trust. We do a lot of things to make sure that they deliver the exams the way we want, including secret shopping. And they actually agree to follow all of our rules if they want to be at one of our centers.
If I can just add regarding the security cameras, we have both digital and audio, so we're able to monitor the activity above every 2 testing stations that Jim had indicated. We actually keep those videos for a minimum of 30 days. And the reason why we do that, if there is an incident involving a candidate and you as the commission need to investigate and either press charges or continue an investigation for an incident at the test center that could involve potentially issuing or denying licensure for a candidate, we're able to pull that video provided to you to assist in your investigation. So we see that as critical. And the other thing with the palm vein, we actually do the palm vein for 2 reasons. One is, as Jim mentioned, prevent proxy test takers. 2 is the palm vein there's a blood vessel pattern that each individual has that's very unique. So that palm vein scan is done at the point of check-in, and that each time the candidate has to enter or exit the testing room for whatever reason, that palm vein is scanned again. Again, it's the unique aspect, and one of the key things that we do is from a security standpoint, because we do understand that we're affecting the credibility of the various boards that we're representing and protecting the liability of the profession.
Yeah. And one thing I neglected to mention is in every one of our Pearson Professional Centers, we also refresh the hardware every 3 years, which we just completed last year, and we increased the screen size from 19 inches to 24 taking their examination. Now, where are the Pearson Professional Center locations? Well, we have 7 of them in your state, including 2 in Memphis. 1 is in Midtown, 1 is sort of on the outskirts of the town, and as we all know, Brentwood is near Nashville, so we have centers here. The 2 pictures show you the entrance area, which is unique to Pearson, and it's the patented design, but it's not unique in the sense that every one of those Pearson Professional Centers look the same. slightly arranged differently based on the office space and the number of testing stations. But everybody comes in, they go to that unit in the top picture where they would sign in with the administrator. We always have 2 people on duty in a Pearson Professional Center, one who acts as the person who receives you, and we also have 1 person who sits in the little booth in the second picture, which is the actual proctor, and that person, as you can see, is right in the room, surrounded by soundproof glass, so they're not disturbing them. And they're also not only able to see them visually, but they have a television screen, again, which is, I believe, 26 inches, that shows all of the stations as they're being videoed. We also provide web registration and call center registration. Our web scheduling is available 24/7. We have a View-managed call center, which is about half a mile from our main headquarters in Bloomington, Minnesota. It's available 7 days a week, and each of the representatives in the call center would have an online real estate commission program specific information, so that any of your rules, if they would be changing, it's totally real time and online. We could update them at any moment. And the person, if they had any questions, maybe it wasn't a frequently answered question, still has all the basic rules, complicated rules, so that they can answer questions of your candidates. Our real estate exams are based on our National Job Task Analysis, which we conduct every 5 years. The most recent one was completed earlier. State-specific items, we'd obviously work with your state subject matter experts. Can be commissioners, can be staff, can be people that you recommend, that you feel comfortable with, that would be able to help us develop questions which are reliable and valid. We have a psychometric staff which looks at all aspects of the statistics of testing. We currently have 13 PhD level psychometrics. Allow the state to be as involved as much as you want to be. Some of our clients are kind of hands-off. They are rather into the compliance part of the role rather than in the testing role, but they know testing has to be done. We have other departments where many of the staff and the committee actually participate when we have the annual content development meetings. And as I just said, we do it annually with our clients, and because of the large staff of content developers and psychometricians we have, we don't have to use subcontractors. By people that are employed by Pearson VUE. Our program management tends to be kind of unique to our company. Every client is assigned a program manager. That person works with teams back in the regulatory office, which is in Bala Cynwyd, Pennsylvania, which is right outside of Philadelphia. And they work with people to make sure that every aspect of your program is taken care of. So they would develop the business rules, they would meet with the internal staff and let people know what needs to be done. They are the oversight. Everybody sort of reports into them for the program. And as you can see, there's many different areas: candidate services, call center, issue escalation of something, we have an incident in the center, it's written up in our proprietary system, which we call VSS, the VUE Support System. And the program manager would be able to contact your staff and say, this is the incident we had at the Chattanooga Center, we want you to be aware of it, and here's how we're investigating it. We also have client support on many levels. Our executive team remains involved. We have a program coordinator who is very up in our call center on what would go on with your rules. And on the other side, we have our IT team, so that if you need a specific type of report delivered to you electronically after each testing day, they'll it with your system to make sure that it works. And all these people work through the program manager who's assigned to the program. So that person, if we would win the contract, will develop a project plan with your input to implement the program. They'll manage every aspect of the implementation to make sure that it's up and running when it needs to be. And they are the person that is responsible for assuring that the client, you, would receive superior service throughout the contract. We're very proud that we have a state regulatory market team that has, for the most part, 15 years of experience for each of the individuals. Okay.
Just a quick snapshot. Pearson VUE is certainly we're big. We're financially viable. Pearson itself is constantly reinvesting in our business, in our people, our products. I personally have been with the company since 1992, so I've seen the industry evolve significantly over the years. And things that come to mind. One is our Pearson Professional Centers that I invite each of you to take the time to visit at any of the 7 locations. So if you choose to do so, please just communicate through Eve and Steve McDonald, because I do authorization letter issued to anybody who visits our centers, and that goes for anybody, even the president of our company. If he's not pre-authorized and goes in letter, nobody is denied, nobody's granted access to the test center without that authorization letter, and there's only a few individuals within the company are authorized to issue that letter. Fortunately, I'm one of them, so that's one piece. So you'll get a feel of what the candidates are going to experience when they go into our second piece, and I'll end it here to give time back to the commission. Is one of the things that I'm proud about with Pearson VUE, and for me personally, is we understand that we have an impact on somebody's livelihood. The impact here would be obvious. So it's imperative that we create a professional testing environment, which we'll see by our centers. The second piece is making sure, and this is where our capacity management group come into play, and that's to ensure that we have a sufficient inventory of seats for candidates to schedule their exam, go in and take the test. Those are the 2 key impacts that I believe that we bring to Anybody have any questions before we conclude? Yes.
So it's been a long time since I've had to take one of these tests, but I occasionally hear of real estate schools that teach to help you pass the test, as if they know what the questions are. Is it possible? Do they get candidates to bring back 2 test questions from the test, and how do you protect against that?
That's a very good question, and there are schools across all professions that try to do that. We have a series of security officers that do what we call data forensics. So we're able to capture how much time an individual spends on a question, how much time they spend on clicking back and forth. So all that information is collected. So when you click your mouse to and from, we're able to detect how long you're spending on a question. So we can actually see a pattern on an individual and as they go in and what their behaviors are on a test. So our data forensics analysis will go in and we'll be able to identify and report back to the commission that specific candidates are spending time on just a series of questions, and that's what we detect as proxy test takers. So that's a very good question, because this is a very serious concern for us and also all of our sponsors to protect the intellectual property and the profession. So there are schools that try to teach to the exam, and we try to protect against that based on the what we do with our data.
So good that you can tell which schools?
If there are, if part of your process, we could identify the schools depending on what the individuals are. So we will be able to report back to you the individuals. I'll tell you a story what happened, and this was over in, I believe it was South Korea. And that's the nurses exam is now administered globally through and Pearson Professional Centers are also available globally. There was a school that was sending proxy test takers in, and these individuals were going in and trying to identify a series of questions and go back and report into schools. So we actually were able to set up cameras outside the test center and actually follow the individuals, and they actually set up an office right across from our test center. So we're able to do that. But to answer your questions, we could identify the school, we could identify the candidate, so we would be able to go back and track where he or she was, what school they were affiliated with. Okay? All right.
Do y'all offer any type of training mechanism for the test through all your publications for any particular test?
Well, there could be certain Pearson companies that publish real estate materials.
Or study for the test?
For study, but they're not affiliated with Pearson VUE, okay? We do draw the line between training and testing. That is certainly taboo, but Pearson itself could publish real estate materials. I can't be certain. My guess is we do publish some sort of publications into the real estate market, but we're not affiliated with that Pearson division, nor do we get involved with training materials. Now, we do offer a practice exam, so it's a little bit different, but we're not affiliated with any training materials or aids that would assist a candidate in
Are the questions pulled from a database that constantly changes, or is the exam always the same?
Exam is different. We do develop test forms. The items are scrambled, so if you and Commissioner Bloom, I hope I'm saying your name correctly, if you're seated next to each other in a center and you're both taking test form A and looking at question 6, it's a different question because the items are scrambled within the test form.
Any commissioners have any more questions of either Mr. Fryer or Mr. View?
Are you willing to add any
What's your
testing?
What's your name?
Tom Megalanis.
Tom Megalitis. Okay, Tom.
Close to you, it's close to you.
Are you
Yeah, Mr. View,
open to opening other test centers in Tennessee if we needed more?
We are. We do that capacity analysis on an ongoing basis, and if we see that volume is beginning to increase, we will certainly build centers. We actually add centers every year depending on demand and where the population is, but we will certainly open up centers to meet the Thank you for your time. I appreciate it, and
Thank you for
Great.
coming and presenting this very pertinent information that we all need to know. Ms. Maxwell, do you have anything to
No,
add?
I
or-
appreciate y'all coming in. I mean, I think that was very informative. You know, I think it's great to know.
Where'd you two come in from?
Philadelphia.
Okay.
Brotherly love.
So
Yes.
brotherly love. We talk a little bit funny, don't we?
Yeah.
No, we do.
Arrange this trip where you could go to the CMA boards.
I'll tell you what, I wish I was staying down there, but you wouldn't believe I was telling Steve earlier, the hotel rates more than triple
Yeah.
for tonight than they were last night.
Just for people coming from Philadelphia.
That's right. They saw we were coming up. They don't want us up here. Great. Thank you for your time. I appreciate it.
They said it was because.
Thank you. I appreciate it. Thanks for your time.
I'm sorry, but we fixed it. The boys
We
were,
got through.
the boys were over at the food court at the farmer's market. They had to run back over here.
Okay, I'll be shut down in just a second. I'll be out of your way.
Back on. Kelly, you giving us some lights back?
Does anybody mind hitting the lights in they're by the door there?
Why?
Oh, there it is.
Okay. Now, Ms. Kelly, are we on?
Yes.
Okay.
I never turned it off. Carry on. And our, I can't.
All day?
Yes.
The next thing
all
that
day.
I'm about to wake up.
Even when you turn the lights off, that one stays on.
is Marilyn Anderson, an applicant. We have two informal applicant appearances. And the first one is Marilyn Anderson, the applicant, and her principal broker, Scott Crandall. Are you two here? If you two would come on up and have a seat. I want to remind you to when you talk, lean forward and pull that microphone down and talk right into it. And at this time, I'm going to turn things over to Miss Maxwell or Julie. Julie, you go. You gonna swear him in?
I'll swear him in, yeah. Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
I do.
Thank you.
I'm just going to give kind of a brief overview of what you had disclosed to us and then let you answer some questions that the commission might have of you and your principal broker. Marlene, is it Marlene?
Marlene, yes.
Ms. Marlene Anderson is here today. She would like to be an affiliate broker. She had not tested when she turned her information into us. I don't know if that's still the case or not.
I have tested
You
since
have
then.
tested. So she is tested for affiliate broker. She's here with her principal broker, who is Mr. Scott Crandall. He is the principal broker of North Star Realty and Management, DBA Remax of Clarksville. He has had no complaints against him. He was first licensed on 1/6 of 1999, and he became a broker on 10/25 of 2005. The applicant, Ms. Anderson, has disclosed one conviction for theft of government property, and that occurred on 10/17 of 2003. At the time of the occurrence, Ms. Anderson was 23 years old, and she has just said that she was a young wife and mother, and she went into the PX at Fort Campbell and stole some items. Specifically, I believe it was Halloween candy she was going to give out to some trick-or-treaters, and some chapstick or just some other personal items. She was caught as she was leaving, and so she returned all the goods without ever getting beyond the PX with those. It was the first and only time she had ever been in trouble. When she appeared in court, she was given 6 months of probation and a fine of $250, and she needed to participate in a community health program. She then started working again, and she got certified as a nurse assistant, but she passed the test but couldn't get certified because she had not been off probation long enough. She has now been off probation since 2004, so she's been off a long time at this point in time. And she has done a lot of volunteer work, she said, about the base, helps wives, I think, whose husbands are deployed for long periods of time, and it sounds as if she's devoted a lot of time to that. And that's the only item that she's disclosed to us. And I'll let you fill in the blanks.
Just in your own words, just tell us what you have done since, I mean, I know she's alluded in this letter that you have written to all of us that's part of this record. But just tell us why you want to get your real estate license and what you've been doing since all of this happened, and just in your own words, just to tell us about everything.
Well, it's been 10 years, and I think it's been a little too long for me to just sit around and not do anything with my life. So I would like to start a career. I've been a stay-at-home mom for 10 years. I've done a lot of volunteer work, but I would like to contribute to the family financially and set a good example for my daughter. 10 years ago, I set a terrible example, so I would like to make up for that and be given the chance to do so.
Your husband in the military?
Yes, he is.
Okay.
He's active duty.
Have any questions of Ms. Anderson before we hear from her principal broker, Scott Crandall? Scott, tell us a little bit about your company and how you're going to be able to train Ms. Anderson if this commission votes to allow her to get her license and come to work for you.
Sure. Our company, we're small. We're at 19 agents, I believe. Myself, I'm retired military, actually from the same unit her husband's in. My partner's retired military. Most of my people have some military affiliation. We're located right outside the gates of Fort Campbell. We're very small, very family-oriented, and I work with my new agents daily, and that's my job, and that's what I like to do. I'm a trainer.
Pull your microphone down.
I make a motion we approve.
I have just one question. So, Ms. Anderson, will you be licensed in Kentucky and Tennessee?
Just Tennessee.
Is your firm licensed in Kentucky and Tennessee?
I'm in both, yes, sir.
Do you have a requirement that your agents be licensed in both states?
I do not have a requirement. However, if they opt not to be licensed in Kentucky, they don't cross the line.
I'll second.
We have a motion by Commissioner Collins and seconded by Commissioner DeShar that we approve this application and allow Ms. Anderson to, she's already taken her test, haven't you?
Yes, I
She's already
did.
taken her test, but
Yes.
we allow her to become active in this industry and start a new career in her life.
Thank you.
Any questions or discussions on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion passes unanimously.
Thank you.
Good luck.
Thank you very much.
Thank you.
And as David Flitcroft, who is not here today, he likes to say, if she comes back, you come back, Mr. Scott. So you just train her well.
Outstanding. Thank you.
Thank you.
Thank you. Next, we have Scott Stumbo, the applicant, and his principal broker, Terry Hollingsworth Rutherford. If you two are here, come on up. You've seen the drill. Miss Kropp will swear you in, and Miss Kropp, just stand up. Don't sit down yet. Stand up and raise your hand.
All right. Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. Okay, thank you.
Mr. Stumbo is here today with his principal broker, Terry Hollingsworth Rutherford. Ms. Rutherford has had no complaints against her. She was first licensed on 6/14 of 1999, and she became a broker on 1/5 of 2011. Mr. Stumbo has tested for affiliate broker and has disclosed to the commission that he has a conviction, a misdemeanor conviction, distributing obscene material to a minor. This conviction was handed down in 2008. I believe the event occurred in 2005, and it was reported in 2006. He was suspended he was given 6 months in jail, but it was suspended to 2 years probation and was given a $139 fine and cost. Could not have contact with the victim's family, and his teaching certificate in the state of Kentucky was revoked. So that's why he's appearing before the commission today for those reasons. Mr. Stumbo states that he was a teacher, and in September of 2005, I believe, 3 girls accused him of sexual harassment. They were all in a class that he taught in high school. One girl accused him of giving her a typed pornographic letter of a dream. And then another girl had said that the applicant had engaged in lewd conversations with him over lunch or during classroom time. The evidence, Mr. Stumbo says, showed his fingerprints on nothing. It wasn't on the letter. They couldn't find evidence of his that letter being on any computer to which he had access. There were no witnesses to any of the allegations, but 1 week into the investigation, the state police arrested him and charged him with these charges. The investigation progressed. In November of 2007, Mr. Stumbo was diagnosed with leukemia, and his trial was scheduled to begin in January of 2008. Shortly after he had finished chemo treatment and was still undergoing some additional treatment for his leukemia. He chose during the hearing to take the Alfred plea, which is a best interest plea, and he can explain exactly what that is, but he took that on the advice of his doctors and his counsel. The judge then, with that plea, basically said that he was guilty as charged, and he was then, as I say, given 6 months, which was suspended to 2 years of probation, and lost his teaching. I think that's kind of a short summary of what occurred.
If you could, in your own words, Mr. Stumbo, just tell the commission about, in your own words, just what transpired and what you've been doing and why you want to get a real estate license.
Well, a girl in my class accused me of handing her a letter off my printer in my classroom, and I got to read that letter later, but it was a pornographic type material. When the state police came to my house and arrested me, they had asked me if they run the fingerprints on this letter, whether or not my fingerprints would be on it, and I said no. And so they sent that off to the forensics department in the state of Kentucky, and it came back showing my fingerprints weren't on the letter. 5 different sets of fingerprints were on the letter. All of them were undetermined who they were, but mine were not on them. I maintained my innocence the whole time. The investigation by the Board of Education in Shelby County, the investigator never talked to me one time before they made the decision to basically fire me from my teaching position there in Shelby County. I went through the process. It was a long process. It went over a year before the court proceedings was going to happen. Well, I came down with leukemia in November, the first part of November of 2007. Spent 6 weeks in the hospital, went through chemotherapy, and probably nearly lost my life around Thanksgiving. Was in critical care for about a week. But getting out of that and spending the 6 weeks there, I got out just before Christmas. My scheduled appearance was in early January. Under the advice of my KEA lawyers, Kentucky Education Association, that I was provided, and my doctors, the prosecution came to us and asked if we wanted to make an Alford plea, which was maintaining my innocence. And I didn't really, I guess, understand truly the ramifications of that, because that's like making a guilty plea. The only thing that got me out of was not going to court and having my day in court. Looking back at it retrospectively, I would have gone to court and fought this in court and proved my innocence. But because I made that Alford plea, I was told by my KEA lawyers that that wouldn't affect my teaching certificate in any way. I found out that was an automatic suspension. I appealed that. We had a court hearing with a hearing officer in the state of Kentucky. Went through kind of a mini trial with that. The hearing officer had made recommendations in favor of me. She took that to the 7-member board, I think, in the state of Kentucky. I think it's 7. But for whatever reasons, they went against her ruling or what she thought was correct, and made their own decision, and that canceled my teaching certificate permanently. Since then, I've been doing construction and remodeling. I actually came down with leukemia again in 2009, 2 years after that. I spent another 6 weeks in the hospital, went through a bone marrow transplant down here at Vanderbilt in May of 2010. And so right now I'm currently cancer-free, but I'm looking to try to start back a career again. And real estate, I've known Terry, and Deanne that's back there in the back is been in real estate for 30 years. I just thought this was an area with my background in construction and remodeling that this would be a good fit for me.
Okay. Does anybody have any questions of Mr. Stumbo?
How'd you get to Thompson Station?
Yes, I do.
I say, how did you get from Kentucky? Where were you in Kentucky?
I was in Louisville, Kentucky at the time, and then my parents, when I got the leukemia, I moved down to Bowling Green with them, so I was out of Bowling Green, Kentucky. Since then, I've met Deanne, who lives in Nashville here. So after my bone marrow transplant, basically that's how I got down here to Nashville.
Do I have any other questions, Mr. Stumbo, before we hear from our principal broker, Ms. Hollingsworth Rutherford?
Mr. Stumbo, I know it's not easy to come to a commission meeting like this and state the case, but do you expect you're going to have the same issues with customers and clients?
Absolutely not.
I don't mean that you're going to be charged with things, but if somebody says, I hear back in your past you had this issue, how do you handle that? Have you thought through that?
Well, I explained to them just like I explained to you. I was accused of something that I didn't do. There was no witnesses to anything that they produced. I really do believe the prosecution came and offered me an Alford plea so they wouldn't have to go to trial. And if I'd have had the proper KEA representation, I really feel like I wasn't given the right information that I needed to have, that I would have gone through that and fought that.
If some client or customer says, "Hey, I am uncomfortable with your history, regardless of whether it's right or not," can you live with that? I mean, you're going to get upset with those people? Or
No,
what do you
I
see
would be
happen?
polite and say, you feel free to go work with anybody else you need to work with.
And that's a question for the broker, too, at some
Right.
point I'd like to get to. That's all I had. Thank you.
Okay.
I have a question. Did, during this investigation, did they ever check your hard drive on your computer or anything?
They took my daughter's iPods, they took my computer, they took every electronic device I had in my house and checked everything. Checked the school computer, they ran it, Kentucky Forensics, and never found the letter on anything that I had.
How do you think you got there? Just somebody?
Grover,
Yes.
talk.
How do you think somebody just,
Well, somebody's produced this letter somewhere else and then turned that into the principals, how it happened. So, but she said it was off my computer in my room, so I don't know. It couldn't have been off my computer in my room because they looked at my computer and looked at everything in the school or at my personal residence also.
thank you.
Ms. am I spelling that word? Hollingsworth Rutherford?
You can just say Rutherford.
Ms. Rutherford,
It's a
okay.
mouthful, I promise you.
Miss Terry.
Yes, it'll work.
Just tell us about your company and what kind of mentoring program you're going to have for Mr. Stumbo if his commission votes to allow him to get a license. Just tell us a little bit about your company and how many agents you have and everything.
We are a RE/MAX office, RE/MAX Fine Homes in Brentwood. We're getting ready to open a Spring Hill location, and we've been in business 2.5, almost 3 years. I've been with RE/MAX since 1993. Ventured out to open an office that I could kind of do my own thing with. We're a charitable office. We donate with every house that we sell. So whenever my agents sell a house, I make a donation to a charity for their client out of our proceeds because we feel the need to give back. We are an office of about 52, 53 agents. I think we signed on a couple last week. We are a lot of seasoned, experienced agents, if you will. We have very few new affiliate agents who are just newly licensed. And we only sign on agents that we feel, fits the bill for our office or has what it takes to be a successful agent. Scott is going to team up with Deanne Cutoff, and she's been in the business over 30 years. So along with her mentoring and our mentoring there at the office, we wholeheartedly support him 110%. I believe that he was unwrongfully accused and that he deserves to start a business in real estate. As an office, we'll support him and do whatever we need to do to guide him along the way as we do any of our new affiliates.
Anybody have any questions, Ms. Rutherford?
Go ahead, I don't have a question, I was gonna make a motion.
Did I understand you to say you're fixing to open an office in Spring Hill or already open one?
We are going to open it next week.
And Mr. Stumbo, where are you gonna be?
I'm going to be out of the Brentwood office.
Okay.
Okay, Ms. Rutherford, so I pose the same question to you. If a client or customer is uncomfortable with Scott because of his past history, correct or incorrectly, what's your position at that point, with as far as the customer or client's concerned?
I think for any of the customers that my affiliates work with, if they had a problem with any of my agents, I would suggest the agent terminate their buyer's agreement or their listing agreement with them and have them work with somebody else in the office. I will even work with them if they want to stay with the RE/MAX concept, but I don't think anybody should be forced to work with anybody they're not comfortable with under these circumstances or any circumstances.
If somebody says, I'm uncomfortable with Scott, but I want to stay in the concept, I want to stay with RE/MAX, you're okay with that?
Absolutely.
Scott says he's okay with it.
I've had it before, and I've taken on clients for an agent in my office that couldn't handle the client or they didn't want to work with them before or again.
I make a motion, we approve Mr. Stumbo to move forward in his real estate career.
I have a motion by Commissioner DeShara to approve this application. Do I hear a second?
Second.
I have a second by Commissioner Bloom. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Go forth and do well and make this industry proud.
Thank you all very much.
Good luck.
Thank you.
Next on our agenda, we have, and they have just entered the room, just a perfect timing, Commissioner Giannini and Kimberly Whaley. And at this time, I'm going to give you the floor.
Good afternoon, Chairman, Commissioners. Hope you all are well. Sorry that I didn't get to hear the first half of your meeting. But one of the things that I know that some of you probably are aware that we have talked about doing, and we're finally doing that, is annually coming before you and discussing your financial state. We've just gotten our budget closed for the past year. You should have a copy of this on your iPads, and I think you also have a paper copy. Is that correct? I have paper. If anyone would like a paper copy, we have those available for you. So, but we feel like it's important that you understand what we are doing with your licensees' money, and that we are spending it wisely. Has everybody got a copy of the budget close in front of them? All right, I'm going to try to run through this. At any point that you have questions, feel free to stop and ask. And if you don't, I'll certainly leave time at the end. If you'll notice at the top, you've got regular salaries and wages. You see at the last column is fiscal year 12 and 13, the year we just ended. Your total salary and wages was $542,748. You can look back at the previous 3 years to see the trends of where we're at. It's down substantially from the previous 3 years. In part, I would like to claim that it's all to our staff's great management, but it is in part that we did have some staff vacancies over the course of the year. I would also point out that that includes a 1.5% raise that was given across the board last July. So, and then if you drop down to the bottom of that with travel, you see $71,728, again down substantially from the year before. And that is directly as a result of us leasing cars rather than doing mileage, which historically we had done, and also the lack of several vacant auditor positions for part of the year. And I'm going to fast forward down to the bottom of your expenses to grand total. You can see that 12 and 13, it was $1,216,231. Again, down substantially from the previous 3 years. You'll notice if there's any, the one that may jump out at you at the top is third-party professional administrative services, and that $21,000 of that number is in temp fees and for changes in the way that the F&A assigns certain monies to certain things. I will then take you down to total expenditures. You can see is $1,695,814, and again down substantially from the previous year. And I think it's even more remarkable to look back at year 9-10 where it was $2,228,718. I don't have to tell you all that you had a substantial decline in licensees over the past 5 years. I do think, and the next number we're going to talk about shows your licensing revenue. I think we are finally seeing a planing out of your license pool, and I believe this is probably the new norm. If you look at your licensing revenue, it was $2,253,258. For fiscal year 11-12, it was $2,223,277. Fiscal year 10 and 11 was $2,373,613. So you can see that, and then again, go ahead while we're here and talk about 9 and 10, it was $2,596,000. So we've gone from $2.6 million down to $2.25 million. So that's a substantial decrease in revenue. However, we're up from the previous year, so that's a good trend. We hope that we see that again this coming year. Something else that we're doing that has not been done in the past was to pull out your complaint revenue. That's money that you all receive from consent orders and for licensee discipline. That number is $38,873. In previous years, that number was just incorporated into your licensing revenue. We will continue to pull that out so you can see what sort of revenue you receive from that. Fiscal year balance for the year, fiscal year 12 and 13 ended at $382,236 in the black. That puts your fiscal reserve to $2,987,247. You have now a total of 27,926 licensees. I think at some point you were in the 40,000 range of licensees. Matter of fact, Kimberly has it right here in front of me. I should have known. 2010, 31,936. 2011, 29,309. 2012, 28,119. So you can see the trend there. I wanted to talk to you also, tell you while we're here about your Education and Recovery Fund. You finished the year $45,663 positive, which puts your balance at $109,238. Balance is $3,856,168. Before I go on, any questions about the budget close? I should have known.
Oh, are those balances, are they restricted?
They are.
Could you just maybe, not the recovery fund, but the operating budget, those balances?
Right.
2.9 million, say 3 million.
It is restricted. I can tell you that we have recently, because one of the things that we're going to talk about that we're doing is the purchasing of a new licensing system. We have talked about, and since I've been here since 2011, we were always under the impression that those reserves were entirely untouchable. We have found out, and I don't want to be held completely yet because we are still in ongoing discussions about this, but we do believe now that we will be able, there's a provision that would allow for us to use some of that money to actually pay for the licensing system. We had been told up until very, very recently that we were going to have to pay for the licensing system with new money over 5 years, which really seems crazy when you've got $3 million in the bank. We do believe now that we found a provision that would allow that. I would say to the board, of course, I don't think anybody thinks that it's a good idea to have $3 million sitting in an account that you can't do anything with. The first thing that we would hope to have you at least talk about is your licensing fees. However, I think that in the previous 5 years, with the market conditions, the way they have been, and unpredictable, I think that it was probably the responsible thing for the commission to continue business as usual until we see that the economy planes out and that, agents are either not continuing to bail out or start to come back in. So, but I think that the way to reduce that fee, or the only way to get a handle on that reserve fee, absent some statutory change by the legislature, would be to look at your licensing fees.
You think it's any way possible for us to use that $3 million to develop a in-house state training school for realtors, kind of like Alabama does, and man it and pay for it out of that, or set up a relationship with some like Memphis or Middle Tennessee or Knoxville to have a training area explicit for real estate, like a chair of insurance, some schools?
Commissioner, I would say with the legislature, nothing's impossible. But I do think that it would require a change in the statute to be able to do that at this time, and that would go for all of the boards, unless it's explicitly noted in the statute that we can use money. We don't have that ability. Now, you may be able to use the Education and Recovery Fund for something of that nature.
Anybody have any other questions for Mr.
I'm still
Giannini?
curious about that $3 million.
Yes, sir. Me
Can,
too.
can any other part of Tennessee government come and just take that fund and use it for something else?
I know that at some point, in was it 2008? 2008,
Swept it?
that they swept the funds across all of our regulatory boards.
And just to make sure, both funds are almost at,
If you
both
would,
funds are almost at $3 million, so just to make sure which one we're discussing, are you talking about the education recovery or your main account?
I didn't hear you.
Are you, when you say $3 million, both of your accounts are almost at $3 million? So are you referring to the
I'm talking about the reserve account for
the education recovery or the main account?
recovery.
Okay. I just want to make sure when if we ask questions later that we,
Yeah, because
We
the
properly
earlier question,
answer.
I was referring to the main account.
I'm as well. So back, when did they sweep that account? 2008, is it? But was it down to zero and it's built back up to this number?
I took half of it, didn't they have 7 million?
They didn't take, right, I don't think that they completely swept it.
we had about close to $7 million, you're right, Commissioner Collins, and I think it was $4.5 million that they took. Somewhere in that figure, in that range.
Thank you.
We can't get it back because they spent it.
Well, it's interesting, because every time I go over to the legislature, somebody says, we took it. I don't know how that happened. I think it would be a healthy discussion for the board to have, you know, how they would, and certainly to approach your legislators about that.
Thing about it, as this surplus continues to grow, somebody's going to want it.
They'll take it again.
They'll take it again.
Why don't they take it all if there's nothing we can do with it?
Commissioner, I can't answer that question. I wasn't here when they wrote the law. I've scratched my head and had more conversations with this about legislators than I can count on my hands and feet. So I don't understand it. I can tell you that I do think that there is a will, at least among some legislators, to have a discussion about that money and what we are doing. I certainly think, you know, again, restating that the board can look at license fees, look at what we're taking in. I can tell you that your administrative staff is doing a fantastic job of managing the money that we do have, and we are going to continue to do that. As you can see by these numbers, they have reacted to the decline in your licensing revenue, and they've done so by making cuts where needed without having to raise license fees.
The other commissions pay their way.
All of them.
All of them are self-sustaining.
Sorry?
All of them are self-sustaining.
Yes, sir.
At one time, there was an idea of using some of this money to help with legal aid. And I guess that would have to be done through the legislature. But I remember that coming up several years ago, so people would have an avenue if they had. I know we've had several folks come before this commission that unlicensed activity, and the public has been greatly taken advantage of. And I don't know if that's of or not, but it could benefit the public from particularly unlicensed activity.
Well, and let me say, I don't think that when the legislature set the statutes up for our programs the way that they did, that they envisioned that we would stockpile cash. I think what we are required to do is to be self-sufficient. We are required to make sure that the money that you raise from your licensees pays for your operation and is not substantially, that the fees associated for those licenses isn't substantially more than it costs to run your operation. I will say again, I think given the fact that you had a probably unprecedented drop in licensees of any regulatory program in the history of regulatory programs, with the decline in the number of licensees, it was probably the fiscally responsible thing to do to wait, because I can tell you, certainly there were years where I wasn't sure if this was the worst year we were going to have or not, both as a assistant commissioner and as a business person working in the private sector. I do think that this year shows, hopefully, that this is the beginning of a new trend back up, however modestly, and that maybe it is a good time to have that discussion. But the legislature does not want us to continue. I think at some point I can tell you, if market conditions are such that things look to be planning out, there's going to be a question in the legislature, why do you have $3 million in this reserve fund? And why have you not lowered your license fees? That will be the logical question.
What latitude does this commission have to control its expenses? I mean, I can reduce reserves by increasing expenses, like additional programs, pay more rent to the state, whatever. Do we have some latitude there?
Certainly, the Tennessee Real Estate Commission has latitude to expand things that directly relate to the regulation of the licensees. Without giving a little more detail, I'm a little reluctant to say yes or no.
I understand. I'm just looking for
right
some recourse to that money.
Commissioner, I'm probably the newest one here.
Hello, Mr. Bloom.
Good to meet you, sir.
Good to meet you. Welcome.
Thank you.
Fellow Memphian.
Yes, thank you. I have no clue what my responsibility is to the staff here or my authority over the staff.
The Real Estate Commission is, your primary responsibility as a commissioner, as a board, is to regulate and implement the policies regarding the profession and the professional things to do with the practice of selling real estate. From the administrative side, those responsibilities are the responsibility of the administration and the Commissioner of Commerce and Insurance, and by delegation, my office, from the day-to-day administration.
Yusuf, while we're there, and I agree with you except one thing.
Uh-oh.
And if I read the manual right, it says that this commission sets the executive secretary's salary. And that's been denied every time.
Okay, let's clarify that. The executive director first, not the secretary, correct? Okay, make sure we're talking about the same person.
That's right.
The commission does set the salary. However, the commission sets the salary, which has to be approved and conform with statewide policies, which is ultimately determined by the Department of Finance and Administration. And that is where each time that an increase in the salary has not been approved, that has occurred. Yes, sir. You don't look like you're... Okay. I think, and I actually submitted some information someone requested regarding pay raises for the executive director over the past 4 years, and I think that information was presented to you at the last meeting, which I was not able to attend. Is that correct?
That is correct, and I have that information in my car. In the my car in the parking garage at the Sheraton is where that information is, and I didn't get my black folder.
The information about what?
Hope it doesn't
What she
rain.
made, her raises.
I think we got it on our emails as well.
Move to recall the chairman.
Not from the chairman, but I think from you.
I've seen that. I disagree with that, but nevertheless, that's all I got to say about today.
Thank you, Commissioner.
Well, the fact that our executive director works twice as many hours as the other directors, does that not help? Can we not?
I'm going to take the fifth on that.
Mr. Giannini?
Yes, sir, Mr.
A lot of states, when a new commissioner comes in, there's a school Arello offers.
Yes, sir.
And we've been hampered by not letting our commission go to these conventions for training. And I think it'd be very important if our commissioners, especially the new ones, were afforded that opportunity to know their responsibilities and duties of being a commissioner. I just want to throw that out. Heretofore, it's been stopped because the state would only let maybe 2 people go or 3, but we could use that $3 million fund that's supposed to be for education, which would be educating the commissioners, looked like to me. I'm from the country, I don't know much.
Yeah, because our recovery fund, it's 3 million, which one is it, John? What's the balance in our recovery fund? Is it 3.6?
3.8.
3.8 million. The interest off of that, I don't, just give you an example. Under the Sundquist administration, as many people that wanted to go to Arello, as many of the commissioners, we had 9 then, we got 9 now, but as many of the commissioners wanted to go, they ain't having a problem with as many as they wanted to go. But subsequent administrations have changed that policy, even though we've got plenty of money to pay to send commissioners to these Arello meetings, which are invaluable information for this state to interact with commissioners from all across not only America, but Canada and about 45 other foreign countries as to how they're doing things and ideas that we can bring back to this commission here in Tennessee. Just want to let you know how things have been handled in the past and how they're handled now.
I apologize. I can't hear in my left ear, so when she's talking to me and you're talking, I mean, it sounds crazy. So.
You want me to go over that again?
No, I heard you. I think I heard the important parts. Let me first say, okay, I am very much in favor of the commissioners being able to attend anything educational that you think will benefit the licensees. Very much so. I very much agree that if we can justify having the Education and Recovery Fund pay for that, it's a great use of the money. I think that because we don't get to talk every month and because we don't have ongoing dialogue, I think there's probably some misconceptions about when we have in the past denied travel, especially as long as I've been here. I can tell you that the thinking was, and when we budget you the year for the coming year, we budget on the previous year's numbers. That has been very challenging in the environment that we've been in. There was a point this past year where we were very fearful that you were going to end up in the red. As you can see, through that very conservative management of your operation, that did not happen. However, we have to plan that that could happen. I think that I certainly now, with the operation as things are going, and we feel like we have your expenses under control, feel like we don't have to be as conservative. We have prohibited travel the past year that I very much would like you to have been able to attend, but we did not feel like it was a responsible thing to do given the circumstances. Keep in mind, too, your budget was put together in 2011 for 2012 and 13.
You know, the thing about it, though, Commissioner Giannini, you know, when we've got $3.8 million surplus.
I can't use that money.
But if we were, let's just say, if we were to wind up $20,000 in the red.
Yes, sir.
Can't we draw on that?
You can.
To get $20,000 of that $3.8 million?
You can, but in an unpredictable economy, if you go if you run in the red for 2 years straight, you're up for sunset.
Oh, I know that.
I'd just like to make a couple of comments about the Arillo. Commissioner Collins made the comment about the Commissioners College. That requires us to either go a day earlier or stay a day later in order to go to that, and there is a fee involved in that. I agree that as a fairly new commissioner, that when I came on board, it would have been invaluable for me to have been to that, and I have benefited greatly from the Arillo conferences. I'd also like to point out that most of the states take their attorney along, which is one thing we're not allowed to do, and I think it would be invaluable to Ms. Kropp, even if she couldn't go to all of them, to at least be able to attend one a year so that she could kind of have an idea of what's going on a national basis.
Yes, ma'am. Just let me clarify, because the attorneys are not prohibited from attending trips. We have other programs where the attorneys do attend TRIP. So I'm not sure, that would be on a case-by-case basis, and we look at the agenda depending on what it is. But if it's a valuable opportunity for the attorney or a board member to participate, we very much want you to go. If we have the money to pay for that, we want you to attend those kinds of events.
I want to go back to what you said you wanted to use some of this money for, licensing activity. And you mentioned it in the beginning. You wanted to use it for.
Yes,
Is this
that's
a new
one of
computer
the-
program? Is this a new?
We are midway through now the purchase of a new licensing system to replace the system that we've had since 1993 when Ned McWhirter was governor.
What would it do? What would the new one do?
From externally, it will appear to the licensees that we've moved into this decade.
Thank you.
That would be nice.
That would be very nice.
Yes, it would be nice. It will allow us to correspond with the licensees electronically. It will allow us to be much more efficient with your money. It will allow I believe that ultimately the experience for the licensees will be much less painful, and it will allow us to do lots of things that the system that we have today just currently doesn't allow us to do. How many of you, if told you've got to use your cell phone you had in 1993, would feel like you were going to be very efficient today?
Would it benefit?
We have a couple.
We have a few up here. Would it benefit you if we were to somehow make a motion or even just say that we're behind you on this? Does that help? Would that help you to have the commission's?
I think at this point, we have a willing Department of Finance and Administration to help us. They recognize, too. It's insanity. I think everybody agrees. Anybody that we ever talk to about this recognizes it. And again, I don't think that the law was not set up to stockpile money. The law was set up to make sure that we very, very narrowly manage your money and don't charge licensees too much for a license. And, and not to go on junkets and do those kinds of things. We've not done that. You're not doing that. We've been very efficient with your money you have. We do not also want to take money from next year's revenue to basically borrow money to pay for a system when you've got money in the bank. We believe we have sympathetic ear to that and that we are going to be able to do that. Hopefully in the next month or two, I will be able to report back to you much more confidently about that.
Well, if we can do anything, if we can do anything to help you, just please let us know. And
A vote of support for that initiative certainly couldn't harm me.
Can I make a motion that we support that initiative? Or would we?
Second.
I got Bear, we got a first and a motion and
Call
a
for the
second.
question, Mr.
Mr. Chairman, could I ask a couple of questions before we vote on that?
Yeah, we got a motion by Commissioner Haynes to go on record as supporting the administration's effort to upgrade our computer system, and second by Commissioner Grease. Now we need some discussion.
All right,
Commissioner
thank you.
McMullen.
Commissioners, wanted to ask a couple of questions to get a little bit of clarification on what you were talking about with some of the fiscal issues.
Yes, sir.
I think you said that if we operate in the red for 2 straight years, then you're up to be sunsetted. Is that correct? Is that with respect to the main account, which y'all are calling the main account?
Correct.
Okay, so if money is spent on this computer system that you're talking about out of that main account, is that going to put us to where we're operating so-called in the red?
No, sir. Because, and that's the kind of one of the fallacies of the way that it's constructed. The reserve fund only comes into play when you run on an annual basis from July 1st to June 30th in the red. And if you run in the red for 2 consecutive years, then you are called up for a sunset hearing where the legislature could basically sunset the real estate commission or reconstitute it.
But spending money on this computer system is not going to be taken out of that calculation. Is that what you're saying?
Right. Actually, in the scenario as we understood it when we started the effort to purchase a new licensing system was that it could, because it would be taken out of current revenue for the fiscal year. that we have not, revenue that we've not taken in yet, but we would take in over the next 5 years. That was the plan, that there would be a 5-year plan, that each board would be allocated a certain percentage of the cost of the licensing system, because we're spreading it not only within the boards and the 24 boards in my division, but also Consumer Affairs and Division of Fire Prevention. So, but now that it looks like F&A is going to allow us, as we have discovered this provision to pay for it out of reserve funds, we will basically be able to pay cash.
So this is going to be out of the reserve funds and not the operating funds?
That is our hope. That is our hope.
Have I been asleep up here? Is the figure of approximately what this new system's going to cost, is anybody?
Yes, sir. Well, not the, it won't cost the real estate commission. It's going to cost the entire department.
Right, but I mean total.
$2.5 million.
$2.5 million, okay.
That's reasonable. Okay, I have a motion in a second.
Any other discussion on the motion?
Motion.
I think
I had another question.
Okay, go ahead.
Step right up.
Earlier, you were saying that that the board ought to consider reducing some of the fees that licensees are charged in light of the fact that we have a significant reserve amount that's in that main account, as you're calling it. If we were to reduce those fees so that we could, give money basically back to the licensees and operate, lower expense, is that going to put us in this red situation to where we're going to be subject to being called up for sunset because we've reduced the fees that we're charging people, and now we're operating at a deficit in order to try to spend this money that's in the main account?
Well, I think that would be, we would need to have a deliberate discussion and an analysis of where you are. I think if you are, this previous year, Chairman, did you?
Go ahead. When you finish, I've got a thought.
Just got to keep his hand up so he don't forget.
You better hurry.
The previous year, you had on revenue of 2.253, you had a fiscal, you were in the black for $382,236. That's a significant percentage of your revenue to bank. And I can tell you, when we sit down and budget you, we try to budget you with about 10% spread. That's how we like to see. That way you've got pad, but we're also not charging more than you need to charge, and we're not spending more than you're taking in from revenue. I'll continue to say, however, in defense of the commission, that it has been the very responsible thing to do with the unpredictable real estate market to hold tight and to maintain the status quo and not do anything in a gut flinch reaction that could, because it is very difficult. It takes a long time to raise a fee and it takes a long time to reduce a fee. And should you find out 18 months after you've lowered the fee, well, we shouldn't have done that. Now we are in the red. So I think that it needs to be a meaningful discussion and analysis to determine, are you now in the right economic climate and with your fiscal house in order to be able to do that?
There's two things I'd like to bring up since we're discussing this. We've got the money to buy the whole system.
Are you agreeing to pay for the whole system?
We'll buy the whole system, but we're going to charge rent to these other 23 boards. We're going to charge them monthly rent to use our system.
The fire marshal may disagree with that.
The second thing, all you licensees out there, we as commissioners, we do what we do for the money. We make $50 a day. You don't think you got enough?
For the days we're in meetings.
Yeah, for the days we're in meetings, we're making $50 this day. You don't think you could raise our salary up to $60, could you, Commissioner Giannini?
Did y'all not get the 1.5%?
I'm just joking.
If we did, it was in taxes.
I'm just joking. But anyway, Commissioner McMullen, you have anything else?
Yes, sir.
Commissioner Grease, before we vote.
Can I say one more thing in kind of in the light of Commissioner McMullen? I do think that it would be a good idea for the board to consider putting together an ad hoc committee to discuss fees. No one's saying that you need to reduce them. We always believe that it's a great thing when we're able to say to Tennesseans or to licensees and fly in the face of every other thing in their lives, we've lowered the cost for you to do business with us and not raised it. I think that says great things about the commission, says great things about your staff, and that you are very conscientious of that every dollar that you raise is somebody else's dollar. So
We did that last year.
you did have a discussion?
We lowered it.
No, we lowered it.
We
No,
lowered
you did
the
that,
recovery
absolutely,
fund.
right, right.
We lowered the amount of
Yeah.
money that was going into the recovery fund. It was, what, $10 per licensee?
Yes, sir.
It was 30, now it's 10.
Now it's 10. We lowered it.
And
So we
that's-
have done that.
And that's, you guys are a great example, and for other boards and commissions across the state because of that.
Well, as a licensee, I would like to see our technology improved so much more than the reduction of a fee that I'm paying. Maybe I've just gotten used to seeing it. But when you pay the fee and then you don't get in return what we should be getting, it's very disgusting to licensees. So I think that's a great idea.
With that thought in mind, we have a motion on the floor, and I say in a second, and all in favor of the motion.
The motion?
The motion is for us to go on record of supporting the administration's efforts to proceed forward with a new computer system. And all in favor say aye. Aye. Opposed, no. Motion carries unanimously. Mr. Grease.
First of all, I find this very helpful. I appreciate you putting this together.
You are very welcome, and just because we want to do this annually, but you certainly at any point in the year are free to contact me, contact Director Maxwell and ask for, we get this monthly, and we very much want to keep you informed of where your money is going, what we're doing with it, and so that when you're asked from someone else, that you are in full possession of where you are financially.
Secondly, do we ever get to see the budget?
Do
we
you-
get to see the budget?
Sure.
I'd love to see the budget compared to the column,
Sure.
just to see if we're over
Absolutely.
or under on a particular item.
Yes.
Not that we can do a lot about it, but that'd be helpful. And apparently we can't do a lot about it. Finally, in this year's budget, so you'd reference auditors and the lack of.
Yes, sir.
And so, does this year's budget anticipate salaries for investigators or for help in enforcing the rules and regulations of the Real Estate Commission?
Yes, and I can tell you that we did not, because it's an ongoing discussion, I believe, with the board about exactly what how the audit process will work. We stayed with the previous year's numbers on payroll. I think that, we didn't have enough information to tweak that down, and so we left it there. It's always perfectly acceptable to come in under budget, so.
Well, on the other hand, we don't want to come in
Right.
with the public at risk because we don't have anybody that can check up on things.
Absolutely not. Absolutely.
Commissioner, I want to go back to one other thing, and I'm not going to get after you this time. In reference to the Arello,
Yes, sir.
we pay dues for all of us.
Yes, sir.
So that's money wasted if we're not going to be able to go.
I will look into the Arello specifically. I have a bunch of boards and commissions, and I get some of the associations confused sometimes in some of the particulars. We do have associations that we actually contract with for testing, and we're prohibited at that point from allowing to pay to go to, because it's money going both ways. I don't think Arello's that way, but I will look into the Arello for you and come back next month and talk to you. I'm a fan of Arello. I think that Arello offers very good content at their meetings and would very much like you to do so.
Stay on the cutting edge, and that's what's interesting.
Yes, ma'am.
Can I just make another comment about that? They've just recently sent out a form as far as nominations for next year for candidates to serve on Arello. And I will be serving on the Fair Housing next year, but I would like to see Ms. Maxwell be able to do that if she would like to.
I'll defer to Ms. Maxwell. We would not object to that.
Yeah, because like I say, with the amount of money we have in our recovery fund,
Yes, sir.
our statute allows us to spend the interest on that money. And I mean, we've got the money. Will you come back next month?
Yes, sir.
We'll treat you kindly.
As long as the governor says so.
Appreciate you giving us your time.
Yeah,
Yes, sir. No,
we
my
appreciate
pleasure.
y'all coming.
I did want to tell you one last thing before I left. I was going to also talk about CORE, which we've talked about. CORE is the new licensing system. I think we've talked about that probably enough. And the last thing that your staff has participated in is something that every member of my staff, every state employee is participating in, and it's high on the governor's initiative, is customer-focused government. And it is, Ms. Whaley here, along with a couple of others, have actually took the role of teacher in these trainings. And Mr. Steve McDonald down there on the very end, under the tutoring of Ms. Whaley, did a great job. And he took that role on. It was volunteer, and he did a fantastic job. We had 6 classes that lasted about 4 hours, and I participated in every one too, and they were absolutely, to me, they were thrilling, and the governor is committed to improving the perception of the public about state government and the licensees. All of these things fold into the governor's bigger goal of transforming government, defying the odds, and making people go, wow, that was a lot better than I expected it was going to be when I call or when I email or when I send my money. And the customer-focused government is a very, very important piece of that. And your staff did a great job. And again, thanks to Steve and to Director Maxwell for allowing him to come down and do that for us. So, any other questions? Bear? You've always got one more.
Well, no, for the sake of time, since you're coming back next month,
Oh,
I'll save it to the next month for the sake of saving a little more time.
so I got a reprieve. Okay, thank
Yes.
you.
Thank you for coming.
Y'all be
Commissioner.
careful.
Okay, Ms. Whaley, thank you, ma'am. We have one more informal applicant, is Stacy Grissom. Yeah, do we want to go, before we have a break, can we wait and go ahead and get this one out of the way, since they've been waiting patiently while the commissioner? No. You need to go? Yeah. You need to go, let's take a short 5-minute break.
Ready?
We ready, Kelly? Call this meeting back into session, and our Stacy Grissom, an applicant, and his principal broker, Perry Hamlet, make your way to the front. Come on up here and raise your right hand, and our attorney, Julie Kropp, will swear you both in.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Where would you like for us to sit, please?
Right there, those two. And then when you talk, just pull those mics down and talk into them so we'll have a permanent record.
Mr. Stacy Grissom is here today applying for an affiliate broker license. I believe he is tested, is that correct?
Yes. Wait, no, I'm sorry. I have
You
not
haven't tested, okay. He has not tested yet, but he wants to be an affiliate broker. He is here with his principal broker, Mr. Perry Hamlet. Mr. Hamlet has no complaints filed against him. He was first licensed on 3/23 of 1994, and he became a broker on 9/27 of 2001. Mr. Grissom has disclosed to us that he has 6 convictions, the first being petite theft, which is petty theft. First offense, it's a misdemeanor, as are all of these convictions. That occurred when he was a young man in 1992, and he was 23 years old?
Yes.
23 years old. And he says that he was out with some friends, and there was a convertible car parked, and they jumped into the car and took something out of the glove box, and then there was an unmarked police car there that saw them and arrested them. He got 6 months of probation and had to pay $125 in cost on that particular conviction. The second conviction involved drug possession of marijuana under 20 grams, which is less than an ounce, and that happened in 1995. And for that, he also got 6 months probation and a fine of $460, but that's combined with another charge for paraphernalia possession that happened at the same time in 1995. There, he was pulled over by the police, and when they searched his car, they found some marijuana and a roach. As I say, it was under an ounce of marijuana. In 1998, he was convicted of possession of marijuana less than 1 ounce, and he spent 14 days in jail, a $500 fine, and 6 months of probation. The number 5 and 6 that he disclosed were evading arrest and trespassing, and those occurred in 1999. He says that he had gone with a friend to see where the friend hunted, and the grounds that he hunted on happened to belong to a private citizen who was a policeman. The citizen who owned the land was intoxicated. Some sort of an argument ensued, not with Mr. Grissom. He was sitting in the car, but his friend got into an altercation. They then left, and Mr. Grissom was later arrested and then pleaded guilty to trespassing and evading arrest. He received a fine on each of those of $50 and 6 months probation. His probation, his last probation ended in 2000, and he's worked for the last 20 years at various jobs, and I'll let him fill in any other details that he'd like to fill in.
If you would, Mr. Roach, just tell us, no, Mr. Grisham, I'm sorry.
It used to be Mr. Roach.
That's a minor Freudian slip. Mr. Grissom.
Working in your favor.
I was reading here on the second.
It's voice activated.
I was reading up here at the top, applicant was pulled over, police searched car and found a roach, and it was about that time I said, yeah. Now, Mr. Grissom, in your own words, tell us, I mean, you want to add anything that Ms. Maxwell has said, or just tell us why you want to get a real estate license and what you've been doing?
Well, I want to get a real estate license because I want to move ahead, advance my career, which has really been going nowhere due to past circumstances. So right now I'm not working, but I take care of my kids and my home, and but when I can, I was working. My most previous job was delivering pizzas, which is a terrific job, and 'cause it's pretty good money. As far as my, well, in 1990, I think the trespassing, that was, the dates were a little off there, but that happened in 97, and then the actual went to court and pled guilty was in 98 or 99. Anyways, that one is really, first of all, I should probably go down to the petty theft, which happened 22 years ago, over 22 years ago. I was drinking, I was drinking, and I was with some friends and just showing off, and just did something stupid, jumped in a convertible, took something out of the glove compartment, and don't even remember what it was. A few weeks later, I was in a head-on collision, hit by a drunk driver on a highway in South Fort Myers, Florida, where I grew up. No lights in the highway, and there's a median, and this gentleman was on the wrong side of the median with no lights on. And I was in a coma for a few weeks after that. And then once my rehab after my accident got over with and so forth, first of all, I'd like to thank God for saving my life. That was a tremendous experience. And so basically, that was part of one of a number of And I was, when I got a notification about this, which was almost over a year, probably a year after it happened, about this petty theft arrest, I didn't even remember it. And I went to court about it, and so they gave me 6 months probation and so forth. And then recently, I was getting some materials together, like the court disposition and so forth, because I didn't even remember what it was, what happened 22 years ago. I had to call a friend of mine and ask him what did I do, what happened, because I've got petty theft on my record, and he explained to me. So, I was really ashamed, and I'm ashamed. That's not my character. That's not who I am. That's not how I was raised. That's not how I raised my children. It's not how I live my life. But it was a terrible mistake that I made, and I paid for it. And in some ways, I'm still paying for it. Then moving on to the trespassing. What really gets me is I happened to run into a friend of mine that I hadn't seen in 13 years. We were friends in grade school, and he was showing me around. I was driving, so he wanted to show me a place where he hunts, which happened to be in Sumner County, which back then I didn't know that. And so we're on this gentleman's property. His house was over at the end, down off the road a little bit, and then next thing you know, we're just looking around. I don't know what. Just like, like I don't even hunt myself, so I didn't really have much interest. But I was just entertaining my friend, and this old gentleman came out. I knew that he was a police officer because my friend told me. So my friend was like, "Hey, Stacy, go ahead and get in the car. Let me talk to this guy for a minute." So they talk, and then I don't know what happened, but they got mad at each other. And my friend gets in the car and says, "Let's go." And so then I leave, and then next thing you know, I get arrested at my house. My friend never got in trouble, but I get arrested at my house, and then I ended up pleading, instead of pleading not guilty and so forth, because it would have been thrown out by the judge because it was in Sumner County, not Davidson County. But I pled guilty because I was a couple of weeks of moving to Alaska, where I was a commercial crab fisherman for a while. And I didn't want that to stop me from going, and I knew it was just going to be a misdemeanor, but it's turned out to be a real thorn in my tail. But it's over and done with, but that's the story on that. But all these things that I've done, they're just childish, and some are punishable, some are not, but I really regret and the things that I've done that were just stupid, like the petty theft and so forth. So I'm ashamed of what happened, like I said, and I haven't been in trouble for anything like that since, and I'm just trying to get on with my life. I have a beautiful wife and 2 daughters that are ages 4 and 6 years old, and I drive them to school and pick them up every day, and I'm just taking care of them, and I want to provide them a better life, and I know I can achieve that as a real estate agent.
Okay. Perry, your principal broker, Perry Hamlet, tell us about your company, Perry, and how you're going to train Stacy if he gets his real estate license.
Well, I will be his principal broker if he gets his real estate license, and I believe he will. Just take it from here. If he gets his real estate license, how will I train him? What services will I provide?
How many agents do you have now at your company?
159. We started business in you mean to give you a little history? Is that what you're asking?
Yeah,
sir?
brief little
Okay.
history.
All right, I can give you a quick overview. In 1987, Realty Association was created. We were at 3200 West End Avenue in the Blue Cross Blue Shield building. We outgrew the building that we're renting space in the year 2000. We purchased a building at 1305 Murfreesboro Pike. In 2001, I became principal broker at the Realty Association and have since then. On my first day in the chair, Eddie Sneed walked in. I had no idea what an audit was, and he taught me. He was there for 2 days. I miss the auditors, by the way. They provided a lot of education and keep us brokers and real estate licensees on track. But from my experience with Mr. Sneed, I understood what my duties were and had the benefit from our company of being allowed to provide a high-level service. Our brokers, there's 3 of us in the company. I'm principal broker. We're all full-time, open 7 days a week. We provide service on Saturdays and Sundays on call. I love my job, and I'm good at it. I respect the rules. I adhere to the rules. I continue to study the rules and the laws. I'm faced with asking questions every day. Sometimes I don't know, and I dig deeper and find out. I believe that I can provide that supervision to Stacy Grissom. When I met Stacy Grissom, I didn't know him as with a criminal past. I met him and knew him for a month before he brought that to my attention. He was a buyer at our company working with one of our agents, and as I interacted with him and the agent, I got to know him and respect him. And he came to me, I don't know, maybe 6 weeks after I met him the first time, and he told me his story. And I've turned people away before that didn't have to come to the commission that I didn't think that I could supervise. I don't know Stacy Grissom as a criminal. I know him as an intelligent, loving husband and father of his children, and he wants to become a professional and provide service to the public, and I think that he will do a good job doing that. I'm not worried about his, and we all know that if he did, we would learn about it probably the first week of him having a real estate license. The public will tell on you real quick.
I know, it looks like to me, Stacy, you just had a bunch of series of bad luck as you've gone through life, little incidences that have happened. But does anybody have any questions of Mr. Grissom or his principal broker, Mr. Hamlet?
You know, this is not a question, but my only concern, Stacy, is your belief that you can do it. I mean, and maybe you can get that positive motivation in there, but you're here today in front of us with your hat in your hand, and I'd prefer you to be here going, this is going to change my life. And I hope that's what you can bring to this licensee. And I hope you become an all-star. But I hope you don't spend the next 10 years looking back. I hope you'll spend the next 10 years looking forward, if you get your vote, which I suspect you will.
There's one thing does anybody have any other questions or any comments?
Well, I want to make a comment to Mr. Hamlet. Congratulations, with 159 agents and no complaints filed against you. You've evidently done a good job.
And been easy.
And Stacy, I just have one comment. And you've heard, several of you on this commission have heard me say this before. My grandmother had a saying one time. She said, everybody goes up Fool's Hill. Just some stay on it longer than others. It looks like you've gotten off of Fool's Hill and you're ready to go on with your life. I hear a motion to what we do with the licensees, Mr. Stacy Grissom, as he moves forward to get into this industry.
I make a motion, we approve Mr. Grissom to get his license.
Second.
I have a motion by Commissioner DeShara to approve this applicant request, and seconded by Commissioner Grease. Any discussion on that motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously, and you go forth and work hard, and good luck.
Thank you, sir.
Thank you.
I really want to.
Thank you.
we're down now. If we get our E&O update out of the way by Ms. Maxwell, then the only thing that we're going to have left on our agenda is the legal report by Julie Kropp. So, Ms. Maxwell, why don't you just take
Okay.
it over?
And this won't take very long. As you can see from page 1 of the E&O uninsured numbers, we don't have anyone who is uninsured who is active. We have on the second page the update on the suspensions. We have 217 affiliate brokers who are suspended, 18 brokers. The number of principal brokers is 27 because we had one drop off yesterday. So we have 27 active principal brokers. Well, they would have been active. They are now in suspension. 259 timeshare salespeople. So we have 521 individuals in suspension for E&O. If you note at the bottom with the little star, the firms of all the principal brokers who are, the 27 principal brokers, are either in problem status or they're beyond their expiry date. 20 of the principal brokers have been in suspension since 7/1 of 2013, so they've been in suspension since the inception of the effective date of the statute. 3 have been in suspension since 9/10 of 2013, and 5 have been in suspension since 10/31, so they were just placed in suspension right as I did this. 10 of those principal brokers are in Tennessee, and 17 are out of state. The ones that have been on since the 1st of July have been notified numerous times. Some of their mail has all come back. We've attempted to email and to call them, so we've tried every way that we really know to reach them. And then the others are, the newest ones have received a letter of suspension, and we'll continue to follow up with them. And that really is, the rest of the E&O report shows how many people have alternate insurance and Rice Insurance. And that's, Rice has 18,775 licensees insured. The alternate carriers have 7,450, and those numbers add up to more than we have licensees that are active. That's because some of the people who are retired had bought E&O and then retired shortly thereafter, and then some people have double coverage because they bought state E&O and went to a firm that had a blanket policy, so they have 2 policies.
How many of these 217 affiliate brokers who have a suspended license, how many of those do you think are just going to say, the heck with my real estate license, I quit, I'm going to go work at Walmart or somewhere?
I think probably, I think probably the majority of those might. I mean, the core of this group, no matter what category it falls into, they've been in suspension since the very first. I mean, you can tell since we've only had $4,000 that we've received in the penalty fee provided for under the statute, we haven't had very many people come off. We have had some people roll into retirement, but by and large, I think most of these people are just going to let their licenses go.
What
Yes.
about, excuse me, what about those brokers where those companies they're in?
They've all received notice of the individuals, if, like they got a notice when it went out originally because that's required by the statute. So we haven't penalized them at the current time because the policy did not provide for us to do that. The policy that we passed, the rules do provide for that, but it'll be, a few months before the rules are effective.
I'd like for you to email me those 10 brokers in the state.
Okay, I think I probably have a list of them here, but I'll email those to you. Are there any other questions about the?
Call Barry and tell him.
Yeah, he'll mail me a hard copy.
On his 1992 phone.
Axel. I just want to make a comment.
Okay.
We were so inundated with these hearings when I first came on the commission. It was just blowing my mind. All the money that was being spent on this, and to have it, one legislation has cleared it up. And I'm just so proud that we were able to go through all that. And thanks to TAR, they were a big help.
And I think once we get the new system, the core system, it'll be able to it'll be able to send the letters out by itself, so it should make the system work a lot more efficiently, because they'll be able to just, it'll read when the person doesn't have E&O, and it'll just be able to send that letter out, generated automatically, so.
Finally, we're in this century.
I hope, we have another year or so before the core comes online, but that'll be great when it can do that. Are there any other questions about E&O? Then that's, thank you, that's, now it's.
Now, Ms. Crop?
Before I got started with my legal report, Ms. Ryan had one thing regarding a matter that y'all had dealt with at a summary suspension hearing. It's kind of progressed. She was going to bring that back to you all. It's not anonymous, obviously, because you heard it at a summary suspension hearing, so that's why it's not on the legal report. So I didn't want to do mine and then forget to acknowledge her, so I just thought I'd let her go first.
I don't believe she's on the schedule.
I don't, yeah.
She's part of the legal report.
I do think I'm still legal. Okay, well, two points, actually. You don't know about this other point. There is a hearing next month that will require the commission to be here. It was a continuation of hearing in October, so for your December plans, sorry, there's a hearing. Just thought I'd let you know that. Most often, most years, I try not to make a hearing in December, but this year we have a hearing. The issue that I'm bringing before you today is a partner of a matter you did hear earlier. This is Griffey and Associates in Clarksville. They was brought before you on a summary suspension matter. That particular business has worked hard to close, and they have signed a consent order and surrendered their license. And I'm here today asking for an approval of that. Actually, it's an agreed order of approval of that agreed order, which would then surrender their license and put them back in the position of not being in business. I can't tell you all the particulars of what went on, but I can tell you that the attorney and the others worked hard. I do know that there were very few clients left, and many of those were transferred to another business. So there is nothing hanging or clinging in this particular point for this particular business. So I'm here today to ask you for approval of that, and if so, then we'll go ahead and do that, and then we can close them out legally.
Just need a motion on that,
Yeah.
Ms. Ryan.
Mhm.
I make a motion that we approve the agreed order on Mr. Griffey,
And no, Griffey and Associates.
Griffey and Associates.
I hear a second.
Second.
Commissioner DeShar makes a motion. We approve the consent order to close Griffey and Associates file, and seconded by Commissioner Collins. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. You have anything else, Ms.
No,
Ryan?
except for to tell you that you lucked out. I do have hearings tomorrow, but you don't have to be there, and it is tracked, but I knew you, I knew you feel that way. You are certainly welcome if you want to stay and listen to them tomorrow. I know how much all of you enjoy doing that, so I do expect to see you all there in the audience anyway. Anyway.
Will it be in this room?
No, room 6A.
We didn't notice it.
What? Yes, it's in 6A, upstairs.
And I don't know if this would be a good time to let the attendees know, but Mr. Chairman, I think Ms. Maxwell had spoken with you about whether or not the attendees needed to attend tomorrow as well, and I think you had given her a decision on that, but I thought you might want to let them know.
I'm just one of 8.
I don't know what you're talking about.
Whether the attendees have to be here
Pretty
tomorrow.
educational, Mr. Chairman.
That room's awful small.
That room's small up
Is
there.
it?
Well, it's not that small. It's smaller than this room, yes. It would not be comfortable necessarily. You've been in that room before. It would not be comfortable necessarily if.
I thought the decision had already been
It
given.
I think they've
Max.
received an email, did you not? Yeah, they've already received an email
What about?
saying they don't have to be here tomorrow.
Received an email about what?
One of 9?
Saying they don't have to be here tomorrow.
8 today, one of
Yeah,
mine.
yeah, but
That's just one.
doesn't sound like the one, sounds like the
That's what I
one.
was trying to do.
Go ahead and say it, Chairman Mayor.
I couldn't get all of you on the phone at the same time. I talked to Miss Maxwell, and Steve,
Trying to get in his Maxwell.
Steve,
called
Steve,
You're getting thrown under the bus now.
and along with Mr. McDonald, they've
And
had
Mr. Roach.
conversations.
Since he's not in the room.
Yeah, go ahead and throw him out.
Oh, there he
I'll
is.
throw him
He's
under,
back
too.
there getting thrown under the bus.
Yeah, Miss Maxwell and Mr. McDonald, they conferred, and I conferred, and I felt that it would probably be best if they not just sit through this hearing tomorrow.
Did you check with the vice chair or anybody on that?
No, I did not check with my vice chair.
I asked him for an executive decision, and he was able to
Don't take it.
reach for an executive decision on
I
his
just wanted to be
own.
sure they knew for purposes of
Right.
making their plans, so.
Might I say I object to your qualification as sitting through.
Are being subjected to. Would that be more appropriate?
Okay, that's okay.
Well, I was asked about the time today. They may have to stay just a bit longer. I don't know what time it is now, but.
It's 3:30. We're going to continue on.
3:45 almost.
3:45. They're not, they're,
Use my auctioneer voice.
So I'm thinking maybe they, no complaints, though, they need to stay.
oh, yeah.
Until we're finished.
They're not going anywhere till we finish.
Okay.
Okay, you ready for
Yes.
me to get started?
Ready, set, go.
Okay. Any consent order authorized by the commission should be signed by a respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. First matter on the report is 2013-011-341. Complainants were lessees and respondent is the principal broker of a licensed firm. Complainants state that they entered into two leases, a 12-month lease and a 6-month lease with the company, with a company that has substantially the same name as the firm for which respondent is principal broker, except the firm with which complainants state they dealt had a division name added to the end of their name. Complainants state that the property was not habitable, so complainants moved prior to the end of the second lease term. Complainants state that there was a broken window at the time complainants moved in. Windows were not airtight and a door was not airtight or windtight, as well as other issues which complainants state the company refused to repair. Complainants state there were a number of matters which were not handled in compliance with the Landlord-Tenant Act. Finally, complainants state that they were sued by the company, which included the division name, and are in a legal battle. Complainants state that they received a letter from the Executive Director for the Real Estate Commission stating that the company with which complainants dealt was not a licensed real estate firm. Respondent states that complainant signed a 1-year lease and then another for 6 months. Respondent states that all monthly payments were paid until January 2012 when complainants moved out, breaking their second lease after purchasing a home. Respondent states that all tenants were asked to send in a list of any issues with the property prior to moving in, and such a list was provided by complainants. Respondent states that this list included a cracked window and a lease provides that the tenant accept the property in an as-is condition. Respondent states there was nothing filed to request the window be replaced or that respondents were given a 30-day notice. Respondent states that a lawsuit was filed and a judgment was entered against complainants. This has been appealed and the appeal is currently pending. Respondent states that respondent's firm is a licensed firm in the state of Tennessee and addresses complainant's allegations as if they are alleged against respondent's firm. Respondent does not specifically address the allegation regarding the company with a substantially similar name which dealt with complainants and which does not have its own firm license. Based on an internet search of the company with which complainants state they dealt, it appears to be an LLC registered with the Secretary of State. Respondent's licensed firm is also registered with the Secretary of State as a corporation, but also has a website with the company's name at the top of the web page, which states that it's a property management company. The website also includes the name of respondent's firm at the bottom, along with an address and phone number, but the phone number does not match the firm number of respondent's firm as displayed on respondent's firm website. Additionally, complainants provided copies of the lease agreements, which included a letterhead of the company with division in its name and a security deposit check which was written to respondent's firm but was stamped deposited into an account including the name of the company with division in its name. In light of recent discussions regarding topics of a substantially similar nature, it is recommended that the commission discuss this matter. That's a recommendation that we discuss it, and I can try to clarify anything that might have been confusing because sometimes it's hard to describe some of these matters anonymously, and this one was a little bit difficult. No, I'm sorry. When I describe them, I'm keeping out names and I can't reference. So if anything was unclear because I was trying not to give away too much identifying information, I'd be happy to clarify it.
So the respondent, I'm sorry, the complainant thought that he or she was dealing with a firm that had a division name.
Like X division at the end of it.
Like Wendell Alexander Realty Commercial Division.
Exactly, something of that nature.
And the respondent didn't discuss that complaint
No.
directly.
And the respondent is the principal broker of, in your example, Wendell Alexander Realty, no division. He discussed it as if it was all one firm, and as I said, the lease agreements had the company with the division name on top of it, a lawsuit was instituted with a company with the division name at the top of it. It's separately registered with the Secretary of State's office, and on the website, it's a little confusing as to whether there are one or more entities. This may be something that's hard to describe. I don't know, this may be something that one of you commissioners that's more interested in advertising may want to look at, because it's very hard to explain sometimes some of these issues. But it's something that we had discussed in a roundabout nature in several meetings, but this, came up in the context of a complaint, where, it was kind of central to the focus of.
Since we're working on all this advertising stuff, this sounds like one Commissioner Grease needs to take and look at this file and see if it falls in.
I'd rather vote on it and let somebody else take a look at it after you've.
I'd be happy, if somebody did take it to, discuss it with me. I just know it's hard.
Let him review it.
Well, let me ask a question before I commit to it. Is this perhaps a case of unlicensed property management?
I think it would be the case of a possibly unlicensed branch office, that maybe this PB should technically have two licensed firms, and he could be the PB of both of them, but it appears that there's some separate branding going on. That's the potential that I see for it, is that it should be possibly have its own firm license instead of attempting to clump the two together.
Would you take it, Commissioner
I'll
Greaves?
look at it.
Okay.
Form of a motion.
I make a motion, Commissioner Grease review that file.
Second.
I have a motion by Commissioner DeSharon, seconded by Commissioner Alexander, that Commissioner Greaves take this file and give us a report next month. All in favor say aye. Opposed, no. Motion carries.
I'd like to thank my former friends.
I like
Not a very big one.
Okay.
Okay,
Number 2.
2 and 3, 2013-012-591, 2013-012-592. Complainant states that complainant attended a timeshare meeting in another state where complainant met with respondent 2, an unlicensed company. There, complainant states that respondent 2 asked complainant to purchase an expensive vacation package, and complainant declined, but did pay $1,500 to respondent 2 to transfer complainant's timeshare, which was also located in another state, to respondent 2. Complainant states that complainant was told by a representative for respondent 2 that complainant would be contacted regarding the transfer process in 10 days and a check was soon cashed. Complainant states that a transfer document signed by complainant at respondent 2's presentation stated that respondent 1, a firm, would handle the transfer paperwork for a specified transfer fee. Complainant states that complainant was never contacted by either respondent regarding the transfer, so complainant began attempting to contact individuals associated with both respondents. Complainant states that a respondent for respondent 1 stated that they had received no paperwork from respondent 2 to complete the transfer. According to complainant, the transfer of complainant's timeshare was never completed, and respondent 2 has not returned complainant's $1,500. Respondent 1 submitted a response stating that complainant attended a meeting in another state with respondent 2, not respondent 1, and entered into a sales transaction with respondent 2 there. Respondent 1 states that complainant has not paid respondent 1 for any services. Respondent 1 states that when a timeshare owner attends a presentation and wishes to have a timeshare transferred out of their name, respondent 1 is sometimes referred to the owner to handle the transfer. According to respondent 1, the referral is then sent to respondent 1, and respondent 1 contacts the owner to explain the transfer process, and at that point the owner is billed for the transfer service and documents are requested to actuate the transfer. In this case, respondent 1 states that the referral was not forwarded to respondent 1, and when complainant contacted respondent 1 and sent the documents and was informed that there would be a transfer fee, complainant stated that the transfer fee should have been paid by respondent 2. Complainant denies that complainant was told about this additional fee or refused to pay it. After additional discussions with respondent 2 and complainant, respondent 1 suggested that respondent 2 recommend another company to complete the transfer process. Respondent 1 says that if complainant wants a return of the $1,500, complainant should contact respondent 2. Is that who was paid the money, and no funds have been paid to respondent 1. It appears that the transaction with respondent 2 took place in another state regarding a timeshare located in another state. At this time, there does not appear to be any information substantiating that respondent 1 was ever paid to complete the transfer paperwork for the timeshare or to show any violation by respondent 1. Therefore, the recommendation.
We take your recommendation.
Second.
Have a motion by Commissioner Collins. We take council's recommendation and close this file, and I have a second by Commissioner McMullen. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries.
4, 5, and 6, 2013-012-611, 2013-012-612, 2013-012-613. Complainant was the prospective purchaser of a property. Respondents 1 and 2. Respondent 1 is a broker. Respondent 2 is an affiliate broker. Respondent 3 is the principal broker. Originally represented the seller builder, but became facilitators when complainant entered into the agreement to purchase the property. The contract included a purchase price, which was the list price plus a closing cost amount, which was specified in the contract to be paid by the seller at closing. Complainant states that the complainant paid earnest money to respondents and also paid in excess of $3,000 to other parties for a hardwood floor upgrade. Later, complainant could not qualify for a VA loan, and the hardwood floor upgrade money was not refunded to complainant. Complainant states that as licensees, respondent 1 and 2 knew that the VA would not approve the loan and that complainant had to pay for the hardwood floors and for molding up front. Complainant states that the VA lender overestimated income and had a number of other complaints regarding that lender, and complainant states that the lender was in conspiracy with respondent 2 to keep the VA from processing the loan. Complainant states that respondent 2 contacted complainant to switch to a different lender, but the second was not approved either. Complainant states that complainant was advised by the VA to have complainant's own realtor, so complainant hired another party to represent complainant, but the sale fell through. Complainant feels that complainant should be reimbursed for the flooring upgrades. Respondents state that complainant approached respondents 1 and 2, who represented the seller builder, about the home, which was a new home that was completed except for some flooring. Respondents state that complainant provided a letter stating that complainant was approved for a VA loan, and after conversations with the lender, respondents were assured that complainant would be able to secure the necessary loan. Respondents state that complainant was not represented, so respondents 1 and 2 defaulted to facilitators on the contract and the confirmation of agency. Due to the VA loan, respondents state that the lender said that complainant would need funds for closing costs, so these costs were added to the total price of the contract with a provision that the seller would pay the specified amount of closing costs. Respondents state that after the contract was drafted, complainant asked for additional hardwood floors, and complainant was given a quote by the supplier installer. Respondents state that complainant was told that this additional flooring was in addition to the home, that it would have to be prepaid, and that it was non-refundable. Respondents also state that they advised complainant against this additional cost, but complainant wanted this done prior to moving in. Respondents state that they were assured by complainant and the lender that complainant would qualify for financing, and complainant stated that complainant had no objection to paying the extra money for the hardwood upgrade. Respondents state that the home was appraised for more than the purchase price, but the lender then indicated that complainant would not be able to get the loan. Respondents state that they asked complainant what the issue was and were informed that support listed as income on the application by complainant was not being received on a regular basis, and complainant asked for another mortgage company referral. Respondent suggested another company, and this company required more to be paid toward closing price, thus raising the price an additional amount. Respondents state that the loan documents were never provided to this new mortgage company, and respondents had difficulty getting complainant to respond to phone calls. Complainant secured another licensee to represent complainant, so respondents state that the parties revised their original confirmation of agency form to indicate that respondents 1 and 2 represented the seller and the other licensee represented complainant. The second mortgage was also denied due to insufficient income. Respondents state that respondents learned that complainant had overstated outside income that could not be verified. After the loan was denied, respondents state that an earnest money disbursement and mutual release of purchase and sale agreement was completed, and complainant's earnest money was returned to complainant. But as explained to complainant, the hardwood upgrade was non-refundable. Based on the information in the file, there does not appear to be a violation by these respondents, and therefore the recommendation is to dismiss.
Motion to accept council's recommendation.
Second.
Motion by Commissioner Collins to accept council's recommendation and dismiss this complaint, and seconded by Commissioner McMullen. Any questions or discussion on this particular complaint? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. 7 and 8's next.
2013-013-031, 2013-013-041. Complainant, a licensee, states that respondent 1, affiliate broker, is advertising and acting as and receiving payment for being a property manager for a certain property without proper licensure. Complainant states that respondent 1 has listed respondent 1's cell phone number on a sign on this property for 4 years. Complainant attached a photo of the sign, which offered the space for lease, included the owner's email address and 2 telephone numbers, one of which was allegedly respondent 1's cell phone number, and did not include respondent 1's name. Complainant also makes complaints of respondent 1's position as a city alderman, specifically respondent 1's involvement with the erection of a cell tower, which has devalued nearby property. Respondent 2 is respondent 1's principal broker, and the complaint was open for failure to supervise respondent 1. Respondents each submitted responses denying the complaint's allegations. Respondents state that Respondent 1 has never been the property manager for the property bearing the sign, and Respondent 1 has not received any compensation for real estate activities relating to the property. Respondents state that the property belongs to someone out of state whose son manages the property, and Respondent 1 allowed Respondent 1's cell phone number to be listed together with the out-of-state number so that there was a local number. Respondent 1 states that Respondent 1 has received a few calls on this property over the years that the sign has been displayed, but Respondent 1 has never discussed any lease details, and all callers are given the property manager's number or the information has been passed to that manager. Respondent 2 states that Respondent 1 had no discussions about the property, did not list or connect anything about the property with Respondent's real estate firm, and there is not nor has there ever been a contract of any sort between Respondent 1 and the property owner. Respondents attached a letter from the property owner confirming that Respondent 1 has never been employed by the owner of the property or acted as property manager. Concerning the cell tower issue, Respondents state that Respondent 1 had no voter say as this was voted on by the City Planning Commission. Further, respondents indicate, and the letter from the city mayor also indicates, that complainant has residential property near the cell tower, which was approved by the Planning Commission. Complainant restated that Respondent 1 is representing himself as a property manager for the subject property and states that an individual called and spoke with Respondent 1 who discussed the prices for renting space, space amenities, and offered to show the property. Respondent 1 submitted an additional reply stating that Respondent 1 has no recollection of speaking with the person referenced by complainant, and Respondent 1 referred all calls to the property manager. Based on a review of the information, there appears to be no evidence that Respondent 1 is acting as a property manager or being paid as such. Further, complainant states that this sign has been up for 4 years. Additionally, as Respondent 1 is not being compensated for performing real estate services and is only providing Respondent 1's cell phone number as a local point of contact to forward calls to the property manager and is not representing himself as a real estate licensee on the sign, there does not appear to be a violation by respondents, and therefore the recommendation is to dismiss.
Second. Have a motion by Commissioner Collins to dismiss, and it has been seconded by Commissioner McMullen. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
9, 10, and 11, 2013-013-161, 2013-013-162, 2013-013-163. Trek open complaint against respondents. Respondents 1 and 2 are individuals who are spouses, and Respondent 3 is their LLC, based on information submitted by a licensee who stated that she received a very lowball cash offer from respondents and requested that Trek take a look at respondents as they did not appear to be licensed. The licensee provided 2 pages from respondents' website and a copy of a partially executed contract, presumably the one referenced by the licensee, which lists Respondent 1 and Respondent 3, the LLC, as buyer. Respondent 1 submitted a response on behalf of respondents stating that Respondents 1 and 2 are real estate investors who do not claim to be real estate licensees. Respondent states that respondents are a business that buys, sells, rents, or leases properties which are owned by respondents or in which respondents have an equitable interest, and respondents do not represent others in real estate transactions. It does not appear, based on the information that we have at this time, that the respondents are engaged in unlicensed activity, and therefore the recommendation is to dismiss.
Motion we approve council's recommendation.
Second.
I have a motion by Commissioner DeShar that we accept council's recommendation and dismiss this complaint. And I have a second by Commissioner, these 3 complaints. I have 3 complaints. Dismiss all 3 and have a second by Commissioner McMullen. Hearing no further discussion or comments, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 12 and 13 is next.
2013-013-171, 2013-013-201. This complaint was opened based on an email stating that an email advertisement failed to meet Trek advertising requirements. Based on a copy of the internet advertisement, it appears that Respondent 1, affiliate broker, appears to have created Respondent 1's own team name, and Respondent 1, working together with an architect and builder, advertised a new development which included that team name. In said advertisement, Respondent's licensed firm, as well as the licensed firm's address and telephone number, is included at the bottom of the email in a smaller type. Respondent 2 is Respondent 1's principal broker, and the complaint was opened for failure to supervise Respondent 1. Respondents each submitted responses to the complaints. Respondent 1 states that Respondent 1 now understands that the firm must always appear in conjunction with Respondent 1's branding. Respondent 1 states that when preparing the email advertisement in question, Respondent 1 questioned the placements and provided documentation that shows this questioning, as well as a response from the person preparing the flyer for the email, who said that the flyer as presented would make Respondent 1 compliant. Respondent 1 apologized and stated that Respondent 1 has made the needed corrections. Respondent 2 states that Respondent 2 states that Respondent 2 started as principal broker around the time that the events which were the subject matter of this complaint occurred, and Respondent takes matters such as these very seriously. Respondent 2 states that Respondent 2 met with Respondent 1 after verifying the rules so as to correct any error. Respondent 2 states that Respondent 2 was assured by Respondent 1 that Respondent 1 would follow all rules set forth by the Commission and would correct any error in a timely manner. Respondent 2 states that Respondent 1 enlisted the help of a professional marketing company, and that company did state that the advertisement was compliant. Respondent 2 states that Respondent 2 made it clear that all advertisements were to be reviewed by Respondent 2, and that it was the responsibility of Respondent 1 to be clear in all advertisements that Respondent 1 works in Respondent 2's firm and is not a separate office. Respondent 2 further states that Respondent 2 reviewed the modified advertisement and states that it is in full compliance with the advertisement rules. Respondent 2 also attached a copy of a letter to Respondent 1 which informed Respondent 1 of the importance of following TREC rules and stating that Respondent 2 must be put on all email, social media, direct mail, and ad distributions and must be approved by Respondent 2. Though it appears that Respondents immediately took action to correct the issues within the subject email advertisement as well as future advertisements, Respondent 1 might benefit from a letter of instruction regarding TREC's advertising rule. The recommendation is to dismiss as to Respondent 2 and as to Respondent 1 a letter of instruction regarding 1260-02-.12, which is the advertising rule.
This complaint came as a result of an email?
Yes, it was an email that was received into the office, just basically saying, I think the subject email advertisement was forwarded maybe to Ms. Maxwell. Is that correct? I think that's what it was.
I make a motion, we accept council's recommendation.
Second.
Have a motion by Commissioner DeShar and second by Commissioner Collins that we take council's recommendation and dismiss as Respondent 2 and as Respondent 1 a letter of instruction regarding Rule 1260-02-.012.
So Julie, did either Respondent 1 or Respondent 2 admit that it was a violation of the advertising rules?
Well, it was one of those things where it was opened because we weren't sure exactly if this was a team name or an unlicensed branch or something. It was a team name. The firm name, telephone number, and everything was displayed at the bottom in compliance with the rule, but it was just not as prominent as the other, and the principal broker recognized that in the future they wanted to make that more prominent. As far as the strict guidelines of the rule, they do have at the bottom of it what is required. Some of the things we've been discussing lately about the prominence of one thing over another, may not have been there as much as is necessary, but it appears this principal broker has spoken with this individual and emphasized the importance of displaying the firm name very clearly so that the public is very aware that that's the firm that this person's with.
They didn't admit that there was a violation. Is that a fair statement? Either one or two?
I think that they both addressed that there may have been some problems. As far as a clear violation, I think it could have been seen as not very clear as to what the firm was. I mean, it was on there. It wasn't as if it was totally left off. I mean, they both said that they would address in the future, so I think that's acknowledging that there should be some change to it.
Do we have clear guidelines on this? I mean, could it have been interpreted that they did everything correctly? I mean, could they have made that case just as easily as saying, we'll not let it happen again?
I think based on the way it's worded at the current time, let me take a look at it. Based on the way that the advertising is worded at the current time, it doesn't appear that this advertisement indicated that that this person wasn't engaged in the real estate business. It did have the firm name and telephone number on it at the bottom. There's something about a sign. authorization from property owner. The only issue that could maybe come up is, the possibility of advertising in a false, misleading, or deceptive manner, or with the appearance that this team name could have looked like a separate firm and could have been a little confusing.
Have that advertisement.
Look up
Are
and-
you looking at the advertisement?
I was looking at the rule just now.
Okay, so you didn't see a copy of the
Oh,
advertisement?
no, it is in the file. I thought you were asking me if what I was
How
looking at
about
was.
showing it to the commission?
It'll destroy the anonymity.
We can't, I was getting ready to ask what the name of the team was, and I
There
thought,
is-
I can't ask that question.
There is no, it does not appear to be any explicit violation of our advertising rule. It's just that it appears that they both recognized that the firm name should have been featured more prominently, and that's what respondent one had actually questioned in the beginning.
Well, see, I don't know that we can tell them that. I mean, based on what we have right now, I don't know what a letter of instruction would say, other than be clear in your advertising. But we can't say, I don't think we can say the company name has to be as large as the team name.
No, the letter of instruction is merely just to be sure that these people have a full copy of this advertising rule in front of them and know exactly what the rule as it is states now. It would not be giving them any kind of interpretation or saying, here's specifically what you did wrong. This principal broker appears, the reason for the letter is to, for one, recognize that obviously this licensee had some concerns about the way this ad was laid out, and I think that that deserves a reminder of our advertising rule. Clearly, the principal broker appears to have a clear grasp of what it should look like, just to eliminate any confusion. And I just think that in the event that we have an issue come up with this person in the future, at least they've been given the opportunity to see what our rule is as it stands now, and just a reminder of what the requirements are.
I understand your position, I just don't know how we give clear guidance.
At this point, we don't have anything better than our,
Gotcha, I'm with you.
yeah.
You licensees out there, as you've been sitting here all day, one thing I want you've heard us allude to this on a time or two, but advertising has sort of gotten away from what the statute says it's supposed to be. We're talking about these teams. There's been a rise of teams across the real estate industry all nationwide. And here in Tennessee, we have decided that these team names that are affiliated with these companies, that lots of times the team name is real big, and down here at the very bottom you have to look to find the name of the company. And that principal broker is responsible for all those licensees, and we're in the process of developing some rules that we're going to address this issue, and that these teams are not going to be able to run as rampant as they've been running across the state, because our job is to make sure the public is protected, and the people who have houses to sell or they wanting to buy houses, we want to make sure that they know who they're dealing with. That firm is who they're dealing with, and that firm has a principal broker. And those principal brokers are to be responsible for all those things that their agents are doing. And that's just one thing when you go back to your office, and that's something we're going to be addressing.
Ms. Crop, the advertising rule 1260-2-.12 has been changed since this Green Book came out, right? It's that insert that's in the back of the book. That's one reason I think it might be beneficial if somebody's going by the Green Book and don't have that insert that goes in the back of the book, at least they would have the most up-to-date advertising rule.
Excellent point. We have a motion and a second on the floor. Any other discussion or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 14 is next.
2013-013221. Complainant states that Upon a pending transfer to another state, complainant had to use an agent who was approved to do relocations, and respondent, affiliate broker, was hired. Complainant states that when negotiating the offer from the buyers would not come above $327,000 and complainant would not go below $330,000. So respondent offered to reduce respondent's commission by 1%. This situation was accepted by complainant and spouse, but when the paperwork was prepared for the sale, the reduced commission was not included in the documents. Complainant states that upon questioning how complainant was going to get the $3,000, respondent stated that respondent could do that. Respondent could not do that, and only the relocation company could do that. Complainant states that in a conversation with the relocation company, complainant was told that the relocation company would not assist, and respondent was deserving of the full commission. Many phone calls ensued between complainant and complainant's spouse with respondent, and in one conversation, respondent told complainant that complainant needed to communicate directly with the relocation company as there was nothing that respondent could do. Complainant states that upon learning that this conversation took place, respondent again agreed to a reduced commission, but respondent said that respondent could not write a check to the complainant. Complainant states that the sales price was based on this promise, and that in making that promise, respondent misled complainant and should not have made a commitment that respondent could not fulfill. Respondent states that when the buyers and complainant and spouse became deadlocked over the sale price, respondent offered to reduce respondent's commission, not realizing that complainant and spouse were not paying their own commission. Respondent states that respondent told complainant and spouse the commission reduction would be subject to relocation approval, but stated that the commission reduction would be the only possible way that respondent could assist them. Respondent states that respondent then attempted to have the commission reduced, but was told by the relocation director that this was not possible because complainant and spouse were not paying any of the closing costs or commissions, so they could not get the credit for the 1%. Further, respondent was told that respondent deserved the commission, and it was company policy and relocation policy not to reduce the commission. Respondent further states that respondent so notified complainant and apologized, but complainant's spouse repeatedly called and demanded to know how respondent would pay the $3,000. Respondent states that respondent was willing but not allowed to reduce the commission paid, and this was the only way that respondent was able to assist at all. Respondent provided emails to support this statement, including an email that complainant's spouse was informed by the employer to leave the issue alone. Respondent regrets that the situation arose, but states that respondent's hands were tied. Documents provided showed that the relocation company was the seller in the transaction. There appears to be no violation by respondent, and the recommendation is to dismiss.
Why isn't there a violation?
Well, from my understanding of the issue and the documents provided, it appeared that the ultimate seller in the transaction was the relocation company and not the complainant and the spouse directly, and the relocation company would not agree to the reduction in the commission since it was not being paid by the
But
sellers.
that's lack of knowledge on that agent and on that principal broker. If they're gonna take that listing, then they certainly should have known who they were dealing with. And I can't believe that they didn't know they were not dealing with a third party. I disagree with you.
What would the actual violation be?
And this is the
Other
first
than
one of
breaching
these that I've ever
contract.
seen, so.
Misrepresentation. If I tell you that I'm going to short my commission, you can't short your commission. You can refund the commission, but you can short the commission.
Well,
But this, they led these people to believe that they were gonna give them credit and they was gonna take less commission. Well, the principal broker should have been involved, and they should have known that they were dealing with a third party.
Well, but I guess that's where I kind of don't understand where there was any misrepresentation, is because the complainants were not the ones that the respondent was representing. The complainants were the third party here, and he couldn't give money back to them because the sellers were actually the relocation company.
That's correct. Initially,
But who signed the listing? Who gave the listing?
Well, would have had to been the relocation company
Not necessarily.
if they were the ones that,
let me check. It's just,
if they were the sellers, they would have been the one that.
In the meantime, my role as vice chair and now in charge of this meeting, is there a motion that someone would like to put on the floor while we're looking this up?
Not until we have
Well, we
this
shouldn't even be
information.
discussing it, frankly, until we have a motion.
Well, but we don't want to dismiss it yet. We
I'm
want to
not
know
telling
who
you
the
to
seller
dismiss it.
is.
You can put any motion you want to, is fine with me.
I move to dismiss.
Is there a second? Is there a second?
I'll second, so we can
Okay, so
discuss it.
there's a motion on the floor. Motion made by Commissioner Bloom, seconded by Commissioner DeCharo to accept council's recommendation.
There is an exclusive right to sell listing agreement between the complainant and the spouse and the realty company. There are subsequent documents to it regarding a listing exclusion clause which references the sale of the property to the relocation company later, possibly later on, and instructions for the listing agent for the relocation's home sale program. And it requires that the listing agent sign the listing exclusion clause and proceed along the policies of the relocation company, who was, like I said, the ultimate seller according to the
Signed the
purchase.
sales contract.
The sales contract, that was the relocation company.
Initial listing, the initial listing was with the buyer, the owners of that property. And they had an option probably anytime they wanted to convert that to the relocation company and get their money where they could go on. But the initial listing, when was the contract signed? When was the sales contract signed?
And when was it negotiated?
Yeah, that's what I'm thinking. Next question is, when did it get assigned to the relocation company? When was the sale contract?
Also, when somebody didn't get a copy of that a copy of the
They've got a
contract.
copy where.
I'm talking about, the seller said they didn't get it because they didn't agree to that cut in commission. So apparently it wasn't sent to the relocation company.
The purchase and sale contract, the offer was submitted on April 7th, 2013, and was
April 7th.
accepted by the relocation company on April 11th, 2013.
Without the commission.
That just,
They didn't agree to.
it provided for, it had no notation regarding the commission in it.
So it was left blank then.
It's not in the, if they used a state contract, there's no commission mentioned in the
Well, my point
purchase and
is, the
sales
seller
agreement.
didn't know they was gonna get gypped out of $3,000.
Well, they weren't the seller at the time of the purchase and sales agreement. The relocation company was.
Well, they didn't know, because they wouldn't assist.
The complainants didn't know.
Well, but you don't know how long they had been working.
I can tell you the
Well-
date that the original listing agreement was signed. Would that be helpful?
Yeah, tell me when it was
Okay.
signed.
The original listing agreement, the exclusive right to sell listing agreement between the individual, the complainant and the wife and spouse, and the realty company was executed on November 17th, 2012.
And then when, Julie, was the assignment to the relocation company signed?
I'm sorry, I'm looking, there's just a lot of documents here.
The commission's in the listing agreement.
Commission is in the original listing agreement.
On record.
So it was originally negotiated in their listing agreement, renegotiated?
It is not modified within the listing agreement. It still says a total of 6% commission and 3% of the selling price to the listing broker.
Where was it modified?
I don't see that it was modified.
So this is just hearsay between the two, that one said that they would and one said that they
Well, one says that she said that she would, and the respondent says that that version of the events is, she said, the only way I can help you is to reduce my commission, but it's subject to the approval of the relocation company. That's the other version of the events. And the relocation company, there are emails of this respondent contacting the relocation company saying, I would like to reduce my commission, and them saying, no, not an option. That's what I do have in writing, is that part of it, but I don't see where that was altered on this particular
All right,
listing.
now, let me come back and ask you one other question. Was the directions to the listing companies from the relocation company, did they have a copy of it?
Yes, there is a copy of this somewhere in here. I just had it. Yes, there was an addendum to the listing agreement by and between the complainant and the spouse and the company, the firm for respondent. And it says, there is an agreement that this respondent signed with that regard. Is there something in particular you want me to?
What was the date on that, Julie?
11/12/12, the same date as the listing agreement.
Day of the listing agreement.
It is 11/12. Oh, I'm sorry, 5 days prior. It's 11/12/12. The listing agreement with the complainants was 11/17. The 2 and the 7 look similar. And it says, it does say the broker expressly agrees that any commission shall be paid by MSI, and that under no circumstances shall the seller be obligated to pay the broker any commission for services relating to this agreement. Any sale of the property relating to this agreement shall be expressly conditioned upon the acceptance of a written offer by the relocation company. Any commission shall be deemed earned and payable only upon closing of title with a purchaser other than the relocation company. Commission shall be at the prevailing rate, but not to exceed 6% without the prior approval of the relocation company. And should the seller request a release of his or her obligation to the broker or to the agent of the broker, both the broker and agent agree to terminate the agreement with no further obligation or liability to any party except where a sales contract was executed prior to the termination request.
Other questions or comments? If not, the motion on the floor at this point is to accept council's recommendation and dismiss. All in favor of that motion, please vote aye.
Aye.
Those opposed, no.
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 Let the record reflect that there were 6 ayes and 2 noes.
Sorry, there's a lot to look through.
Mr. Chairman, back to you.
I had it flagged.
Back to me.
Number 15.
You only have 5 ayes.
Back to
We
Oh,
have
yeah, I'm sorry, 5 and 2. Mr. McMullen is not present for the vote.
Austin left.
Okay. He snuck out.
Okay,
All right.
you're in charge, Ms.
The
Crop.
last clump, I'm going to read all of these together because they're all relating complaints. So it's going to be quite a few numbers of complaints. And then I've consolidated all of the summaries into one to hopefully make it as clear as possible and avoid as much repetition as I can.
I don't know how you done that, but go on.
It was tough, but I'll answer any questions you have. But I'm going to read a bunch of numbers now. 2013-003911, 2013-003912, 2013-012151, 2013-012152, 2013-012153, 2013-012161, 2013-012162, 2013-012181, 2013-012182, 2013-012201, 2013-012202, 2013-012203, 2013-014041. The above listed complaints all involve transactions relating to timeshare transfers. Respondent 1 in the above listed complaints, that's in each of those, I put lines in between them to demarcate it. Respondent 1 in all of those is an affiliate broker whose license is retired. Likewise, Respondent 2 is an affiliate broker whose license is retired. Respondent 3 in complaints that have a Respondent 3 was a timeshare salesperson whose license is expired. The issue for TREC's determination is whether these individuals are engaged in unlicensed timeshare resale activity. I'll start with a brief summary of each of the complaints. 201300391. The first complainant states that she hired Respondent 1 and 2's company to handle a trade of Complainant's 2 timeshares in 2010 and 2011. Complainant states that there were problems with the transfers and Respondent should not have taken the transfer fee and agreed to transfer the timeshares if they were not able to do so. Respondent submitted a response stating that the timeshare resort for one of the properties had been giving them trouble with completing the transfer, and respondents are still currently trying to complete the resort's necessary steps to effectuate the transfer. Respondents state that complainant's second timeshare actually had money owed on it, so it could not be transferred. Respondents state that they offered complainant a return of the closing fee paid to respondents, but complainant just wants out of the timeshares. Complainant submitted an additional response stating that complainant believes that respondents have done all they can do to resolve the issues. 201301215. This complaint was originally filed with the Consumer Affairs Division in 2011, who referred the complaint to TREC in mid-2013. Complainants state that Respondent 3 contacted complainants about their timeshare, which was listed for sale in 2010, and Respondent 1 and 2's company was to handle the transfer. Complainants state that the timeshare was sold, but complainants never received their money. Respondents 1 and 2 submitted a response stating that the money had been sent to complainants for the sale of the timeshare to Respondent 3. Complainants deny this, even though Respondents 1 and 2 were told by the Attorney General's office of Respondent 3's business practice and told not to pay any amounts relating to sales involving Respondent 3. 201301216. This complaint was originally filed with the Consumer Affairs Division in 2011, who referred the complaint to TREC in mid-2013. Complainant states that complainant hired Respondent 1 and 2's company to transfer 3 timeshares out of complainant's name in 2010 because complainants were joining a travel club. Complainant states that respondents did not complete the transfers and complainant continued to be billed by the resort for maintenance fees. Respondents 1 and 2 submitted a reply stating that respondents have done everything possible to transfer complainant's timeshares, but complainant provided insufficient documentation for 2 timeshares and did not have anything showing ownership of the 3rd timeshare. Respondents 1 and 2 state that they sent a check for the closing amounts minus the title searching fees to complainant. Complainant denies receiving payment but admits that complainant has no deed for the 3rd timeshare. 201301218. This complaint was originally filed with the Consumer Affairs Division in 2011, who referred the complaint to TREC in mid-2013. Complainants state that they hired Respondent 1 and 2's company to handle a transfer a timeshare out of complainant's name in 2010 because complainant was joining a travel club. Complainants state that the transfers were not completed quickly and complainants continued to be billed by the resort for maintenance fees. Therefore, complainants wanted the transfer stopped. Respondents 1 and 2 submitted a response stating that respondents mailed a check to complainants in 2011 for the maintenance fees and provided a copy of said check, and the resort took the property back from complainants. 201301220. This complaint was originally filed with Consumer Affairs Division in 2011, who referred the complaint to TREC in mid-2013. Complainant states that complainant purchased timeshare from Respondent 3 on eBay in early 2011 and has not received a title of the property 4 months later when the complaint was originally filed. Respondents 1 and 2 submitted a response stating that the money was sent to complainant for her purchase from Respondent 3 and there were issues with the properties that Respondent 3 had sent Respondents 1 and 2 to transfer. Respondents state that they contacted the AG's office about Respondent 3's dealings and were told not to pay anything relating to Respondent 3's transactions. 201301404. This complaint was originally filed with the Consumer Affairs Division in 2011, who referred the complaint to TREC in mid-2013. Complainants state that complainants hired Respondent 1's company to handle the transfer of complainant's timeshare out of their name when complainants joined a travel club in 2010. As of the time of the complaint in 2011, complainants stated that the timeshare still had not been transferred out of their names. Respondent submitted a response stating the delay in the transfer was due to an upgrade which complainant had purchased and complainant's daughter's name was on the deed, and once these problems were ironed out, the resort had changed their transfer policy and requiring a larger transfer fee. Respondents state they were glad to return the transfer fee paid by respondents due to the difficulty encountered with the resort during the transfer process, which complainants expressed willingness to accept as a resolution. The issue for TREC's determination is whether these respondents are engaged in unlicensed timeshare resale activity. An investigation was requested regarding the above referenced complaints as well as respondents' current activity. The investigator met with respondents 1 and 2 and examined their files regarding the complaints referenced above, as well as investigated their current practices in relationship with respondent 3, who was non-responsive to all complaints. Respondent 1 and 2 stated to the investigator that respondent 3 was not connected in any way to respondent 1 and 2's business and had only handled some of respondent 3's closings in the past, but are no longer doing so as advised by the AG. The investigator uncovered that Respondent 3 was incarcerated and possibly recently released, but was unable to obtain any other information through the internet and contacting Respondent 3's family member. Respondent 1 and 2 told the investigator that they do not sell or purchase timeshares, but only handle timeshare closings, transferring timeshares from one entity to another when requested to do so. The investigator stated that she was free to look at whatever documents she wanted, and it appeared that Respondents 1 and 2 worked diligently to complete complicated transfers. It does not appear at this time, based on the information provided and obtained through investigation, that respondents are engaged in unlicensed timeshare resale activity. Therefore, the recommendation is to close as to all. I'll answer any questions if you have any.
Would you send our thanks over to Consumer Affairs for?
Yeah, I add my name to that thank you note.
I hope, was this somewhat clear? I tried to resolve the issue on the front end.
It's an amazing piece of work, and because of the quality of that work, I move we accept council's recommendation.
And I'm going to second that.
Could I ask one question?
Sure.
Does this order to dismiss also include respondent number 3?
Respondent number 3, like I said, we've not been able to locate. I can try to see if my paralegal or somebody else can track down more information. That particular licensee did not respond to anything, presumably, according to the investigator, because maybe was incarcerated, but the person has an expired license. In addition, that license has been suspended 2 times, once for lack of child support payments and once for not having errors and omissions insurance. So it's unlikely that that person will return to the arena, but we can separately investigate that. I think we should probably do that separately than these complaints, since they're relating to transactions back to 2011, but I can try to uncover more information about this person.
Okay. I don't have any interest in any more information, but I don't think we ought to dismiss that person. I think we ought to only dismiss 1 and 2.
We can either amend this motion, if you'd like to, Commissioner Bloom, or we can just withdraw your motion and we'll...
Well, it looks like number 3 is the guilty party. I don't think we ought to dismiss him.
Just leave it open as
We don't really have any information confirming that one way or another, because we only were able to speak with one side of it, and the likelihood of finding, we could maybe flag this person, we could close and flag as to this person, where if they come back, we could bring them in before you all, before, reinstating a license of some kind, but without being able to locate them or have information to necessarily prove wrongdoing, we only have one piece of the puzzle at this point.
I'd be happy with that if we could do that.
If we flag the file for respondent 3, that way if they reappear, we can try to.
So that's an amendment to my motion I'm happy to accept.
We got an amendment to the original motion as to respondent number 3. We're going to flag his file at their file, whoever they are. And
It's got to be a man. You know that.
yeah. But we'll flag that file. Any other discussion on this motion? Everybody understands it? We're dismissing, we're closing as to 1 and 2, but on 3, we're flagging their file.
Vote first on Gary's motion.
I'm happy for it to be voted on.
Yeah, it just all got rolled into one motion. And all in favor say aye.
Aye.
Opposed, no. Motion carries.
I just have one more, and it's just for discussion, 2013-008251. This was originally presented at the September 2013 meeting. It was a TREC open complaint based on an audit of respondent's principal brokerage firm in April 2013. The auditor's report indicated a shortage in the firm escrow account, which only held one earnest money deposit when comparing accountings to the most current bank statement. Based on the escrow account shortage, a complaint was opened. Respondent submitted a response admitting that the escrow account shortage due to obligations, which led complainant to utilize funds from the firm's escrow account, which respondent states respondent used due to expected income in the near future, which did not come to fruition. Respondent acknowledged in the response that respondent's action action was a clear violation, but expressed regret and stated that the account would be fully funded by June 2013, and respondent would furnish proof of same. Based on respondent's statement that the account will be fully funded by June 2013, legal counsel contacted respondent in August 2013 inquiring as to the current status of the escrow account. Respondent stated that the single deposit in the account is the same earnest money deposit referenced in the audit, as the sale is still pending. With regard to the current shortage, respondent stated that the shortage is worse now than it was at the time of the auditor visit. A current statement of the firm escrow account shows a severe shortage. Respondent admits the violation but states it was not done for personal gain, and respondent expressed regret and inability to rectify the situation. The recommendation at that time was a consent order for voluntary termination of respondent's license for failure within a reasonable time to account for or to remit any monies coming into the licensee's possession that belong to others in violation of Tennessee Code Annotated Section 6213 312B5. Failure to timely account for trust fund deposits and all other property received from any party to the transaction in violation of Tennessee Code Annotated Sections 6213 312B14 and 6213 4036, and failure to properly disperse funds from an escrow account in violation of Rule 1260 -02-.09 subsections 3 and 6. That time, the commission voted to accept the recommendation of legal counsel. After the authorized consent order was sent to respondent, legal counsel was contacted by an attorney who represents respondent, indicating that respondent would be interested in entering into a consent order, but requesting a lesser penalty than voluntary license termination if respondent provided proof that the escrow account was replenished. Respondent's attorney then provided a bank statement showing that the full amount of the only earnest deposit had been returned to the escrow account. Respondent's attorney further stated that the escrow account is now fully funded and there is no other money belonging to others which is unaccounted. In light of this new information, this matter is being represented to the commission in order to determine of whether or not, in light of the new information, the commission is willing to consider revising the terms of the consent order. New recommendation is to discuss it. I told the attorney, in light of the fact that the account had been replenished, I would bring it to you, but I couldn't guarantee anything. It would be up to you all to determine if you wanted to offer something lesser in the consent order.
It seems to me if they don't like the consent order we offered, they can appeal it and we can hear it. Correct?
Right, it can go to a formal hearing.
See, we've already gone through this once.
Not the formal
You have,
hearing.
but I
Oh,
just
we
thought
have.
we had had a formal hearing in the past where somebody had been offered some, a consent order, and they tried to correct the situation. It came forward to a hearing, and they ended up paying back the money, and, the commission was happy that I think it was violation of an order or something like that. And so I thought it would be at least worth, I was requested to bring it to you. If you're not willing to do that, I'll just go back and tell them the original terms still stand and we go forward to a hearing. But since the money was fully replenished, I thought that would be noteworthy to at least give you notice of. And if you want to just take it to a formal hearing, we can certainly do that. But I just said I would convey the information.
Rather than just dropping it, could we request that, every quarter they send us a statement of some kind?
Well, we can
Where we
even
could-
still have a civil penalty in there. They're just requesting something less, less
Less than losing their
less drastic
license.
than
losing their
voluntary
license,
termination.
but we don't have any way now of sending somebody in to look at their books.
We could
So
do something
can-
by consent order, maybe where they agree to send us bank statements once a month for the
Once a
next
month?
6 months or
Yes,
something like
that's
that.
something
And
like
then,
that, and I would feel a whole lot better with your recommendation if we added something to that.
Hold it just a minute. When did this individual get to be a broker again? In '94, if you look at history, he took a downgrade to an affiliate in 1 year of probation. 30 hours, now you want, so who's the principal broker of that firm?
When was
this person is a principal broker again. I don't know.
You see where you look at, am I looking at the right?
where it says closed
28,
company
says
downgrade
down there
to
history.
affiliate?
And
What
that
year was
94
that?
means it was in 1994, wasn't it?
I believe somewhere around that time. I don't.
Closed, is he a broker now?
He's a
Is
principal
he or
broker.
she a broker?
It's principal broker.
So they come back and reapplied, is that right, Ms. Backer?
His file doesn't indicate anything about this closed consent order, what it was for, why it was downgraded. I mean, the computer file doesn't show anything. There's no information about this. He reapplied to be a broker and was granted a broker's license. And that's, we looked to try to figure out what this particular action was taken for, and we couldn't.
The information
No.
is on there was all I was able to obtain off the system, and that was
Yes,
with the help
yeah.
of Connell, who's much more
Right.
adept at the
Got a
system.
motion.
I'd like an explanation of that, too.
There's no motion on the floor?
I'll make a motion. I make a motion.
The
that
recommendation
we-
was to discuss. I didn't even know if you would be willing to consider something.
I'll make a motion that we affirm our original decision.
Second.
We have a motion by Commissioner Bloom that we reconfirm our original decision, and second by Commissioner Alexander. Do we have any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Thank you, Ms. Crop.
What else?
Good job.
What else do you have, Ms. Crop?
Just the consent order, the consent order log for your review. That's just my tracking mechanism. At this time, all of the outstanding consent orders have been transferred over to Ms. Ryan to be put in line for formal hearing. I just provide it every month as to show you that these are being moved along, and consent orders are being sent out after 30 days. They're being transferred to her. So if there's no questions, I don't have anything else.
Okay. If I could, I have talked to Kelly back in the back, and she'll always be McDermott to me. But anyway, Steve, unless the commission has any objection, I'd like to go ahead and ask if you would, in charge of all your licensees that are here today, Mr. Education Director, your foal that's here.
Hear the legal report for their edification and knowledge. With that conclusion, I will leave this up to you to see if this satisfies the requirement of attendance of a commission meeting. Okay, well then, if those of you that are needing to sign out, please do so. If you've satisfied your obligations with the commission, make sure you do that before you leave, and pick up your certificate at the end. Have a safe trip going home. It is raining.
Yeah, we hope this has been beneficial to you, that you've learned something that you can carry back to your offices and share with them. And there's one thing, share with them. If they want 8 hours of continuing education, they can contact the office and make a reservations to come up to one of our commission meetings, get 8 hours of continuing education.
Free. Are there going to be
Free, it's free.
any commissioners' reports or anything?
Yeah, we're going to do that when they leave.
Well, no, let's do it while they're here.
Just
start
start
them.
Just go ahead and start them.
Yeah, commissioner reports. Commissioner Bloom, you have anything you'd like to add or?
I don't have anything I'd like to add, but this idea of $6 million, the possibility of using that in a way that would benefit the industry is intriguing, and I don't know, I think Commissioner Collins is onto something with some kind of a educational thrust. That would be great, and I'd also like to see if we had some expertise that we could pull in here for the possibility of having our E&O self-funded by us.
Other than the weather report.
He's showing the weather
Yeah.
report.
Do you have any?
Ugly.
Any commissioner report from you?
I'm just so happy to be here.
Mr. Collins, anything? Mr. Charo?
Well, I would just like to wish everyone a happy Thanksgiving. It's hard to think about Thanksgiving. It's only a few weeks away, but I hope everyone has a great Thanksgiving. You guys be safe driving home.
The only thing I would like to, from my report, is that when Chairman Stevenson was talking about Mr. Roach over here, is that his name? Mr. Roach, was that it? At the same time, and it almost when I noticed it, Executive Director Maxwell quickly, just like this, said 20 grams is less than an ounce, and I don't know how you know that. I know, I mean, just like that. Oh, that's my report.
Okay, now, my report is, as soon as Kelly is finished back there, Kelly,
Kelly.
I'm asking that you come forward. Okay, well, you've got 4 more to go. Yeah, we want to talk about,
Do we want to go off the record at this point? Are we done?
I mean, do we have to do, hey, Eve?
Yes.
Miss Maxwell?
Yes.
Excuse me. We just need to make a decision about lunch next
Okay.
month, and I mean, that's the reason I wanted Kelly. I mean, we can just go off the record. We can adjourn this meeting and then just
Adjourn it
discuss
and
it.
talk about it.
Yeah, we don't have to talk about that on the record,
Right.
do we? Okay. The only thing I have to say is, I'm glad y'all like me, because if you didn't like me, I'd be a hell around here.
Who said they liked it?
And commissioners, don't run off.
I know, that's what I'm saying.
Commissioners, keep your seat.
More than we do.
You don't want this job for $50 a day. Is that what you're telling us? Have a good trip.
Yeah.
Turn the machine off.
Yeah,
Turn it off.
this meeting is adjourned.
And then come up here, Kelly.